about rights without including the other gender. So I am very privileged to as well see a number of the men who are representing the other gender, because we need to do this together, just like goal number 17 of the Sustainable Development Goals looks at partnerships. So we need to partner with everyone responsible to achieve these rights that we are talking about. That's going to be the greater part of the discussions through our panels through the 3 days. And in just a few minutes, we should be having our leaders coming in through as well, and we'll be starting off immediately after that. Thank you and good morning. My name is Mildred Tohaise, and of course, I'll be taking on this noble duty with Commissioner Frank Baine, Senior Commissioner Frank Baine. We didn't throw the party though for the elevation. But anyway, we'll be starting in less than 5 minutes from now. Thank you. God bless you.
Dear delegates, good morning. I'm called Frank Baine, Senior Commissioner for Prisons. Glad to be here. As we deliberate about our mothers and sisters that are on the other side of the law, first and foremost, I'm gladly inviting you and welcoming you to Uganda, more especially those who could be here the first time. You are welcome to Uganda. Feel Uganda and enjoy Uganda. The beginning, as our leaders come in, we shall have two most important things: the anthems, both Uganda and East African, and thereafter a prayer, and we shall have the protocols and the other details as we shall be taking you through with my co-director of ceremonies, Madam Mildred Tracy. So in a minute, we should expect our leaders and band be on standby so that we begin as soon as they practically are here. Thank you. peace blankets, may we raise for the anthems. Let's keep standing for a word of prayer. Miss Lucy. Nadira.
Let's humble ourselves for a word of prayer. God in heaven, we thank you for this day. We thank you for bringing us here safely. We thank you, O Lord, for the organizers of this gathering. Lord, we ask for preservation and protection even as we stay in this place. We ask, O Lord, that you take charge of every proceeding as we do that which is dear to your heart, and that is justice. We thank you. In God's name I pray.
Ladies and gentlemen, we may get seated. Thank you so much once again for honoring our invitation and coming through for a very important discussion. And as clearly our theme states, unlocking the barriers, the rights of women in the criminal justice system. When we look at Agenda 2063 of Africa, which is looking at not only making Africa a global powerhouse quantitatively, but also qualitatively, we are paying attention to Aspiration 6, which is looking at development of, which is people-driven, especially relying on the potential that is offered by its women and youth. And for Uganda's case, of course, if we paid attention to the demographics of our population, almost more than half, slightly more than half of Uganda's population are women. So this is not a far-fetched discussion that we are having. But it clearly also loops in the Sustainable Development Goals. And if we look at specifically goal number 5, that looks at gender equality. And it also, there is no achievement of development that could go with leaving women and the youth behind. When we talk about the demography of the youth, the statistics also speak clearly, talking about more than 75% of Uganda's population being the youth. And as the saying goes, the youth are the future of tomorrow. But these days we get to say that the youth are the future of today and now. So if the future is ahead, we get to think about it as being now. But also the Sustainable Development Goal number 1, which talks about no poverty. If you talk about goal number 10, that looks at reduced inequalities, all that loop in one. But I never get to forget that partnerships are key, just like goal number 17 is. And that is why we have a multiplicity of sectors here that are working to attain the same goal this very beautiful morning. We will be, for the next 3 days, discussing the different gender-sensitive approaches in the criminal justice system, therein recognizing a growing recognition on not only local or national, but also international and regional levels, that women who are incarcerated are a particularly vulnerable group with specific needs that ought to be addressed, and at all levels, from the entry into the criminal justice system all through to the time that they get to exit. And that is why we are seated here not only today, but we'll be taking off 3 days of the week to have this firm conversation, and thereafter we'll get into the implementation. Some of these approaches have already been implemented, but probably we need to make them much better. It's not a day for me to speak. There's so many other distinguished speakers, but I would like to observe the protocol. We have the representative of the Chief Justice, and that is Justice Wolayo, who is the president of IAWJ Uganda chapter, the Commissioner General of Prisons, the Director of Public Prosecutions, the United Nations Resident Coordinator, the head of office at UNODC, and the representative of the Dutch ambassador. We have the executive director of the Penal Reform International. That is the reason why we are here as well. We have the Deputy Commissioner General of Prisons from Kenya. We have the Justice Roslyn Apili, who is also here in our midst, and the representative of the Uganda Human Rights Commission, because all the discussions that we are having this morning are encompassed around one thing, and that is the aspect of human rights. Distinguished ladies and gentlemen, invited participants, and because of COVID-19 that exposed us to the future that we thought was far ahead and brought it closer, we are not only here physically, but we also have online participants. And ladies and gentlemen, allow me invite the online audience. My mates, the journalists, will kill me if I do not recognize them. Journalists, ladies and gentlemen, thank you so much for coming through. My name is Mildred Tuhaise, and I'll be taking on this noble position, as earlier said, with Senior Commissioner of Prisons, Frank Baine. Without wasting any more time, ladies and gentlemen, allow me invite the Penal Reform International representative to welcome us and let us in on what our expectations should be for today and the rest of the 2 days that we will be housed at this place. Ladies and gentlemen, let's welcome the Penal Reform International.
Thank you very much, Madam Chair. Allow me, distinguished guests, to adopt the protocol observed. We are here today because of the progress that Uganda and the rest of Africa has made towards gender equality. We know that today Africa ranks 6th highest among the 8 regions, closing the gender gap to an average of 70%. And under aspiration 6 of the African agenda, Africa's development is driven
especially relying on the potential offered by the women and youth. This means that women and girls, men and boys, should be treated in an equal and equitable manner. Distinguished guests, this means that we need to use, as actors in the justice sector, an equitable approach to gender equality to ensure that no one is left behind. In relation to the women in the criminal justice system, this means that all actors should understand and consider the specific backgrounds, challenges, and impact of imprisonment on the women, and whether directly or indirectly compared to the men. Addressing gender inequalities, therefore, ought to be reflected in the criminal justice sector in order for there to be a balanced level of development. We know that although efforts have been made to close the gender gap in East Africa, women have often been ignored, and yet they are a key population within the region. Women in prison in Africa, currently the women prison population has increased by over 55% compared to less than 25% of men. And according to our research, we know that female prison population has increased by over 75% in the last 6 years in Uganda and over 100% in Kenya. Therefore, distinguished guests, we feel that there is need for deliberate efforts to be made aimed at integrating gender-sensitive approaches in the criminal justice system, including during arrests, pre-trial detention, trial, imprisonment, and during the resocialization process. This conference is therefore an opportunity for all of us working in the justice sector to discuss workable and lasting solutions to ensure gender mainstreaming in the criminal justice sector. Distinguished delegates, it's therefore with great pleasure that Penal Reform International, the United Nations Office on Drugs and Crime, the Uganda Prison Service, Uganda Human Rights Commission, and the Uganda Police Force warmly welcome you to this 3-day event. We hope the conference will lead to workable and meaningful interventions to support gender mainstreaming in the criminal justice sector. I thank you all.
Thank you very much, PRI. Probably right now one would be asking why the percentage increases, what could be the factors leading to that. Those are partly the discussions that we'll be having today. And given the fact that we realize the numbers going up, we will also be discussing what those gender-sensitive approaches could be. Do we have some that are already existent? Do we have some that we need to implement better? Or do we need to introduce new approaches to gender sensitivity in the criminal justice system? That will be a conversation for a later time. Allow me invite the representative of the ambassador of Netherlands in Uganda, Ode de Jonge, the first Secretary of Security and Rule of Law, Netherlands Embassy, Kampala. Welcome, please. Let's give him a round of applause.
Distinguished guests, ladies and gentlemen, please allow me to adopt the protocol as observed by the previous speaker. Good morning. My name is Ode de Jonge. I am the first Secretary for Rule of Law at the Netherlands Embassy. I'm representing Dr. Karin Bove, Ambassador of the Embassy of the Kingdom of the Netherlands, who is currently out of the country. We as the Netherlands are delighted to be with you today at the regional conference on unlocking barriers, rights of women in the criminal justice system in Africa. We appreciate the partnership between the Embassy of the Kingdom of the Netherlands, the United Nations, and the government of Uganda over the years. We congratulate Penal Reform International United Nations Office on Drugs and Crime in Uganda, the Ugandan Prison Services, and the Uganda Human Rights Commission on this very important conference on the rights of justice-affected women. Recent trends indicate that a growing number of women are now relating to criminal justice systems more as suspects and prisoners than victims of crime. Globally, the number of women in prison has been rapidly increasing compared to men, which places women prisoners at high risk of vulnerability. This is because in the past, prisons were uniquely designed for men, including the architectural design, safety measures, and healthcare provisions, amongst other services, which is disadvantageous to women. Addressing gender inequalities ought to be reflected in all sectors of the country for there to be a balanced level of development. This calls for deliberate efforts aimed at integrating gender-sensitive approaches in the criminal justice system, including during arrest, pre-trial detention, trial, and imprisonment. Vulnerable groups, including women, have limited resources for legal representation, either as a suspect or convicted persons when arrested, detained, or imprisoned. Whereas access to legal aid is essential to guaranteeing equal access to justice for all, it is also an important safeguard that ensures fundamental fairness and public trust in the criminal justice process. There is a lack of affordable, effective, and scalable legal aid services, which mainly affects vulnerable groups in contact with the law, including women. This highlights the growing need, nationally and globally, for laws, policies, and practices of the criminal justice sector that take into account the needs of women offenders. Allow me to share the Dutch perspective on promoting access to justice for women in the criminal justice system. We endeavor to approach this challenge with a lens of compassion and understanding. Our best results revolving around recognizing that punitive measures alone do not serve the interest of justice. We have tailored programs that address the unique needs of women in conflict with the law, providing not only legal resources, but also comprehensive support, including vocational training and psychological well-being initiatives. As Nelson Mandela once said, "It is said that no one truly knows a nation until one has been inside its jails. A nation should not be judged by how it treats its highest citizens, but its lowest ones." In embracing this wisdom, we strive to create a justice system that uplifts those at their lowest, ensuring that our approach is not just punitive, but transformative. With the number of women in prison rapidly increasing in Uganda, it is imperative, now more than ever, for criminal justice systems across the region to put in place laws, policies, and practices that promote gender-sensitive, non-custodial alternatives to imprisonment, gender-sensitive sentencing, and gender-sensitive rehabilitation and reintegration services, deliver quality healthcare services for women in prison, prevent and address violence against women in detention and after release, work with women facing the death penalty and safeguard the rights of their children, prevent and respond to violence against women where sexual abuse and domestic violence play a role in women's offending, and seek to reduce the risk of crimes occurring and their potential harmful effects on individual society. The Embassy of the Netherlands is pleased to support this regional conference, which is aimed at contributing to the development of informed policies and more gender-responsive criminal justice systems across the African continent. In December 2022, UNODC in Uganda, in partnership with the government of Uganda and key civil society organizations launched a 5-year program on strengthening crime prevention and criminal justice in Uganda. The Embassy of the Netherlands is pleased to be a key donor of this important national program, which aims at enhancing equitable access to justice and strengthening responses to counter-organized crime in Uganda. This program builds on and strengthens the long-term and multifaceted partnership of the Embassy of the Netherlands with the government of Uganda in the field of promoting the rule of law and delivering justice. This program will take advantage of the work that has already been initiated, supporting some of the key needs identified by key justice actors and continuing to work closely with the Embassy's key partners in the Uganda criminal justice system. The Netherlands is confident that the program will improve cooperation and coordination between law enforcement and prosecution services, the judiciary, CSOs, and other relevant actors that will contribute to a more gender-responsive criminal justice system in Uganda, while also improving access to justice, particularly for the vulnerable, including women, persons with disability, and children. Distinguished guests, ladies and gentlemen, today is also a significant day, marking the 21st World Day Against the Death Penalty. The Netherlands staunchly advocates for the abolition of this ultimate form of punishment. As Albert Camus said, capital punishment is the most premeditated of murders. On this day, let us collectively reevaluate the human cost of such practices and unite in our commitment to promoting alternative forms of justice that respect the inherent dignity of every individual. And I would be remiss not to commend Uganda's decade-long commitment to refrain from executions in a world where such restraint is increasingly rare. Your dedication to preserving the sanctity of life is not only commendable, but also serves as a beacon of hope for human rights advocates globally. The Netherlands appreciates the government of Uganda for its ongoing constructive cooperation, and the Embassy of the Netherlands looks forward to expanding this cooperation. I thank you all for listening, and I wish you a fruitful conference. Thank you.
Distinguished delegates, like Ebre highlighted, women's rights have long been a global concern. And in the context of the criminal justice system, it becomes even more critical to examine the rights and challenges faced by women in details. With that remark, I wish to invite Ms. Susan Ngonge Namondo, Resident Coordinator, United Nations, Uganda, to come and add a voice on today.
Good morning. Let me start by recognizing the representative of the Chief Justice, the Commissioner General of Prisons, the Director of Public Prosecutions, the representative of the Embassy of the Netherlands, and let me, beyond that, stand on all the other established protocols. On behalf of the UN family in Uganda, I'm honored to join you today at this regional conference on the rights of justice-affected women under the theme, Unlocking Barriers, Rights of Women in the Criminal Justice System in Africa. Allow me to start also by congratulating Penal Reform International, our United Nations Office on Drugs and Crime in Uganda, Uganda Prison Service, and the Ugandan Human Rights Commission for this timely conference that would unlock and contribute to further development of informed policies and a more gender-responsive criminal justice system in Uganda and across on the African continent. Our gathering here today is a testament of our shared commitment to advancing the rights and well-being of women who have encountered the justice system, particularly those who are confined in our correctional facilities. In our increasingly interconnected world, our understanding that safeguarding the rights and dignity of women, even those who are in detention, is not merely a good thing to do, but it is also something that is crucial in terms of advancing our broader development goals. As we embark on this regional conference, it is important to recognize the profound connection between the rights of justice-affected women and the achievement of our broader goals, as earlier mentioned. I think first and foremost, as the previous speaker mentioned, is access to justice. At the heart of our deliberations lies the indispensable right to access to justice. Women prisoners often face unique challenges, as has been mentioned, in seeking justice and redress to their grievances. Addressing these grievances is not only an imperative for human rights, but it's also a cornerstone of a just and equitable society. Gender equality has also been mentioned. But third, I think rehabilitation and reintegration. Many women prisoners will eventually return to their communities by upholding their rights, providing access to successful reintegration services such as education and vocational training, would make sure that they're better able to go back to their communities and continue to be law-abiding citizens who can meaningfully contribute to our broader economic and social development. Also, the issue of family and community well-being. Women in prison often have families who depend on them. Supporting their rights not only serves the women themselves, but also safeguards the well-being of their families and communities. It is a testament to our commitment to social development more broadly that we do more in this area. And of course, sustainable peace. Sustainable development is inseparable from peace and security. By addressing the specific needs and rights of women prisoners, we take significant steps towards creating an environment of justice, peace, and security where development can better thrive. And as was mentioned, I think, by Mildred when she started, collaboration and partnerships. I think this conference, which brings together a broad variety of stakeholders from government, civil society organizations, academia, international agencies coming together, further strengthens our commitment to work together in terms of developing these practices, these policies, etc., that allow us to address, to really address the issues of for a gender-responsive criminal justice system. I guess really my main message is, we know that the work that this sector does is truly crucial. And for me, I was glad to hear that we have many different sectors represented in the room. For me, it's how the work of this sector, working with the others, really contributes to the broader development goals that we all aspire to. And why is it so important now? It's because we're struggling on the broader development goals. By the way, we're only 12% on track on SDGs. I didn't check the specific percentage on track we are for those that are relevant for the justice sector. I will go back home now and look at them. Nationally, we are struggling. The National Development Plan at the midterm review indicated that we're only at 17% implementation of that. The situation is broadly similar across countries of the continent. So we are really struggling in terms of our development agenda. And the work of this sector is an important part in terms of us reaching those broader objectives. And I hope that as we deliberate on these important issues here, we will find better ways to build synergies with other sectors so that we can more faster, more qualitatively reach that broader development agenda. That's my main message for this group today. And I look forward to us progressing in that way. I think before I end, I also have to congratulate the government of Uganda in terms of the progress it has made in terms of rule of law, access to justice, the training that has carried out in terms of personnel across the system. It is commendable, the progress that has been made. We recognize it and we applaud you for it. As I conclude, I would also like to thank the Embassy of the Government of the Netherlands for the financial support towards the Government of Uganda's efforts in this area. We look forward to the continued partnership. And more broadly, I also appreciate the Government of Uganda for the continued collaboration and partnership with the United Nations in strengthening crime prevention and criminal justice in Uganda. I think together we all look forward to doing the work that would allow us to progress towards that country and that continent that we all want to live in. Thank you very much.
Once again, let's put our hands together for the resident, Uganda resident representative. Dear delegates, over time, the focus of Uganda Prison Service evolved from being primarily a punitive system to incorporating a correctional and rehabilitation aspects. With us here is the Commissioner General of Prisons to come and share the beginning of the highlights of this discussion that we are going to have for 3 days. You're welcome, sir.
My Lord, Justice Henrietta Olayo, who is representing the Chief Justice, and I'm informed you are the President of the International Association of Women Judges, Ugandan chapter. My Lord, the DPP, Justice Jane Francis Abodo, the UN Resident Coordinator, Your Excellency Susan Ngonji Namondo. I've been trying to download in my head where we last met, and I remembered that we last met in the condemned section at Ruzira. I hope that is correct, and that you are from Cameroon. Thank you very much for coming. The head of the UNODC office in Uganda, Madam Sharon Leza Nyambe, I'm going through this protocol because I'm the one who invited you. So you will bear with me to take a little bit longer to recognize your presence here. The Executive Director of the Penal Reform International, Madame Olivia Rope, and also your colleague, who stays in Amsterdam, the representatives of the Uganda Human Rights Commission, Honorable Semyon Subuga and your colleague Shifura Rukwago, the Deputy Commissioner General of the Kenya Prison Service, Madam Florence Kerubo, you are welcome. The chairperson of the Law Reform Commission, Dr. Pamela Tibihichira Kariejira, you are welcome. The colonel from the UPDF, I hope that is the correct rank. You are welcome. Our colleagues from the Uganda Police Force, at least I saw Kamia here. I saw the director of is that the Chief Political Commissioner? Madam Namtevi, you are welcome, Senior Commissioner of Police. Our officers from the Uganda Prison Service, and all those whom I have not mentioned by name, ladies and gentlemen, and the prisoners band, you are welcome to this event that tries to look at the challenges women face in the criminal justice system. You will allow me to express my appreciation to all the guests that have spared time to honor our invitation to be part of this important initiative. Your presence here today underscores our shared commitment to the principles of justice, human rights, and gender equality. Mine will be mainly a situational report as far as the Uganda Prison Service is concerned, and I will start with the staff. I have a total of 14,385 staff of the Uganda Prison Service, and 30% of these are women. This is a total of 4,287. I have 5 ladies in the senior management of the Uganda Prison Service at the rank of Commissioner of Prisons. I have 6 assistant commissioners. Out of the 266 prison units in the Uganda Prison Service, I have 63 women as officers in charge. I have women officers manning male prison. We don't have the other way around as yet. I don't know why. I don't have any male running a female prison. Probably during our discussions, you will find out why. Director Eri Muhumuza, who is in charge of research, planning, and policy development, should be able to tell us, why do we have women officers manning male prisons, and we don't have the other way around? We don't have men officers manning female prisons. And I have 3 female officers as regional prisons commanders. That is as far as the staff of the Uganda Prison Service is concerned. Now to the inmates. As of yesterday, we had a total of 75,971 total inmates in the Uganda Prison Service. And 3,585 of them are female inmates. Over the last 10-year period, the female prison population has grown from 1,591, that is in 2013, 1,591, to current 3,585. If you do simple arithmetic, that is, I think, 125% increase. 125%. I had the master of ceremony. Do they say master of ceremony or miss of ceremony? You are talking of 50% increase from the last 5 years. But over the 10-year period, this is 125% increase. This is a very serious matter. I think partly the reason why we are congregated here to try and see how to handle this situation and mitigate the effects of having these ladies behind bars. Of the 3,585 women in our custody, 39% of them, or approximately 1,402, are charged of murder. 1,402 out of the 3,825 are charged of murder. 15% of them, that is around 550, are charged of housebreaking, burglary, and theft. I didn't know ladies also do housebreaking. Of course, you have trafficking in children, you have doing grievous harm, assault, that is common. 122 of them on aggravated robbery. Really? Ladies? And we also have ladies as civil debtors in custody. I've seen the chairperson of the Law Reform Commission here. I do not see why we should still have civil debtors in custody. I don't know why. That's a punishment. These ladies we have in custody, 2 of them are condemned. We have only 2 condemned inmates. About 10 are on life. And as the representative of Her Excellency, the Ambassador of the Netherlands said, we have continued to observe a moratorium on executions. The last execution in Uganda was carried out in 1999. This is about 24 years ago. We in the prison service hope it will remain so. But we also have a community that is very retributive, as you know. The cause for this mob justices that frequently occur, and we have also some concerns from our political leaders who believe in a tit for tat. But we hope we shall maintain this moratorium. Incarcerated with the ladies are 268 children. In other words, we have approximately 268 ladies who are with their children in prison. I'm saying approximately because probably some could even be having twins among these, the 268 children. This presents one of the biggest challenges we face as an incarcerating agency, to have ladies with their children in prison. We have a policy. It is not discriminative, it is just circumstantial that all the ladies we have in prison are entitled to have beds. We might not be meeting it, but that's our policy. All ladies incarcerated in the Uganda Prison Service must have beds. The men don't have access to beds because of the numbers. It would be practically impossible, but the prisons which we built specifically for females, I think about 6 or 7 of them, about 20 years ago, were designed for that you must have beds for ladies. We have had an establishment of HIFA projects in the female prisons to ensure that there is milk available for the lactating mothers and their children. We have struggled to provide adequate logistical and sanitary requirements for the well-being of female prisoners. And because of our biggest challenge in Uganda prisons, which is congestion, currently at 360%, we have morbidity prevailing among our ladies, especially as far as tuberculosis and hepatitis B is concerned. And unfortunately, the recent Sero survey on HIV/AIDS puts the women in prison at a prevalence rate of 23%. 23% HIV/AIDS prevalence, as compared to the males, to the male inmates at 13%. we are still assuming that this difference is just because of the vulnerability where these ladies are coming from. We are yet to confirm if there is intra-prisons transmission to account. But even then, it wouldn't account for this difference. Therefore, this conference is timely for Uganda Prison Service. The reason why I salute the UNODC and the Penal Reform International, it is our hope through experience sharing and new gender-sensitive approaches in handling critical challenges facing the administration and management of prison systems, including access to justice, violent extremism, radicalization, that at the end of the day we shall come up with suggestions, shall come up with solutions to some of these outstanding challenges to the women in criminal justice. Once again, let me express my gratitude to UNODC and PRI for joining us to call this conference. I forgot to recognize the Honorable Lady Justice from our neighbors, Kenya. Madam Justice, you are welcome. I had already chatted with you and told you that you have a very serious and very tough Chief Justice, Lady Chief Justice, whom I happened to meet at the Crime Commission in Vienna recently, last May, and what a lady she is. You are welcome, Madam Lady Justice. Ladies and gentlemen, thank you for coming to be with us. Unfortunately, if any of you happens to be our client, I will not be kind that you attended this conference, but we shall handle you humanely and professionally. Thank you very much for listening to me.
Another bigger round of applause to Dr. Johnson Byabasaija, the Commissioner General of Prisons. That disclaimer right there, where's the bigger one? But I love that he entangled it with professionalism on the way you would be handled. But like you said, this is a very timely conversation. Those statistics right there are a little heartbreaking. But like we said, the reason why we're here is to be able to find out some of the reasons that have been asked, some of the reasons that we could be able to explain the statistics that have been given right here. But I think Dr. Byabasaija, on why we have women manning the male prisons and not the other way around, I think I'll bounce it back to you and the maybe the HR department of the Uganda Prisons Service to be able to explain that. But ladies and gentlemen, we continue with this conversation by listening through from the representative of the Inspector General of Police, and the Inspector General of Police is represented by Senior Commissioner of Police, Hadija Namtevi. Let's give her a round of applause. I love that the IGP chose a lady to represent him to come and have this discussion. Welcome, Senior Commissioner.
Thank you very much. The representative of the chief guest, the representative of Chief Justice, my lord, the DPP, the UN Resident Coordinator, the Commissioner General of Prisons. Allow me to read on the protocol which has been presented before to save time. I'm Senior Commissioner of Police Hadija Namtebi, the Acting Chief Political Commissar of the Uganda Police Force, standing in for the Inspector General of Police. I bring apologies to you all from the Inspector General of Police who could not make it, but he's with us in spirit. As the Uganda Police Force, we welcome all efforts that have been put across to improve access to justice by women. There has been a challenge as earlier legislative, administrative, and physical structures in place ignored or never put across concerns of women accessing justice. I don't know whether it was an overrating that women are pure, cannot come into conflict with the law, or it was just ignoring concerns of women. But the case, whichever case it may be, issues of women in area structures were ignored, and it has impacted continuously up to the present. As you are aware, that the police is the entry point to access to justice. But we imagine that so many stations earlier never had detention facilities for women, and that really hampered the way women would access justice in case they came into conflict with the law. We have had obstacles such as delayed investigations, inadequate physical infrastructure, as earlier I have discussed, even absence of women to respond to issues of women, because at the entry we have had very few women joining the police force, and therefore sometimes when women are in conflict with the law, you find it difficult, especially when a case is very sensitive, to be responded to by women. However, the status quo has changed as of now, and it continues to change for the best. As a police force, there are steps that have been put in place to address these obstacles. All our new stations, the structural plans do provide for women facilities, and with facilities inside to cater for women in custody. We have developed a robust policy framework. We have the Gender Policy 2019, the Gender Strategy, and the Gender Action Plan, all to address the issues of gender within the UPF. We also developed human rights policy, and we have also integrated human rights and gender studies in all our training programs. We have created departments such as Women Affairs, the Department of Child and Family Protection, the Department of Sexual Gender-Based Violence and Trafficking in Persons under CID. All these are to cater for the structural gaps and to put more emphasis on how best we can provide or prepare women for accessing the justice in Uganda. At the entry point, we emphasize recruitment of a minimum of 30% of women at every recruitment program. And this is all to cover the gaps we have in the structure of the police. We have worked with very many partners in the area of justice. We appreciate UNODC, who have been our partners to support Interpol, Forensics, CID, and Narcotics Department. We also appreciate Penal Reform International for supporting us in training our personnel on treatment of female offenders. They have also supported us on trainers of trainers program to build our internal capacity of our police personnel, and also have supported us in developing training manuals so that we continuously build the capacity of our personnel. We have other partners. We appreciate the Netherlands Embassy. We appreciate the International Development Law Organization. We appreciate the UN through the UN different agencies, UNFPA, UN Women, UNDP, UNOHCR, for all the efforts you have given to us in terms of infrastructure, in terms of training, in terms of strengthening the capacity of police to ensure that we do provide the best services, especially for women to access justice. We have been working with the JAILOS, and we have been working with Uganda Prison Service, especially joint trainings, and the Office of DPP, who usually now provide us with guided prosecution-led investigations. We shall continue with these partnerships, and we call upon so many other partners who can come and work with us to strengthen our capacity or synergize efforts to ensure that women access justice. We hope that this conference provides us with a space that we are going to share experiences and borrow riff from other jurisdictions on the best practices on how to handle challenges of women to accessing justice. We reiterate our commitment to improving women access to justice while delivering policing services. We thank you all for participating. We thank you, the conveners of this conference, and we hope that this conference achieves its objectives. Greetings from the Uganda Police Force once again. We protect and serve for God and my country. Thank you very much for listening to me.
Once again, a bigger round of applause to Senior Commissioner of Police, Hadija Namtebian, for ably representing the Inspector General of Police. As the conversation is so that we are paying attention to looking at deliberate efforts that are aimed at integrating these gender-sensitive approaches that we are still probably thinking through our minds, some already being implemented, others needing to be made better, but looking at those approaches in the entire criminal justice system. And here we're looking at all the way from the time of arrest, going on to the pre-trial, going to detention, to the trial itself and imprisonment, looking at the entire chain of the criminal justice system. And ladies and gentlemen, to loop into the discussion with regard to the human rights, because whereas we could be, some of us could be in the line, and I'm saying some, quote unquote, could be in the line of being clients of Dr. Johnson Biabashaija, we do not forget that we are dealing with human beings who have rights and rights that need to be protected. Ladies and gentlemen, without any further ado, allow me invite Honorable Simeo Mwanga Nsubuga, who is the Commissioner of the Uganda Human Rights Commission. A round of applause for Honorable Simeo Nsubuga. Welcome, Honorable.
the representative of the Chief Justice of the Republic of Uganda, Lady Justice Harriet Oloyo, the Director of Public Prosecution of the Republic of Uganda, Lady Justice Jane Francis Abodo, the Commissioner General of Uganda Prison Service, Canon Dr. Johnson Byabasaija, the representative of the Inspector General of Police, Senior Commissioner Adija Namutebi, Your Excellencies, the ambassadors present, the UN Resident Coordinator, Uganda, representatives from the ministries, departments, and agencies, representatives from the civil society organizations, the academia, dear distinguished delegates, ladies and gentlemen, good morning to you all. I'm honored to speak to you this morning on this patent topic, unlocking the barriers, rights of women in the criminal justice system in Africa. The 2010 Bangkok rules on women prisoners and non-custodian measures for women offenders is a set of United Nations rules and principles aimed at addressing the specific needs and circumstances of women in conflict with the law. These rules guide governments and criminal justice authorities on how to treat women offenders in a gender-sensitive and human rights-oriented manner. The rules emphasize the importance of non-custodian sentences and alternative imprisonment, such as fines and community service. Particularly the women who are pregnant or who have dependent children. Then when incarceration is necessary, it should be done in the humane way, so that specific to the needs of women. The rules also emphasizes the maintenance of family ties for women offenders. Hence, they should not be separated from their children unless it is in their best interest. They should have access to sexual and reproductive health services. Officials trained to be sensitive to gender-specific needs and experiences of women in the criminal justice system. Reintegration through skilling. Furthermore, for the Uganda Police, for example, the Child and Family Protection Unit, which plays a crucial role in upholding and protecting women's rights by providing a safe and supportive environment for women and children facing various challenges. This unit is committed in ensuring that women and their families are treated with respect and dignity, and that their rights are upheld, fostering more inclusive and equitable society. For the police training school, it has taken a significant step towards protecting gender and equality, human rights, by incorporating a dedicated course on women's rights. This course equips future law enforcement officials with knowledge and skills necessary to effectively address and protect the rights of women in their communities, fostering a more and a just, inclusive society. Government interventions, challenges, and the way forward. In a bid to monitor the government's compliance with the Bangkok rules, the Uganda Human Rights Commission monitors places of detention across the country and has observed that there is fewer women detention. There is fewer women in detention compared to men, although this number has increased, especially in the past decade. Women have gender-specific needs that differ from those of men, such as maternal needs and menstrual needs. Women are usually vulnerable as they suffer the bulk of poverty, discrimination, and sexual and gender violence. They are the caregivers of their homes, whose children suffer gravely when they are detained or imprisoned. Therefore, advocating for these rights does not in any way minimize the rights of men, but rather a bid to meet specific needs that are unique for women. In Uganda, the police and prison services are putting in place measures to protect the specific needs of women. For example, Uganda Police Force has established police cells for women. They mediate matters involving women offenders and have also trained the staff on gender-specific needs of women. The Uganda Prison Service have separate cells for women, that is both the remandees and convicts. They have supplemented the meals for the expectant mothers, as the Commissioner General has earlier mentioned here, and those that give birth while in prison. They have provided sanitary towels and shop for the women across the country, and they skill women in tailoring and farming in a bid to prepare them for integration into the society after serving their sentences. Despite these developments, dear participants, the Uganda Police is still struggling with the accommodation of women suspects due to the limited number of cells, particularly in rural areas. And Uganda Prison Service suffers limited funding to adequately provide for mothers imprisoned with their children. And upon the children reaching 18 months, they are unable to relocate them to other relatives as required by law due to the lack of support by relatives of women in conflicts with the law. Dear distinguished participants, therefore, the Uganda Human Rights Commission calls upon the government of Uganda to continue implementing the Bangkok rules and also to fully fund the Uganda Police Force and Uganda Prison Service adequately, provide for the rights of women in conflicts with the law. That marks the end of my presentation. Thanks a lot for listening to me, and I wish you a blessed day and fruitful deliberations. Thank you.
Thank you very much, Honorable Simeo Subuga, for those remarks. And as he clearly did highlight, we are not emphasizing the rights of women because we seek to minimize the men, or we are not paying attention to the rights of the men as well on the other side, but we're looking at the unique specific needs of the women and how we can be able to deal with and address those particular needs. So I think that should be very, very clear for even our audience that is coming to us through the online platforms. Ladies and gentlemen, representing the Chief Justice of the Republic of Uganda, allow me invite the President of the International Association of Women Judges, Africa chapter, but immediate former President of the International Association of Women Judges, Uganda chapter, and that is Justice Henrietta Wolayo. Let's welcome her with some warmth.
Good morning, Commissioner General, my sister judges in the room, distinguished participants, delegates, all protocol observed. I want to welcome you all to this very important conference on whose theme is Unlocking Barriers, Rights of Women in the Criminal Justice System in Africa. This conference comes on the heels of a similar conference of the Africa region, Women Judges, on breaking barriers to gender justice and strengthening institutions. So it's important for us to build, it's a good thing for us to build synergies so that we can address and actually eliminate, because that's what we are supposed to do. We're supposed to strive to eliminate violence against women. According to the Global Gender Gap of 2023, Sub-Saharan Africa ranks, Sub-Saharan Africa ranks 6th highest among 8 regions, closing the gender gap to an average of 70%. The vision of Africa expressed in Agenda 2063 is one of an Africa whose development is people-driven, especially relying on the potential offered by its women and youth. The United Nations approach of leaving no one behind puts the imperative on member states to combat inequalities and discrimination. Addressing gender inequalities ought to be reflected in all sectors of the country in order for there to be a balanced level of development, and this calls for deliberate efforts aimed at integrating gender-sensitive approaches in the criminal justice system. So in this regard, the conference will canvass topics such as access to justice for women in the criminal justice system and strategies to prevent and address violence against women in detention and after detention, among other very important topics. I look forward to the deliberations of this conference, and I hope that at the end of it all, recommendations to address the gaps in the justice system will have emerged. I now have the honor to declare this conference open, and I wish you all fruitful deliberations. Thank you.
Thank you once again, Justice Henrietta Wolayo, for your kind remarks. We'll also be getting our keynote address at a later stage. That will be in the afternoon because we couldn't have the Chief Justice join us, but we'll be receiving that keynote address much later on. And as we were at it, I want to also recognize the presence of Rachel Doi Musoke, who is the Senior Technical Advisor, Access to Justice. Rachel, thank you so much for making your time to be with us. I think we've been seated for quite a long period of time, and we cannot be talking about rights and not talk about health. It is very unhealthy for us to sit for such a long period of time. So I am going to request that we all stand up and do a very simple stretch, because the next few hours as well till lunchtime is going to be time for us to be seated. So if you do not mind, kindly, we were going to stand up and just do a little bit of a stretch, get out of your seat, stretch your arms, stretch your back. I will tell you, I learned something interesting from the Director of Public Prosecutions when I visited her office, and I'm spilling a little bit of secrets. She literally has a podium in her office, so almost half of the time she works standing, realizing that it is not very important for us to sit. I ask that we stand and we stretch out a little bit, you know, your hands, your neck is very important, your back is very important as well. And we are also going to have our breakfast immediately after this. We want to have a little bit of a break, and breakfast will be served on this side. But I'm going to request that we first of all get seated again and have our group photo. I am going to request the high table definitely to be able to join in, the country representative of UNODC, to the CGP, the DPP, the UN resident coordinator. I am going to request that you as well get to join. Justice Henrietta Hadija Namtevi, Senior Commissioner of Police. I'll also request Ode. We are going to take our group photo from that banner, the huge banner that is right there where the prisons band has been. And of course, Commissioner Simeon Subuga, please, I will request that you will be able to join that picture, and Rachel Odoy as well, please. Feel free to join in that picture. The rest of us could get seated once, just a little bit. Immediately after that, we'll take our break. And then when we do return, as we get that place better organized, when we do return, our next conversation is going to be a panel that will be discussing the domestication of the regional and international standards. And Ms. Lucy Ladira, who is the advisor on criminal justice, Justice Law and Order Secretariat, will be taking on this very important conversation. So I am going to request, yes, Senior Commissioner Frank Baine is organizing the our photo booth, for lack of a better word. It is our photo booth, and immediately when he's done, I will be signaling that our high table and the individuals that I did clearly mention earlier join that group photo immediately. Once Senior Commissioner Frank Baine is done, he will be giving me a signal, and I will be inviting the high table to go to have that picture taken. But otherwise, as we continue, I think it's going to be a brainstorming conversation, because after the our panel discussion, it will be an open plenary discussion on what we think about domestication of these regional and international standards. Do they apply in the context of Uganda? Commissioner Shifra Lukwago, you will as well be able to join that group photo. Do these apply? How best can we be able to apply them in the context of Uganda, looking at the best practices that have so far been done? Of course, there's been quite a lot of benchmarking that has also taken place. That is the conversation that we're going to be having immediately after. But shortly before we go for lunch, we will also have a panel discussion on access to justice for women in the criminal justice system, and looking at experience from East Africa. We'll be having that conversation coming through shortly before we get to for lunch. We'll want to have experiences from Rwanda, and of course we will be having Ms. Joelle Kabagambe, the Deputy Executive Director, Bridges to Justice in Rwanda, We'll be having experiences from Tanzania, and Ms. Grace Duffer, the Executive Director of the Women's Legal Advisory Center, will also be on hand to give us those experiences. Of course, our very own, the Director of Public Prosecutions, will be also giving an experience of what's happening in Uganda, as well as from our neighbors in Kenya. Mr. Hannington Amol, the head of African Leadership Program, will also be giving us experiences from Kenya happening. All right, Commissioner, Senior Commissioner Baine, are we done with that preparation so I can be able to usher in the high table to you? Feel free to interact at this moment in time, because immediately after that, we're going to have breakfast. So I'm going to request that as we do have our breakfast, feel free to pick a cup of tea and a bite or coffee or whatever you deem fit, and you can be able to come back to the table with it, because we lost a bit of time earlier on in the morning. We want to be able to recover and redeem that time. So we may as well be able to have a working breakfast. All right, our venue is ready. I am going to request that we have our distinguished guests as well take to the photo booth to have that photo taken. Dr. Byabashija, we are ready with our photo booth. Ms. Susan Ngongi and the DPP, we are ready with the photo booth, please. Rachel, feel free to join in that. The chairperson of the Law Reform Commission as well, please kindly feel free to join that photo moment right there. Justice Henrietta, feel free to join in the photo moment, and we can continue with pleasantries immediately after that. And immediately after the photo moment, I would kindly request that the team that is taking that group photo will move directly and immediately to our serving points, and let us have our breakfast at this point in time. And ladies and gentlemen, after lunch, please, we will be back here to have other deeper conversations on the topic or the theme that we are having. And in the afternoon, we'll have about just 2 sessions that will be looking at the decriminalization of petty offenses. I know that we were having some questions coming in from the Commissioner General of Prisons on some of these civil cases and why we do have people right there. And we'll be looking at the gender-sensitive sentencing, the challenges and the opportunities therein. But also in the afternoon will be a conversation on management of women in pre-trial detention, and that also will be taking a face of looking at what's happening in East Africa. We'll also, before we close off today, be looking at the progress of gender mainstreaming in the criminal justice system, the lessons from Uganda and Kenya, and we'll be wrapping off the first day by looking at technology and women's rights. Well, knowing that technology is very important, gone are the days where crime was only committed in person or physically. A lot of crime now that is being committed online. And we are talking about the 4th Industrial Revolution and all that. Are we leaving any people behind? How do we get to well equip our criminal justice system with a much needed technology traits that need to be utilized in that space? So those are the conversations we'll have before we get to close off today, and we'll be having yet another fruitful day tomorrow. So I'm going to request the team, our distinguished guests who were in the group photo, to immediately, I request protocol to immediately lead our leaders to the serving point so they can be able to have their breakfast. And thereafter, the rest of us will be able to follow. So we can have our breakfast and get back to our table, so we make the breakfast session a little shorter since we lost a bit of time much earlier on. Once again, to protocol, I am requesting that we get to lead our guests to the breakfast point, which is just on my right, which should be on your left. All right. Since the VIPs are going back to an original area where they had met earlier on, I'm going to request the rest of us to kindly indulge in breakfast. Let's take it as fast as possible as we can be able to. We can pick a cup of coffee or tea and a bite and be able to get back to our tables. I am going to give this a maximum of 20 minutes. So we should be able to get back for a panel discussion at 11:45. Thank you very much, and God bless you. Bon appetit, since we're talking about food. standards that have been set and how we can be able to domesticate them. Now, in most cases, when we are talking about domestication of whether protocols or laws or standards or procedures, we get to ask about whether the environment allows for that, whether it's be it the legal environment or any other environment that could be able to allow for the domestication of such procedures. And that is what we are talking about. And we are also joined by Crispy Kaheru, who is also a commissioner on the Uganda Human Rights Commission. Commissioner Crispy, a pleasure to have you as we continue to talk about human rights, because if those are not respected, we'll be marching to your offices. We'll be marching to the Uganda Human Rights Commission. I am going to request that, ladies and gentlemen, let's get settled. Let's all get to sit back down and continue with our conversation. This one is going to be ably taken on by Ms. Lucy Ladira, who is the advisor, Criminal Justice, Justice Law and Order Secretariat, to take on the conversation on domestication. Is it possible? Is it impossible? Is it only challenging? And how can we be able to domesticate these regional and international standards with regard to the rights of women in the criminal justice system? Thank you very much, ladies and gentlemen. Let's give a round of applause to Lucy as she comes to officially take her chair and take on our next session of this conversation.
Thank you, Mildred. Good morning, distinguished ladies and gentlemen. I seek to stand on the earlier established protocol. We are pressed for time. It's now 11:51 Ugandan time. And this panel was supposed to have started at 10:30. As has been mentioned, my name is Lucy Ladira. I work at the Justice Law and Order Secretariat. The JLOS, as it's commonly known, brings together institutions that are mandated with administration of justice, law enforcement, promotion and protection of human rights, and good governance. And this morning, we will be setting the pace by talking about the standards, the norms, the guidelines that has brought us together. What have the countries and the different entities done, and how are we progressing, and what is the way forward? And this morning, we have been ably informed by the Commissioner General of Prisons that the number of women in conflict with the justice system has been increasing over the last 10 years. The statistics are not good. Are we programming for those increase in statistics? The Global Trends report that is produced by PRI and the Thailand Institute of Justice says that there are 11.5 million people in prisons worldwide. About 740,000 of those are women. Whereas the number of men is increasing, the one of women is increasing at an alarming rate of 60% since the year 2000. Now, as we set the pace, taking us through the legal, policy, and regulatory basis for what we do, the panel has been carefully chosen. Fortunately, they are all females. I don't know if this was intentional, but these are ladies that have been in the trenches. These are ladies that are carrying out advocacy work. These are ladies that are involved in research that are all geared towards improving the condition of women in prisons. Our first panelist is Sharon Lisa Nyambe, who is the head of office of the UNODC here in Uganda, and she will be taking us on the topic of achieving UN Sustainable Development Goals, the role of criminal justice institutions. Sharon is a friend to the justice sector, and as head of office of the UNODC is the custodian of United Nations standards and norms. in crime prevention and criminal justice. The UNODC has the mandate to assist member states in reforming their criminal justice systems to ensure practical application of these standards. Sharon, you're welcome to take your seat. The other panelist is Ms. Olivia Robb. She is the Executive Director of Penal Reform International at the head office. The Penal Reform is a non-governmental organization globally working to promote criminal justice systems that uphold human rights for all under the do no harm principle. Penal Reform has been in Uganda for some time and has supported us. Today she will be talking about the domestication of the Bangkok rules. She will also, I hope, be telling us about the global trend study and inform us on what penal reform is doing in order to push forward the agenda of do no harm. Ms. Olivia, you're welcome. Our third panelist is Ms. Lillian Byarugaba Adriko. She is the Executive Director of FIDA. The FIDA is the chapter of the Federation of Uganda Women Lawyers, established in 1974, providing legal services through a strategic network of offices that reach across the ambit of Uganda. They have an established track record of promoting and defending human rights with a focus on women and children. Over the last years, FIDA has been a key actor on law and policy reform on women's rights, making notable contributions to the passing of the Domestic Violence Act, the Penal Code Amendment, as well as the Succession Act and the Equal Opportunities Act. Lillian, you're welcome to take your seat. The final panelist is from UN Women. We have Agnes Kisembo, who is the program specialist at the UN Women Office in charge of intergovernmental support. The UN Women is also a friend to the justice sector. Most times people ask about the acronym and it's such a mouthful. UN Women is the United Nations entity for gender and the empowerment of women. And they've been working to ensure that all development and human rights issues have gender dimensions. She will be taking us through implementation of the CEDAW, a case for women in the criminal justice system. And I do hope, ladies, that at the end, you will share why it is necessary to adopt the specific conventions, how the UN, the FIDA, the PRI, is working to support implementation of this framework in the different areas that you are working. Has there been progress? If not, why? What are the what works and what have we tried that hasn't worked that we can do better, and any proposals for the way forward? In terms of procedure, we will try to use about 5 to 6 minutes, let's have all the panelists make their presentation, then we can have the Q&A at the end. So let's start from Sharon, and then we go in that order. Thank you. 6 minutes.
Thank you, Madam Moderator. I always believe it's always challenging to be the first, as it is to be the last. So I believe our colleagues in the middle section will possibly summarize some of the key points. I was asked to speak on the topic relating to how do criminal justice systems contribute to the attainment of the development goals. And of course, understanding the group that's in this room, I think we all appreciate that these 17 ambitious priorities that we've set for ourselves are a blueprint for peace and prosperity, for people and planet. There are 17 of them. However, underpinning these 17 is SDG 16, which is quite critical to the conversation we are having today. How do we break barriers in women accessing justice, but also in achieving and ensuring that women's rights are upheld within the criminal justice system. We live in quite troubling times. The whole sense of security and justice is being questioned. We understand from a development perspective that you can't thrive as humanity if we do not have secure and just and peaceful environments. However, I throw it back to the distinguished room. We are now being challenged on what is security and what are the threats. Traditionally, we've understood the threats to be terrorism and conflict, but we've just come out of a pandemic, which has also taught us that pandemics and other humanitarian crises are also a key threat to security. And in this context, what does it mean for criminal justice systems entirely? How are we building resilience as criminal justice actors to withstand some of these emerging dynamics in our society today? And within this context, what does it mean for women? We had very good presentations in the morning from our esteemed speakers. Women are disproportionately represented or are most vulnerable as they interact. Because it makes sense to get to the tail of the criminal justice system, to understand the demographics and the dynamics, and to walk backwards to look at what we see as some challenges in the criminal justice system. Our moderator gave us some statistics, and I just wanted to also share those globally, what we are seeing when we look at women in the criminal justice system. Already we are at over 11 million people in prisons globally. However, we appreciate that men are the majority in the prison context, representing 94%. But the women, though they represent a smaller margin of 6%, they are actually facing much graver indications within the criminal justice system. So over 700,000 women in different jurisdictions coming in conflict with the law, finding themselves in prison, but in prison settings that are tailored for men. Now, what is critical is to note two things, and I think these will be reinforced when we look at other sessions. Women prisoners, or women who are in detention, the unsentenced women, are much more than men. According to our UNODC Data Matters statistics, we have a representation of 36% of women in prison as unsentenced. And this is in comparison to the men who represent 30%. So this in itself can bring us to interrogate, what are the issues? Why do we have more women unsentenced? What are the barriers that women are facing in accessing justice? But when you further get into the prison setting itself, we've learned that over the past decade, as much as during COVID we saw a slump in the prison population, but the women population in prison is growing. And it's growing at a much faster rate than the men. And it's currently at over 35% in comparison to the men at 16%. Now we know, and this may seem to be a bias, but we know that women are not vectors of crime. If anything, women are actually victims of crime. And some of the statistics that the CGP shared with us, we understand globally that most of the women that find themselves in conflict with the law and those that commit grave offenses like murder are actually victims themselves. So where are we failing the women in the criminal justice system, where we don't identify them first as victims, and yet we incarcerate them when a crime is committed? We also note that many women are facing mental health disorders. Recently, we launched our World Drug Report, and we understood that 1 in 5 women have mental health disorders relating to drug use. However, women are less likely to access treatment for drug use disorders. And some of the crimes that women commit actually are related to some of the mental health challenges. Most of the crimes that are committed by women are driven by poverty. Women are nurturers, women are caretakers, and women have now been forced to interface with criminal networks to sustain their families. Women are also facing the challenge as active players in the criminal networks to assert themselves. So how are we building our criminal justice systems to tailor the response, either relating to alternatives to imprisonment, or actually when they are in the criminal justice system, to pick out these peculiarities? And when they end up in prisons, what kind of tailored programs are we having for these women folk? Encouraging from the point of view of UNODC that we've also been tasked to monitor the SDG 16 targets and indicators. These indicators relating to how are member states working to end violence, how are member states building secure systems that actually counter illicit trafficking of persons, smuggling of migrants. How are we working to ensure that systems are better placed for women and other actors to access justice? What are the dynamics when we look at men and women, boys and girls interfacing in the criminal justice system? I was really pleased to hear from the police and also from the Uganda Prison Service that there are deliberate efforts being made to ensure that we employ more women who will be better placed and be given capacity to interface and support the management of women that come in conflict with the law. We have a three-tiered system, distinguished guests. We have women who are actors in the criminal justice system. We have women who are victims of crime in the criminal justice system, and we have women who've committed crimes in the criminal justice system. We need to have research that gives us the tailored responses for the different dynamics. We need to understand how this research data can better inform crime prevention. Why are many women facing socioeconomic hardships that elongate their vulnerability and interface with the criminal justice system? What kind of programs do we have? And lastly, how do we build partnerships that can empower women? I'll end here, and I hope I'll be given another opportunity just to unpack the different gender-responsive interventions that can be employed in a well-functioning criminal justice system. Thank you.
Thank you, Sharon. Sorry, we are pressed for time. I hope at the Q&A you could add the other bits that you wanted to conclude. Let's hear from Penal Reform.
Thank you. I do have a PowerPoint if it's possible to put up. Just on behalf of PRI, the organisation that I lead, we are just so happy to have you all engaged in this discussion. PRI has had women in the criminal justice system really at the heart of its work for many years now, and we have really, we're really honoured to see such high level commitment in this room here today, and thanks of course to UNODC and our other partners. So in December this year, it will be 13 years since the UN Bangkok Rules were adopted in New York by the General Assembly, including representatives of your governments. We were involved in the drafting and the negotiations around these rules, and indeed we really saw them as a huge milestone in protecting the rights of women in contact with the law. So where are we now? What's the status of the implementation of the Bangkok Rules? That's what I've been asked to reflect on. And to respond to the dear moderator's question before, is it possible to implement the rules? Have they been implemented? It's a bit of a complex question, but I think there has been a lot of change. And the wins, one of the most notable gains, I think, observed by PRI is the fact that the Bangkok Rules are known about, that there is an awareness. So even if they have not been implemented in full, the 70 rules are alive in one system, which I don't believe is the case. The idea has been planted, and it's known and acknowledged that we need to adapt the system for women, that the status quo for the majority, the men in criminal justice systems, does not work for women if we really want to achieve rehabilitation and reintegration, which is, of course, the purpose of prison. We have seen a change in mindsets of judges, of prison and probation staff, of detention monitors, and here the training has been key. I did have some nice pictures of various programs that we have implemented, so hopefully we can get the PowerPoint up. But just as some examples, PRI with the Kenyan Probation Service adjusted their tools, their pre-sentencing questionnaires that they use to give to the judiciary, so that gender-sensitive assessments could be done in the cases of women. We, along with others, have trained thousands of prison and probation staff around the world, including in Uganda, Central African Republic, Algeria, Morocco, Pakistan, just to name a few countries, that has really focused on practically every day, how do you put the rules into practice? We've also documented in our Global Prison Trends report every year that there are many, many rehabilitation and support programs for women. And many of these are led by women who have experienced imprisonment themselves or other charities. For example, in Uganda and in Thailand, there have been women in business programs seeing really positive results, and not least because these women in business programs reject gender stereotypes. They're not asking women to knit, to sew. They're giving them seed money, they're giving them business plans to go and carry out some of their own business. And not common, but I think worth mentioning, are countries where we've seen specific strategies for women in prison and women in justice systems being developed at the centralized level with really high leadership, which then has a very good knock-on effect throughout the system. On our website, we have an interactive map of good practices on implementing the Bangkok rules. So you can all find that on our website, and feel free to share more good practices with us so we can add to this. Time's short, but I want to share a few thoughts on where do we go next to really see implementation. Firstly,
one minute.
Firstly, scale up the type of efforts that I have described. We need investment, we need financial investment, we need political investment. And secondly, and I think this will be reflected in a lot of discussions over the next 3 days, we need to address the pathways to imprisonment to stop the harms of imprisoning women. The data is clear, as mentioned by my friend here, and the concerning trend of rising female prison populations globally show that we need to redouble efforts in exposing why so many women are being swept into the system in the first place. Address poverty, address status offences which criminalise women for behaviours that under international law should not be criminalised. Look at punitive drug policies. And my last point is that we need to put justice-impacted women, women who have experienced the system firsthand, centre stage in developing and implementing strategies. We will hear from women with lived experience. They're very brave to come here and speak up here. I can see it's quite intimidating. But these women, their stories, their recommendations, they must be heard and answered to. After all, they know best how policy and practice impacts them. They can often be the make or break, the real difference as to whether an intervention is sustainable and really impactful in implementing the Bangkok rules. So that would be my last recommendation, and I hope that this conference can start off that conversation of how to involve people with direct experience more and more. Thank you.
Thank you very much, Olivia. Now we'll hear from Ms. Lillian on the Maputo Protocol.
Thank you very much, Lucy. Our experience that I'll share today is compounded from our 49 years of existence. We make 50 years next year as FIDA Uganda. And we note that the Maputo Protocol is a groundbreaking women's rights legal instrument that expands and reinforces the rights provided in other human rights instruments. The protocol provides a broad range of economic and social welfare rights for women. Notably, it was produced by Africans and pays specific attention to the African woman. This year, Africans commemorated 20 years of the protocol, and unique to this year is the fact that Uganda submitted the first state report to the African Commission on People's Rights. A commendable effort to the government of Uganda and particularly to the Ministry of Gender that coordinated this process and allowed for NGOs and FIDA Uganda to contribute to and to validate the report that was shared. Important to this discussion are women that are extra vulnerable, and that is who our core constituency is. As FIDA Uganda, I will not break them down, but that includes widows, women living with HIV, as has been severally mentioned in this morning. We also need to understand how groups of women experience crime as both victims and offenders, and that it is a critical thing for us to ensure that they get a fair, effective, and efficient services within the criminal justice system. One way that society groups women is by gender, and long history of research shows that women and men are impacted differently, as we have heard this morning, by crime, and that they engage differently with the criminal justice system. While men make up the majority of those accused, convicted, and incarcerated of violent crimes, the rate of violent victimization is highest among women. I'll just quickly go through, because of the interest of time, speak to the context of these women as we have seen over the last 49 years. And I'll just quickly mention that within the Uganda women criminal justice system, as we had in this morning, women exist at different stages. They are among the people that that form the composition of the police and other law enforcement groups, the local council courts and their mandates, and also the courts and the correctional centers. As we heard from the commissioner this morning, that forms 30% of that category. We also see women as perpetrators, as has already been mentioned. And just to note that the 39% that the commissioner talked about this morning, studies show that most of the convictions for murder and manslaughter are as a result of self-defense in domestic violence situations and other cases such as land justice-related matters. It is perhaps time for us to adopt the battered women syndrome defense, because by the time a woman murders and or kills another, they have been pushed to the wall. But it's something that doesn't, or that is not considered through the defense processes in our various court processes as we have encountered them. I'll quickly mention the challenges that women face. While we have quite a progressive legislation, as was mentioned by Commissioner Hadija, we know that most of the various the policies or the laws that have been mentioned, we do not have efficient enforcement mechanisms. We also note that we don't have sufficient budgets to enforce and or implement these existing mechanisms. While the pro bono system exists, we note as FIDA Uganda that it is largely gender blind and doesn't quite address the specific needs of these women. We also recognize the effort of jealous actors in creating victim-centered justice processes, initiatives of the DPP, such as providing meals in these various criminal cases that are heard in the various courts. we still feel like FIDA, as FIDA, like Tom Sawyer says, that it is not enough. This is not enough, and we still want more to be done by the justice or the duty bearers within these systems. We also note that there are high illiterate levels. There's a very wide digital divide that affects access to justice for women in the criminal justice system. The challenges that come with the pre-trial stage, as was already mentioned this morning, are some of the impediments to proper access to justice for the women within the justice system. What has FIDA done for these women? Of course, we provided legal aid, we watch brief, we have lobbied and advocated for enabling justice processes. We were among the people that lobbied for the provision of GBV, specialized GBV courts. But we still also note that while we have done all of this work, they still need to engage communities, collaborate with informal justice mechanisms so that they are able to take care of women that have served their sentences in order for us to avoid what we call criminal justice system. Recidivism is the ability or the potential for women to become reoffenders in the various communities that they are reintegrated in. There's need for us to continuously advocate the partnerships that were talked about repeatedly in this morning, work with like-minded organizations so that we can popularize the existing ICT innovations, get support for these women to navigate the different processes such as the plea bargaining process that is available within these systems, but also for us to bring it to the attention of the duty bearers that the plea bargaining system, as we have found it at FIDA Uganda, is largely gender blind and does not quite address the needs of the victims within the system. We find it largely perpetrator-centered and also one that doesn't quite apply the human rights-based approach. I'm trying my best to wind this up, and I'll briefly speak to the key recommendations of the Maputo Protocol itself. And the first one is that we need to have legislative measures, and that we need to have modifying behavior. States are obligated to investigate violence against women, punish perpetrators of violence against women, and provide remedies. We also note that women must be given full and unbiased information about all of the legal options which they may have to redress their particular situations. The Maputo Protocol encourages the engagement of and involvement of community leaders, social workers. It encourages the creation of an enabling legal environment. We still don't have a national legal aid bill to date. We don't have witness protection laws to aid witnesses within this system. Briefly, the recommendations is let's create this environment that is still lacking in very many ways. Let's ease physical access to these institutions that provide access to justice, bring services closer to the people. As FIDA, we are advocating for more mobile courts within the work that we do, and also the need for us to adopt the Bangkok rules. I will not belabor that because it has already been ably spoken about by my colleague. Support the inclusion of a target towards promoting people-centered justice in the next 10-year plan. Sensitize legal professionals to on the gender issues that arise as we handle these cases, in our day-to-day work as an organization. I'll leave it at that for now, and I'll perhaps speak to the next when I get the opportunity to do so. Thank you, Lucy.
Thank you, Lillian. We will now have our final panelist, Agnes Kisembo, talking about the CEDAW.
Thank you so much, Lucy. First of all, my name is Agnes Kisembo. I work as intergovernmental specialist and gender responsive planning and budgeting with UN Women. I'm here to represent the country representative, Ms. Paulina Chiwangu, and she sends her greetings. I'm going to discuss about the Convention on Elimination of All Forms of Discrimination Against Women and Girls, CEDAW in short, the extent to which it has been domesticated in Uganda, okay, but in line with women in the criminal justice. First of all, I would like to applaud the government of Uganda for being consistent in domesticating CEDAW recommendations. We have been consistent, especially if you look at the Constitution of the Republic of Uganda, if you look at the various laws and policies that have been developed. We have the Domestic Violence Act of 2010, we have the Anti-Trafficking Act of 2010, we have the GBV policy of 2019, we have a number of guidelines, we have the National Gender Policy of 2007 reviewed, okay, thank you, which has just been reviewed, pending cabinet approval. So upstream, in terms of having policies, in terms of having laws, in terms of having guidelines, I think Uganda has done very well. And we applaud the government for that. We have the recent CEDAW, yes, 8th and 9th report, where Uganda presented to the CEDAW committee in 2021, and it has quite a number of recommendations. I can share with you a hard copy or soft copy after this, in case you're interested, where we have quite a number of recommendations where we should be putting much effort. So that said, we've been quite progressive in terms of domesticating the international legal or normative frameworks for promoting and protecting the rights of women. However, that has not translated into transformative change in terms of women realizing their rights. The fact that we've been progressive on paper in terms of developing policies, laws, guidelines is good, but it's not good enough. And that brings in the element of the barriers, okay? And barriers, especially in the context of women in the criminal justice system. I'm very excited that we are quickly adopting to the use of gender desegregated or sex desegregated data, which is a very good way of helping us to question the numbers, okay? It's a very good way of helping us to plan, to inform our decisions and our budget commitments. So for me, I'm very excited about that because it came out from different presentations. That says, I would like to share some of the indicators in the context of Uganda. According to the Global Gender Report 2020, Uganda ranks 109 out of 158 countries in terms of gender parity in top leadership positions. So I'm highlighting this because it will lead us to what we are seeing regarding the issues that have been raised. Women hold 37 of the senior management positions in the private sector and 36.2 in leadership positions in the public sector. However, representation of women in parliament is at 34. When you compare with the global broad representation, which is 25.5 representation of women in leadership, you would say Uganda has done significantly well, isn't it? Because the global indicator is 25.5 and Uganda's case in terms of representation at parliament is 34%. And you know, when we were writing our constitution in 1995, our target, I think, was 30%. So you would say we have even exceeded the target set. So, but that was under targeting, because if you look at the global commitments we have done under Agenda 2030, we have set parity 50-50 by 2030. That in across social, economic, political areas, we shall have 50-50 representation of women by 2030. We have 7 years to reach there. So given where we are, shall we be able to obtain even in leadership? The answer, you know it. So I would also like to say that some of the issues that have been raised, I know the official in prison said we have quite a number of women serving male prisoners, but the opposite is not true, okay? And we need explanations for that. The explanation is simple. If you look at the way women have been broadly socialized, women are socialized as caretakers. If you look at the gender roles, responsibilities, roles, they have dissected gender roles between men and women. They shape girls to think in line of care, support. And they shape men, boys, to think in terms of leadership, dominance, authority. So we have to go back and question our cultures in a good way, because we have positive cultural values, but we also have negative cultural values and practices that have held us back. So if we want a change, to see a shift, it has to start with our mindsets, our attitudes, our beliefs, in terms of the value we accord to a girl and the value we accord to a boy, men and women. Of course, we are not a homogeneous group, but we have to really look at that. What value do we place on a male? What value do we place on a female? Because this is reflected in our statistics. Police, Uganda Police, we have 2 women directors out of 9. Isn't it? This is police in terms of top leadership at directorate level. This cuts across the judges. I'm not sure how many women judges we have compared to men. It goes back to parliament, 100 plus out of so many men in parliament. So if women are not at the table to express the concerns that are affecting them, the decisions passed, the policies passed, the laws will not favor them or address their issues consistently. So I wanted us to reflect on the socio-cultural factors, the underlying socio-cultural factors that shape our thinking and how much that influence our positions where we sit as men and women. There is outright resistance, especially for women leaders, in positions of authority. Why? Because of gender biases, stereotypes, beliefs that women are weaker, which challenge their confidence and capabilities to act. Yet, we started with a prayer here. In the morning, we all started with a prayer, believing that we are all created by this God, and then we are all created in his image, male and female, and he has given us, all of us, a seed of potential to be the best that we can be. So there are quite a number of challenges. So it's within the area of the environment, policy, structural factors or barriers, and of course our mindsets as individuals that we need to really work on if we are to holistically address a range of issues that have already come out from the previous speeches, remarks, a range of issues that have come up. I had quite a lot, but time is not my best ally. We have issues of sexual harassment which constrain women's progressive growth. We have issues of transfers when it comes to transferring officers in uniform to serve in other stations. Some of them have opted to become single mothers because an agreement cannot be reached between the spouses. So there is quite a lot. We have issues of biases in terms of the recruitment process. If a pregnant or an expectant mother shows up for an interview, she's likely not to take up that job because she's carrying a pregnancy, and the panelists will judge and say, this one is about to deliver, maybe we choose Jack. She may not deliver to our expectations. There is quite a range of issues that we still need to address going forward, but in terms of policy, legal frameworks, guidelines, and high-level political will, I think Uganda is on track, but we still have challenges to address. Thank you so much.
Thank you. A round of applause for the panelists. In my good but not good enough, I went to primary school somewhere in northern Uganda, and we had this particular teacher that it would be a tick like this, and it would be a cross. I don't know how many of you had, those of us on the 4th floor, I don't know if it was teachers at that particular time, so you thought it was correct until you suddenly found that cross at the end of that tick. It wasn't an X, but it wasn't also a complete tick. So UN Women is telling us that in terms of implementation and the legal framework, we are at good but not good enough. We have heard from FIDA that we have progressively implemented the Maputo Protocol, but there are areas of people-centered justice, legal aid, and support to women that has not been adequately done. UNODC has informed us about the criminal justice programming that they have, and Sharon, I'd like you to, just before that, we have two audiences, the physical audience here, and we also have the online audience. And Diva, I don't know if we have any questions from the online audience that you maybe bring to our attention. But we will have 5 minutes. We will have 5 minutes of Q&A, but UNODC, could you briefly tell us about the 5-year program and how you intend to address some of the aspects that have been raised today? FIDA, could you just briefly tell us those aspects of the plea? Uganda has been implementing the Plea Bargain project since 2016, and FIDA has been one of the entities that has been looking at the gender responsiveness of plea bargain, especially for women. And I'd like you, Lillian, to raise those aspects of plea bargain that don't seem to favor the women who are in conflict with the law. So we could start with that, and then we open up the floor for further questions.
Thank you, Lucy. To distinguished guests, to better understand our 5-year program, which has been enabled with the generous contribution of the Embassy of the Netherlands in Uganda, it's very important also understand the mandate that we have as UNODC. I always shudder to explain because we are a UN agency with a very broad mandate, but I'll try to compact it as quickly as I can. We are custodians of several conventions, but also international standards. Quite important, it's important to note that we are the custodians of the UN Convention on Transnational and Organized Crime, and its 3 protocols focused on trafficking in persons, smuggling of migrants, and anti-firearm trafficking. We are also the custodian of the UN Convention Against Corruption, and relatedly work around economic crime, illicit financial flows, countering financing of terrorism, and money laundering sits under our docket. By virtue of our name, we are custodians of the 3 drug control conventions. I will not break them down, but we are responsible for the implementation and supporting member states. As earlier referred in the opening remarks by our moderator, we are also responsible for the norms and international standards relating to the criminal justice system in as far as crime prevention and criminal justice is concerned. So right from police reform to prison reform across the chain is an area of work. When it comes to health, we are a co-sponsor of UNAIDS. We are one of the 10 co-sponsors, and we're responsible for the HIV response among people who use drugs and people within the prison setting. So bringing this back home to Uganda, in partnership with criminal justice actors, we have an ambitious 5-year program that strives to look at how the criminal justice actors in Uganda can better support the government in achieving its targets, in achieving SDG 16. When it comes to strong institutions, we're working very closely with all the actors in the criminal justice chain to build capacity on their ability to counter organized crime, terrorism, corruption, and drug trafficking. And we are working and have partnered with the Legal Aid Service Providers Network to look at how do we target vulnerable groups within the criminal justice system in as far as legal aid is concerned. And this is quite pertinent for us, looking at the over 300% prison congestion that was earlier stated by the Commissioner General. We want to look at what are the modalities to build alternatives to imprisonment, how do we access those vulnerable groups, women and girls, including men who find themselves unable to have access to legal aid. In partnership with Penal Reform International and the Uganda Prison Service, we are working towards supporting prison reform that will enhance prison management, but also enhance prisoner rehabilitation and reintegration. And this is where we see a very clear interface with the private sector, where we can build partnerships that can enhance offenders that leave the prison setting and are willing to integrate within the community. We are also trying, with support from other law enforcement actors, to follow the money. And if we follow the money, that is which are directly attributed to crime, how do we support the government to make this money work for the government? And so in partnership with the Financial Intelligence Authority, the Ministry of Internal Affairs, and other security actors, we are looking at accountability and transparency, mainly focusing on countering illicit financial flows, countering financing of terrorism, money laundering, and we are soon to look at what are the modalities when we talk about asset forfeiture and how do we manage proceeds of crime. Because Uganda has a very young population, and I think the African continent, looking at the other members in the room, the youth agenda is an important one, and we see quite often that more young people are interfacing with the criminal justice system. One of the critical thematic areas of our 5-year program is looking at youth crime prevention. The idea is to build resilience of young people to be able to not engage in criminal activities, to be better resilient as part of communities, not to engage in drug use and relatedly the crimes that come of it, and quite timely to the situation that we're experiencing when we look at violent extremism. We see that young people are playing an active role and are easily radicalized to violence that leads to terrorism. And so this component of youth crime prevention will also look at how do we build resilience of young people, and some of the challenges that easily make it easy for them to be radicalized to violence that leads to terrorism. We are working together with many actors in this room, but we also think we can learn from our global and regional partners, as Uganda itself can also be able to share its experiences, and we hope that through this program we'll be contributing to some of the important targets that Uganda is trying to achieve related to the SDG goals.
Thank you. Thank you, Sharon. Lillian, on plea bargain.
Very, very briefly, from our interaction with the women in prisons, apart from the common problems of overcongestion, lack of breastfeeding rooms, and those things that are important for women in prisons, one of the issues that has repeatedly come across from the women is that they do not quite understand, they are not taken through the plea bargaining session for them to understand very well what it eventually means for their freedom and bargaining, for sentences that are fair. So that has been one of the things that has come through. So it comes back to the illiteracy that perhaps we mentioned earlier, but also when you look at it from the victim perspective, a lot of the plea bargaining processes, they've done very well in decongesting the prisons, but they do not take into account the plight of the person who has been affected by the perpetrator, or the person whose well-being, whose emotional state has been affected by the perpetrator. So the emphasis is on the perpetrator and how long they will spend in prison at the expense of the person who is the survivor in the whole process. So what we are saying, or what research is saying, is for the plea bargaining processes to be reviewed to make them more human rights best, to take a little more time to understand the plight of the survivors and or victims, other than laying emphasis on the perpetrators. I think that will go a long way in giving it a gender face, which we are otherwise finding gender blind as they implement it. Thank you.
Thank you. Thank you, Lillian. I'd like to open up to the floor for the next 3 minutes, if there are any questions. Diva, do you have any questions for me online? No? There's a hand at the back. The gentleman on that table, Justice Wolayo. So we'll take those 3. Can we have the mic there to Winnie?
Thank you very much, Madam Moderator, and to the presenters. My name is Winfred Adukule Moita. Perhaps mine is just a comment as well as a concern. We're talking about prison reform and management. I will declare my interest, juveniles. Where do juveniles fit into this whole equation? There's been so much we're doing for adult prisoners, but that is often a very forgotten group of persons. And I hope and pray that in this 5-year program, that is something UNODC can look into, because these children really do need skilling, they need help, they need to be able to realize their right to effective legal aid. Thank you very much.
Thank you, Winnie. The gentleman just on the next table from Winnie.
Thank you very much. My name is George Kasozi. I am associated with some 2 academic institutions. I would like to be helped here. The panelists, and I think even Dr. Canon Biabasaija alluded to that point, That is, okay, we have a prison which is male prison, but superintendent over by a woman. I do teach criminology and penology in one of the institutions, and at one time we had a discussion on this very issue of correction and rehabilitation. I was wondering who amongst my students would end up in the prison. And as we discussed, I realized that some of the ladies, in fact, majority of the ladies were saying, no, we don't want to go to a prison where we have our fellow women as warders or as in charge. We would rather go to a prison where you have male warders. Now, I don't know, could this be something which is emotional or psychological? Maybe you could help me to understand this. Thank you.
Thank you, Mr. Kasozi. Can I have the mic to Justice Wolayo at the front here? Right here.
Thank you, moderator. I'd like to respond to the problem of women on remand and sentenced raised by Sharon. We realized this problem a long time ago, almost like 10 years ago. You know, those of us who had just joined the High Court bench, and realized that it was to do with the first in, first out system of cause listing cases. You know, there are more men who commit offenses than women. So by the time, you know, you get to list this woman, maybe there are 2 or 3 who have committed, what this a serious offense. It's, you know, the number, the cause list is full, because at that time we would list only 40 cases. So we introduced the practice of, you know, insisting on at least 10% or 15% of the cause list being, you know, comprised of women. So that problem, I think, has been solved at the High Court level. So the challenge could now be at the magistrates' courts level, and, you know, we need to investigate this further so that we can address this gap. Thank you.
Lord, is that something that the International Association of Women Judges will be doing in the near future?
About this? Yes, we plan actually to visit prisons, and I think that's another way of identifying women who have challenges, you know, who have delayed in the system. So I think that's one of our objectives this, you know, in the next 3 or 4 years in our strategic plan. We should be visiting prisons more often and interact with women prisoners. Many times, like recently, I visited Nakasongola prison, and there were women, I think somewhere in a corner there were like 1,000 prisoners. So I never even go to interact with them. So we need to actually target women. When we visit prisons, we should actually go to the women's wing and talk to them, and not talk to them together with the men.
Thank you, my lord. The representative from UN Women will address the concerns of Mr. Kasozi.
I will try, Lucy, because it could be deeper than what I think. But like I said, generally speaking, there is outright resistance for women's leadership. Okay? Taking it from that angle, it could be a belief that women are not good leaders. That's a possibility. It could be a belief that women are weaker. That could be a possibility. But I think we need to interrogate and ask the women separately and find out why they prefer men to lead and to guide them rather than fellow women leaders. It's something that can be interrogated, and you get their realities, their perceptions and beliefs around that. So it's something that we can support.
Thank you. I'd like to give PRI 30 seconds for the final remark.
Thank you. The question around women supervising women and men being allowed to supervise men actually reminds me about how the Bangkok Rules came about. So in 1957, the UN Standard Minimum Rules for the treatment of prisoners, now known as the Nelson Mandela Rules, when they were revised in 2015, already included, well, only included 2 provisions relating to women. And one of them was to say that females should only supervise females. And this was in recognition of all of these power imbalances and gender inequality, and the recognition that these women coming into prison are super vulnerable, complex, often victims themselves, and so they needed to be supervised by women. And just to add on to that, the need for the Bangkok Rules was very, very clear to PRI when you looked at the rules around hygiene equipment. So there was a rule saying that prisoners must be provided shaving kit, but there was absolutely nothing about hygiene products for women. And so that's how the Bangkok Rules came about, because a princess in Thailand realized that there was a big gap, and she spearheaded the whole process, which is why they're called, of course, the Bangkok Rules. So I hope reflecting on the international standards around sex and of supervisors and so on can be a helpful point anyway. Thank you.
Thank you, Olivia. A round of applause for the panel. Unfortunately, that's all the time we have for this. I invite us to use the breaks and over the next course of the 2 days to interact with each other and maybe be able to discuss and pick up some good lessons from each other. I thank you all for your kind attention.
And now a bigger round of applause to Lucy Ladira for ably handling that conversation in such a short period of time. But several aspects and concerns that have come through, of course, most recent, the conversations about hygiene, women who haven't been convicted, and so many others, a conversation about juveniles that also did come through. Probably that is another aspect that we need to be paying a lot of attention to. We'll have just one more panel before we go for lunch, because we needed to have 2 more before we could, but that may be a little bit hard to achieve. But we are next going to have the panel on the access to justice for women in the criminal justice system. Like we said earlier, for those who are joining us, it's not to say that the men's rights are being neglected, but the unique aspects when handling women in the criminal justice system that we need to be looking at, and that is why we're borrowing from best practices from other countries and see how we can be able to incorporate those in our criminal justice system. And without any further ado, ladies and gentlemen, for our next session, the moderator will be SCP Kamia John, who is a Senior Commissioner of Police, Human Resource Development at the Uganda Police Force. So let's give him a round of applause. I think the panels are well balanced. The last one had only ladies. I do not know about this particular one. Maybe SCP John will be letting us know on how this conversation actually does go on. So you could introduce from here and then you can choose.
Thank you very much, Mildred. And thank you very much, the previous panel and the audience. The next panel is going to be on access to justice for women in the criminal justice system. My name is Senior Commissioner of Police, Dr. Kamia John, from the Uganda Police Force Headquarters. As we are all aware, access to justice is a basic principle of the rule of law. In the absence of access to justice, people are unable to have their voice heard, exercise their rights, challenge discrimination, or hold decision makers accountable. Different international, regional, and national legal and human rights instruments emphasize the right of equal access to justice for all, including members of the vulnerable groups, and this includes women, and reaffirm the commitment of member states to taking all necessary steps to provide for fair, transparent, effective, non-discriminatory, and accountable services that promote access to justice. So, for us to discuss and digest this, we have a panel of 4 distinguished guests, and among those is Honorable Justice Jane Francis Abodo, Director of Public Prosecutions in Uganda. Honorable Jane Francis, Director of Public Prosecution in Uganda. The second discussant is Ms. Joel Kabagambe, Deputy Executive Director, Bridges to Justice, Rwanda. The third discussant is Mr. Hannington Amol, Head of African Leadership Program, Kenya. And the fourth member of the panel is Ms. Grace Daffa, Executive Director, Women's Legal Advisory Center, Tanzania. I don't seem to, okay, she's there. So you are very much welcome, members of the panel. I will start with Honorable Justice Jane Francis Abodo, being from the host country. Honorable Jane Francis, in your experience as the Director of Public Prosecutions and as a former judge, what steps has Uganda taken to ensure that women in the criminal justice system receive access to justice?
Thank you so much, and I would also like to join the rest in thanking the organizers of this very important conversation. I just said it is happening at the right time. Just to give a bit of context, okay, thank you. Just to give a bit of context, I'll start with, you said as a judge, and then I remembered some 2 cases. There's a case, I was not the one who handled it, Justice Mutonyi handled it, where the son raped his own mother, just waylaid her on the way and raped her, and the mother kept on crying, "Why are you doing this, my son? Why are you doing this?" He just continued, raped the mother, and then went on his way, went home. The mother went, collected herself together, went home, got, I think, a stick, and beat the son on the head just once, and he died. And she was charged with murder. And she stayed waiting for trial for about either 5 or 6 years. Then she appeared in court, and the case started. And what was the story? The story came out, this is my own son, and he did the unthinkable. And what did the judge say at the end of it? The sentence was, go home because you already served your sentence. And anyway, she was already dead, because then for the rest of her life, she will be living with that stigma, with that shame. The second case was a case in Lira. The man told the wife, the child was sick, so the woman got the bicycle of the man to take the child to hospital. And the husband told her, bring back my bicycle. Just walk to hospital. She just came back, got a, I don't know whether some of you know it, a pistol, which they use for pounding, just hit the man on the head and he died instantly, and she was also charged with murder. But the story came out that there's been a long history of violence. So just one incident sparks it off. So what does this show? This shows that the women, most of the women, they told you already the statistics, most of them are there for murder. If you really cared to listen to their stories, it is just that these are cases, long history of suffering, long history of violence. Just one thing sparks it off, and then that calls for having actors. When these women come into the system, we should have actors at police, at DPP's office, in the courts, in the prisons, who have some kind of gender-sensitive, trauma-informed, so that some of these women, do they have to serve a sentence? Can we call them criminals? Or they are just victims, accused who are victims? Should they be serving a sentence? Or should they just be going for social psycho support? So those are some of the things that we need to have the story behind what, because women are not designed to be takers of life. They're givers of life, and they preserve it. They do everything to preserve. So when they do the opposite, then we should be able to ask ourselves. So that's why I'm saying this conversation is happening really at the right time. Historical. We have been talking about women should be also put, if we are to really tackle this elephant in the room, women should be in positions of authority. I was happy when my brother said there are 5 women in the senior management. Then I said, what happens to the top management? We should have also women there in the top management. And this is across board, really. When I joined the judiciary, I noted one thing. I think with the exception, at the time I joined in 2018, with the exception of Justice Wolayo here, all the divisions were headed by the men, and all deputies were women. Can you imagine? All of them in the judiciary. So that's why I'm saying, and then after all these years in Uganda, the first female DPP is just got in 2020. So that's what we are saying, that we should have women in these positions, because then that's where the decisions are made. If they are not there, then they are forgotten. Like my sister said, Namutebi, she said, why are we saying that the prisons are designed by men for men? You see, eh? So we are just grappling now because the number there. Why? Is it because that the women were not committing offenses, or is it that our offenses were ignored? Look at the offense of child marriage. That is customary. That's customary. How do you start saying that's an offense? Look at rape. Rape, people used to go off because it was not considered an offense. Domestic violence, it was said those are matters of the bedroom. Don't interfere. Even when you take to police, they say, why are you bringing your matters here? You should solve them in the bedroom. But now it has come out that these are offenses. Maybe that's why we were not, because our offenses that touched us, were ignored. From the pre-colonial times, we were not actually, even the colonialists actually dealt with the men most of the time. I don't hear of women who were there in the administration of justice. It was always men. So it became that the men were actually designing most of these things for themselves. The voice for women was not heard. So that is why it is so important now that we talk about access to justice, to women. How do women, because we may commit the same offenses, but we have heard that women, just for lack of a better word, when you imprison a woman, you're actually imprisoning the whole family. Because in Africa, let me talk for Africa, in Africa, The family is held together by a woman. The man may be the head of the family, but the heart of the family is really around the woman. So when you imprison a woman, you're actually imprisoning everyone, including the husband. So that's why this is very, very important for us as we go ahead, that women who come into contact with the law, whether they are accused persons, whether they are victims, whether they are witnesses, that we should design some kind of what can help them, what can help them deliver better. Even as a victim, when they come as a victim of crime, how do the police handle them? How you handle a victim of crime, let's say rape, determines what kind of statement they will give, even the quality of the statement that you get from a victim of rape. If a victim of rape comes and gets 5 investigators in one room, and then she's supposed to tell her story in these 5 investigators, by the way, who are men, and she's supposed to tell her story, you think she's going to say that I was raped? She's going to say that there was an attempt to rape me. From the state attorney, the same story. Then when they come to court, they say, this is our chance. This is our chance to say the truth. And they start telling Justice Walayo that, the man actually raped me. And Justice Walayo says, no. In your police statement, what did you say? You say attempted rape. Now you're coming. The defense jumps on her. You're telling lies. You see? And that's exactly what they fear. That will people believe me? Because most of the time, the people who rape them are people who know them. Defilement cases, there are people who know them. People who defile are not people who are so far away. The father, that favorite uncle, and all that. So that is why we are saying that even the historical barriers to access to justice, like gender stereotyping, it affects how women give their story in police, how women give their story at the DPP's office, how they give their story in court. It affects it. And then we go to the Uganda case. I'm just going over this very, very fast. What are the initiatives that we have put in as a country? I was very happy to hear UN Women. And it's true, we have really done so much as a country. We ratified the Convention on the Elimination of All Forms of Discrimination Against Women in 1985 without reservations. And also, we are, as a country, we are signatory to most of the major international human rights instruments. So we have the legal framework in place. That is good for us. Even under the 1995 Constitution as amended, we have now a number of aspects. I think Article 21, that provides for freedom from discrimination. We also have for women who come into contact with the law, Article 28(3). It gives that non-derogable rights that we as key actors are supposed to actually fight for and make sure that anyone, and especially women, who come into contact with the law are actually guarded so well. So that is why we, as the office of the DPP, now decided to break it down and make it more chewable, just for lack of a better word. We have a department of gender in the office of the DPP. This department makes sure that all the cases of gender-based violence of children, of women, and those disadvantaged, vulnerable, are actually handled. And they're handled in such a way that we work together with police. They are prosecution guided, most of the cases under this department. They are prosecution guided. The prosecutors who are in that department are well trained. They're very much on top of their game. And we also have a cross-sectoral handbook for victim-centered investigation, which is so good. And because of this, together with the multidisciplinary training curriculum on gender issues, we now are speaking from the last special session. We are actually at 80% conviction rate. Just yesterday when I was with Justice Ajiji he had a session in Patongo. Out of 56 cases, there were 44 convictions, which is, those are the convictions we get in plea bargain, not in a normal session, which means really if we train the prosecutors, we train the police, we train the judicial officers, we train the defense to ask the right questions, we can actually get to the bottom of this. So, and also as finally, I just want to throw in a few recommendations.
In 2 minutes.
In 2 minutes. In 2 minutes, that's even a lot. Adequate remedies. We say we have the legislations. We have the institutions. These institutions should be well funded, from the police to the DPP to the judiciary, should be well funded to actually handle this. And then we should have affordability. The economic factor is very, very key, so that we really speak about access to justice for women. We should address impunity at all levels. Then we shall send the right message out. Of course, strengthening the collective struggle. We have women's networks. We have the media, the fourth estate. They are our champions. They make the right noise for access to justice for women. Then, of course, law reform. I see my sister here. Law reform is very key, so that as we handle these cases, we listen to the stories of the women, of the men, and we design our laws so that they're actually addressing this issue. And then, of course, lastly, we should develop gender-responsive policies and general principles. So in conclusion, as key actors, we just need to widen the approaches to justice for women beyond the legal measures. You have heard from since morning, which means it's just not legal measures. We have to look at what is the nexus between the politics, between the economics, and between the culture, because all this come into play. If we use all this and deliver as one, then we shall definitely make a dent in this access to justice for women. Thank you so much.
Okay. Thank you very much, Justice Jane Francis. I now want to come to Ms. Joella Kabagambe. In strengthening access to justice, the United Nations works with national partners such as civil society organizations to develop strategic plans and programs for justice reforms and service delivery. So, Madam Joella, you are the Deputy Executive Director, Bridges to Justice, Rwanda. How has civil society organization in general and your organization in particular helped to ensure access to justice for women in general and women in the criminal justice system in particular, especially the Rwanda experience?
Thank you. Thank you, moderator. As you said, Rwanda work with civil societies to help people to access to justice. As we Rwanda Bridges to Justice, we are a local organization, a chapter for an international organization. We work with lawyers to help detainees, men, female, or children. But particularly in this workshop, what Rwanda Bridges to Justice do, we try to build a trust between lawyers and those detainees, women detainees. And sometimes you can find most of women want to be represented by women lawyers. Someone say here, sometimes women don't want to go to prison headed by other women. But in our countries, we have 2 female prisons. We have 13 prisons, but 2 are only for women. And those prisons are headed by women, because women can understand the problem of other women. It's very easy for a woman to be open to another woman. Even in courts, sometimes you can give a lawyer, a male lawyer, to a woman. It can be difficult for her to tell you that I don't want that lawyer because she needs legal aid. But when you talk to her deeply, we found that she needs to be represented by another woman. Most of them commit crime because of poverty. They just want to have something to feed their children. They can sell drugs, they can fight, they can, some petty offense, but just because of poverty. So, being represented by another woman lawyer, it's easy for her to understand her case and to go in front of the judge, convince the judge to give her freedom, or the process of pre-bargaining, what the prosecutor say here, the director. Civil societies try to work closely with the government, the Ministry of Justice, prosecution, judiciary, so that they can understand the problem of women. The director say here, when you put a woman in prison, it's like to put the whole family in the prison. We are the heart of our family. We have the heart of, we help even our husband to be there, to be the head of the family. So women, they can be victim and then commit offense. I had a case of a woman who was beaten every day. The husband come, beat her, never gave food at home, but just is the head of the family without being the head of the family. After some years, like 10 years, the woman, she was very tired of that situation, and she killed the husband. It's not good to kill someone, it's true. But if you do the backup, the background of that woman, she commit offense because of the life she live every day. So in front of the judge, as lawyer, you can bring that background, explain to the judge, so that she can have a minimum sentence possible, because she have to be punished, but the minimum one, so that she can go back to the family. Being a defense lawyer, being a human rights defender is not easy, but you have to put yourself in the shoes of the one you have to represent. You have to put your shoes in you have to put yourself in the shoes of the whole family, because you go to represent the whole family. And something when you go to see women lawyers in prison, the big issue they have, they are not visited by their husbands when they are in prison. But when women have husbands in the prison, they're always there to go to visit, bring something to them. But when the man is out, the lady in, he go and live his life. That is the challenge to be a woman. And a woman, she have to think about the kids who are outside. Some are with their children in the prison, but the kids, after 3 years, they have to leave the prison and go outside. So imagine that woman without a kid, or without another family outside. The kids will be placed in other families. Those perhaps can forget to go to visit the mom. So they have that legal issue and also mental health issue. Those mixed. So it's very difficult. So you have to be a lawyer and also to be a psychologist. First of all, think about what she wants and then talk about the case. So the question they asked me, we try to build that trust. We try to mix all kind of issue together so that you can help the woman going out of the prison. I think my time is up. Thank you so much.
Thank you very much, Madam Joella. Mr. Hannington, actually, I'm happy that you were a man. You know, the previous panel was full of women, and I felt very suffocated and dominated. So I kind of got an experience what women feel when men dominate, actually. So, but now I'm happy I have a fellow man. At least I'm not so much of a minority. So, Mr. Hannington Amor, you work with African law practice. Where does Kenya stand in the access to justice for women in the criminal justice process?
Thank you so much, Senior Commissioner of Police, and thank you to the delegates. I need to clarify that I'm John the Baptist. I'm actually in the presence of the Justice herself, Justice Roslyn Aburili. She will be speaking later about the actual Kenyan position, so I may not be authoritative. Secondly, I'm pleased with whoever planned the actual positioning of the microphones in this house. I'm struggling to lean left. Naturally, men, we tend to focus more energy on our right, but whoever did this actually had a real experience of what women go through, that in the society, women have unique physiological dispositions, sociological dispositions that need to be taken into account. All the panelists here are very comfortable leaning left. I'm the only one who is struggling with the microphone, but thank you for the organization. It's actually a reflection on the discussion we have today. Why should we be discussing about access to justice for women 3 decades after the 1995 Beijing Conference on Women's Rights? 30 years later, why are we not realizing the 100% aspirations of, access to opportunities and rights to women? It simply means there's still room for improvement. Now, access to justice, not just limited to Kenya, but globally, would have to look at the various components of people who are involved with the crime. Of course, the primary involvement will be the victim and the suspect of that particular crime. At some stage, the suspect will mutate into an accused person. They may then be convicts. And at the terminal stage, they will be prisoner. The victim herself might also happen to be the witness. So when we are discussing access to justice, we must look at the unique situation of these 6 different individuals involved with the crime. We should not lay much emphasis on the accused and forget the victim. We should also not leave access to justice to conviction and not think about what happens to the convict after she has been sent to the prison, and even what will happen after serving their prison sentence. The Commissioner General of Prison made an interesting observation. I was keen on it, that over the last decade in Uganda, the population of women in detention has grown by 125%. Of course, that could be shocking. It could be an indicator that more women are getting involved in crime, but I simply looked at it as the population generally has grown. It's 125 compared to what growth in the population. So I would not want to crucify women for getting more involved with crime, but actually concentrate on what are we doing to reduce the number from 125% growth to 0% in terms of growth. And I believe that is what this conference is focusing on. And Sharon had made an interesting observation, which I'll address as a major point in the discussion, that 36% of women compared to 30% of men are held in pre-sentencing detention. Looking at the UN standard and global human rights standard, pre-sentencing detention is actually a violation of human rights. The aspiration of human rights instruments globally is that nobody should be held in jail, regardless of the gender, before a finding is made as to their culpability, so that pre-sentencing detention should only be limited to people who have shown that they are likely to interfere with the prosecution of the offenses or disappear or commit more offenses when they are released before the trial is over. So are we saying that women are likely to commit offenses or interfere with their trials if they are released before they are sentenced? I don't think so. And my theory or hypothesis is that the society as structured is patriarchal. When a judge or a magistrate is faced with a case involving a woman as an accused person, she will apply the law of the book. When she's granting pre-trial bail terms, she's likely to look at what the rules provide, and the rules don't discriminate between men and women. In Kenya, the bail bond regulations or conditions provide that it can either be a cash bail, with or without a surety. It can actually be a free bail with a surety, or it can be a bond, in which case a title deed, a property, a capital market certificate can be deposited in court to secure someone's release. And looking at what the statistics Sharon had given, my hypothesis is that the structure of the society discriminates generally against women. How many women could rightfully, truthfully say that they are owning title deeds to land that they can use to secure their freedom? How many women are holding car logbooks that can be deposited in court? How many women are holding share certificates in, listed or quoted companies that could be deposited in court? The nature of the society, which is patriarchal, favor men, and most of these properties are in the hands of men. And the moment a woman is accused of committing crime, remember, the woman long left her family. She is married in a foreign land. She's amidst foreigners. So the moment she's accused of a crime, she'll most definitely be in the foreign land where she's married. She doesn't have her relatives there. And do you expect the man's family to sacrifice their title to secure the freedom of this woman before the trial is over? Chances are nil. While when a man finds himself in that position, he's amidst his family members. They'll be ready to use the family title, the family car to secure his freedom. Probably this is the hypothesis. That's why we have so many women in pre-sentencing detention than men. It is the structure of the society. And how do we address that? The American system has something they call bondsmen, which is basically commercializing the release pre-trial through commercial bondmen. Could we as Africa think of this as a solution? Could we allow, the same way banks give security, bank gives loan, bank gives guarantees, could we think of commercializing this process so that women who are disadvantaged could actually get opportunity through support of their friend or even women group to secure release using the bondman services? That's something we could think about. But
summarize in 2 minutes.
Thank you. Where are we in Kenya? One, access to justice is now a constitutional right, and it's part of our national values. I hope others could also think of the same. We have gender-dedicated desks at police stations that basically cater to the unique needs of women that Justice Abodo had addressed earlier. The law now provides for emergency medical care to women who face especially gender-based crime and sexual offenses. There is a robust witness protection program, even though it's underfunded, but at least it's women-facing. The police have been capacitated to have pre-arraignment bond, which enables them to release before taking to court. Female detainees are segregated, both at the police cells and at detention as remand and even after sentencing. And we also have an independent police oversight authority, which is basically able to investigate offenses or complaints against police crimes or police offenses, especially by persons in custody or even victims of offenses. And we also have a legal aid scheme, which is still not having a good uptake because it's underfunded, but is an opportunity. And finally, amongst other things, Kenya has professionalized the prosecution of offenses, has increased the number of female prosecutors, and has taken the prosecutorial powers from the police and taken it to professionally trained lawyers, meaning there's clear separation of investigation and prosecution of offenses. This has brought in, this specialization has also meant that women victims as well as women suspects and accused of offenses are almost guaranteed a chance of getting justice because you have specialized investigation. Even at the ODPP office, that's the Director of Public Prosecution, there's a specialized office that deals with women and gender affairs. And thank you for that opportunity.
Thank you very much, Mr. Hannington. Our last question is on legal advice and legal representation. Ms. Grace Duffer, one of the major obstacles in accessing justice is the cost of legal advice and legal representation. Legal aid programs should be a central component of strategies to enhance access to justice. You are working with Women's Legal Advisory Center in Tanzania as the ED. How has your center helped women in the criminal justice system to access justice in Tanzania?
Thank you, Mr. Moderator. I would like to make a little correction. My name is Grace Duffer, Legal Aid Manager for Women's Legal Aid Center. My executive director was supposed to come as an apology.
Try to go near the microphone.
My name is Grace Duffer. I'm working with Women's Legal Aid Center as Legal Aid Manager. I'm not the executive director. My director has an apology and she's sending her regards. As question posed, say that the cost of legal representation is very high, and the Women's Legal Aid Center being an organization which provide legal aid from 18, we provide legal aid to women who are victims of violence and as offenders as well. And what we are doing, since we say that the cost of legal representation is very high, we are trying to do a prevention measures, and we are doing that through raising awareness to the women and the community in general, so that they don't find themselves in conflict of the law. When women are aware of their rights and the procedure, they are also able to negotiate about how to get their rights. Sometimes we get messages from the magistrate saying that your client are very stubborn. When they come to court, they have a lot of questions. It's because they've been empowered about their rights and they are able to ask him when something is wrong, either in procedure or in content. Another thing we do is to provide legal advice to these women, both as victims and as offenders. We also conduct coaching for women who are offenders, because the organization cannot provide legal aid or legal representation to all women. Due to scarcity of funding, sometimes we don't have enough advocates. So what we do for those women who have offended justice, we coach them on how to self-represent themselves in court and present their cases in police. And we also coach them on how to demand their rights, like right to bail, right to lenient sentences in court, and that has helped them to get their right or to access justice. Another thing which we are doing for women in the criminal system is also to assist children in conflict with law with legal aid advice and legal representation, because majority of women are poor, and when their children get into conflict with law, they cannot afford to have legal representation from private lawyers. So what we do is to offer legal assistance to those children, to educate them to do legal representation so that they are able to access justice. Another thing which we are doing is to visit the prison and provide moral support to these women who are in prison and provide the basic needs like food, clothes, medical
because sometimes when you go to prison, women will say that we are having some ill problems, but we don't have medicine. So we find ourselves coming back and organize for fundraising and provide the support that women need. Also, we provide them with sanitary pads and the other things which are within our capacity. Another thing which we are doing to support women in the criminal justice is economic empowerment. As we say that majority of women go to prison or find themselves in conflict of the law because of the poverty. So we have a program on women's land and property right to empower those women to have an income from property ownership so that they are able to cater for their basic needs and that of their children. Because sometimes we receive cases whereby children are caught stealing because they don't have basic needs from home. So when we support those women to be able to cater for the basic needs of their children, we also assist them in that way. We also do advocacy for the implementation of law and the necessary reforms in the criminal justice so to ensure that women needs in the criminal justice are catered for. Like you have heard about the launch of the Presidential Commission on Criminal Justice, we participated very well in highlighting issues which are affecting women as we heard them from women themselves. And we are happy that some of those issues were very much highlighted in the report of the commission. And now the report is on the way for implementation. Like right now, the Judiciary of Tanzania has established a subcommittee to identify those issues related to the judiciary so that they start implementing the same right away. We also work closely with
some 2 minutes.
We also work very closely with Tanzania Police Female Network and the Tanzania Women Judges Association to ensure that issues of women and issues of gender are being taken into consideration in the process of criminal justice system. Thank you.
Thank you very much, all of the honorable panelists. I think we need to give them another big round of applause. And thank you very much, our audience on the ground here and our online audience. Now we have a plenary of less than 10 minutes because we are eating into our lunch time. I'm going to our online audience. If you have any questions, please send them in. But as we wait for your questions on the screens, I can call upon any of you who have a question to raise up your hand and ask the panelists. Yes, the gentleman over there. I think we shall be taking all the questions at once and we answer them at once. And they should not be more than 4 questions, and then we go for lunch. So, gentleman there, I don't know your name.
Yeah, thank you so much. My name is Joseph Sira. I'm a chaplain from the Born Again Fraternity, ministering in prisons. And my concern is, one, and through my ministry, I encounter women who committed or taken to prison on a case file where she's more than one or they're more than one on the file with the men. But while in prison, they get bail pending appeal or pending judgment. Before the conclusion of that case, the men are off hook, and it is the women who suffer the brunt at the conclusion. They are those women serving. Moreover, they're on the same file, same case, but at the end of the day, the men are out of the same case. It is the women suffering this. Madam DPP, now even more blessed that you're a female DPP. What is the criteria? Or how is this? How does it come about?
Okay, Mr. Assistant Commissioner General of Police, Tumwebaze. At least that one I can recognize.
Thank you very much. Let me correct it. Assistant Commissioner General of Prisons, not police.
No.
But you are pardoned. Thank you very much, the moderator and the panelists. I stand to address this. I hold this view that before we address those who are in the prison, we should start with where they are coming from. Because if you look at the people or the women that we have in prison, fundamentally, they are from the rural setting, very far away from the cities. Having committed A, B, C, D, all those murders we are talking about. Very few are from the cities. And that is coupled with our social, historical, and cultural history. And we have also observed that men are part of the problem. And here we are, in most cases, we are in the conference halls, seminars, discussing and coming up with solutions, which fundamentally and most of the time remain here. Can we try to move further down there and get the local woman to appreciate and understand even what is justice? The time I have lived in my village, I have never seen even anybody passing around, other than of recent when there came in community policing. Other than that, to do with justice, fair hearing, understanding somebody's human rights or women's rights, it is almost not existing. Can we move from the rhetoric talks and discussions from here and cascade what we are talking and put it effect in the rural setup so that the local simple woman gets to understand? And I implore this, dear participants and delegates, that we shouldn't do it in isolation of men. Actually, when you are talking of women being victims, you are telling us to resist, to understand. We need to bring all the men, if not almost everybody, to understand, because you are talking about women, we talk about women, where are the men? We shall continue resisting it and it will not help us. I submit.
Mr. Tumwebaze, whom have you directed the question to? Whom do you want to answer your question?
Since this is a plenary, I put it all of us.
Okay.
Whoever is capable to make a comment can make it, because it is helpful to all of us in any case.
Okay.
I thank you.
Thank you very much. So, any other question? Okay. Being there, no. Is that a hand up? Yes, madam. That should be our last question.
Good afternoon, everyone. I thank you, everybody here. I kindly take this question to Madam DPP. Thank you so much for your speech. I have loved it. As a former incarcerated prisoner, I was very happy to talk about the system of, I wish when we are for trials, they always first consider first offenders, second offenders, third offenders. They group us in that way that when you are first offender, you are just first given a chance of a lenient sentence. It will help to teach people, other people. And more so, I am adding to my commissioner. I'm very happy. I was also burning with this question that I wish we go to grassroots, because being in prison, me, 13 years, I was a reader for 12 years as head girl, and a counselor, I was counseling the inmates. The major problem, they are illiterate, 99 point. They are all illiterate. They are not exposed. They are not knowledgeable. So we say we can cooperate for us who have come there. We have passion. We can go and sensitize, as HIV was sensitized everywhere. Even for us, we are ready to sensitize those villagers, those people in remote areas. They don't see TVs, they don't listen radios, they don't know the disadvantage, they don't know laws. We are there to help to limit such a number, which is increasing. And more so after prison, we face a challenge of settling. I wish also we are considered as groups. We are given myogas. For example, I'm a chairman. I'm having inmates like 50 ladies. We are looking for capital. We are not, because we applied in KCC for myogas, but we are not considered. At least we need also to be what has made us to be in prison. It is illiterate, over ignorance, and poverty. I cannot stop talking about prison, but I thank you for this. I know there is something going to happen. With God, everything is possible. Thank you.
Thank you very much. I will ask our panelists, starting from Justice, Honorable Justice Abodo, and any other member of the panel who would like to respond. But the responses should be not more than 2 minutes each.
Thank you so much. I'll start with my sister, the last one, and I want to say congratulations for coming out and being in this room. Can you imagine 13 years and then you come here? And that is exactly what we look at when we are saying the criminal justice chain. We are interested in how you enter in, when you're inside, and then when you come out. When you come out of the University of Understanding, you should actually come out and sit with us on the same table like this, discussing issues of access to justice. So I want to say congratulations. And that is spot on. It's a continuation of what my brother was talking about, sensitization, community sensitization, because when we just sit there and wait for people to come, wait for files from police, and then take them to court, and then afterwards people are convicted, we are actually just being in theater. We're just doing postmortem. So what you're saying is totally, I agree with you, that we should do community sensitization. Because when we talk about access to justice, I think the true meaning of access to justice is when the last woman in the village has access to justice in terms of in terms of that they can actually reach it. It is reachable. They don't have to travel miles to access justice. And then they also, when they travel, when it is near, it should be affordable, economic terms. Then, of course, lastly, we should not use all the legal jargons. When people come to court, they don't understand what is happening. They come in, stay there, the judge is talking, the defense lawyer is talking, the prosecutor, only jargon. And so it should not be like that. So access should encompass all the three. And I agree with you that we should do more of, that's why we say that we work with CSOs, we work with NGOs. They're the ones who can help us reach the community. Of course, police as community policing, we should do that. Even the office of the DPP, we should get out of prosecution and do prevention, not so. So that at the end of the day, we really talk about reducing and making sure that access is given to people at the grassroots, those who need this justice more. And of course, you said we include men. Totally, I think that's what we started off from the very beginning, that we must include men in this conversation if we must succeed. Because most of the time, you might forget and say this is something that we, the women, run away with. And sometimes I think maybe it is overhyped and it is misunderstood. But I think we have said that we need the men in this conversation and we shall not lose sight of that. The last one on the file where men and they're charged together with the woman, the men get out and the woman stays in. That's like bail. which means maybe the bail terms which were given, and that's what we have been saying, that we have been disadvantaged, even economically, historically, as women. The bail terms are given, someone said they need a land title. How many women own land, culturally? The bail terms are given 2 million, even just 100,000. Okay, let's just say 50,000. Some women don't. Economically, they're not empowered. The men are the ones who are the heads of these families. So when you give now the same bail terms, and that's what the law says, you have to give the same bail terms. So I'm thinking that some of these laws, we should breathe life into them and don't take them as they are. We should modify them to fit in our circumstances as we handle the cases, because people come to us with cases with problems, social problems. They're not even looking for legal solutions. They're actually just looking for social solutions. So that's why we say, when we sit in those seats, places of responsibility as a judge, as a DPP, you have the responsibility and you have the chance actually to use the law to actually make it meaningful. So I think that is why maybe sometimes the women can't actually get the bail, because they cannot satisfy the bail terms. So that's what I can say briefly. Thank you.
Thank you, Honorable Justice Abodu. When you talked about the University of Understanding, I started seeing Dr. Byabashaiza in another light of being a vice chancellor of the University of Understanding. So my other panelists, do you have any comment? Yes, Noel?
Thank you, moderator. The strategy we take in Rwanda Bridges to Justice is the prevention of crime. Not sit there waiting for people going to jail and then represent them, but we do campaigns, prevention of crime. We start in the secondary school. Those schools out of Kigali, those schools, we teach them about the law so that when they go back to their families, they can teach others. We take those from senior 1 to senior 6, and also those in primary school. We open up clubs, anti-crime clubs. We teach them the law, and then they can go and teach others in their family and their village. And also empowering women, socio-economic empowerment for teen mothers and also single mothers. That strategy helps a lot, so that people can stay away from crime and live their life, normal life. Thank you.
Thank you very much, Joel. Mr. Hannington, any parting shot?
Thank you so much. Just specific to what the Assistant Commissioner General of Prisons posed to us, where do these women come from, the women in detention? I think in the afternoon we'll be talking about poverty as a source of women in prison. So I know Julie and the team will be discussing about decriminalizing poverty, because women are in prison being caught brewing or selling traditional brews, which were basically celebrated by our ancestors, being caught selling weed, bang, to earn a living, or being caught in what is called prostitution, but basically a trade in their flesh, which are still offenses in the book. So those are things that will need generally to be addressed. But the other point I wanted to address, again, it had come earlier, is that victims of crime, especially women, if they don't get assured justice, they end up in prison as convicts or as accused persons. And simply because if a woman faces sexual violence, for instance, and she knows how the society reasons, she's likely to seek self-help, and that could end up being a charge of murder or attempted murder in the process. So probably, as we look at the source of women in prison, we must ask ourselves, are women victims of crime getting justice? Are they confident that if they report to the police station, they are going to be heard, their story is going to be investigated? Are they confident that if they present themselves before the judge, they are going to be heard? And are they confident that if they have fear of presenting themselves as witnesses, there's a robust witness protection scheme in place that can still assure them that their story can be heard in court without fear of retribution or vengeance by the society. I think those are some of the things that we can debate as we carry on with the conference. Thank you.
Madam Grace, 2 minutes.
Okay, thank you. My take will be to invest on community awareness from at the level of family, starting with the children, because if people understand their rights, it is very easy to not to get into conflict with the law, and sometimes when they get into conflict with the law, they are able to negotiate their rights. That is why we say that Women's Legal Aid Center, we are working with the community, and we do community inclusion, which means we are working with men and women. Because if we let aside men, they tend to defend themselves. So it is very important to include men, and we start with the children so that they understand and respect the human right of each other, because we know that the root cause or the main source of women going to prison or coming into conflict with law is poverty and the lack of awareness of their rights. So if we invest on those areas, it is going to work, and we can assist those women to access justice. Thank you.
Thank you very much, Madam Grace, and thank you very much, our distinguished panelists. You've been such a good source of knowledge and information. Thank you very much, our audience, both here on the ground and online. I would like to say that some of the questions will be answered also in our coming sessions. For example, I know there is a session on Friday about challenges around resettlement of female offenders, and this will answer very well the question that the other lady raised. So let us just keep in the sessions, and many of the things will be discussed as we go on. Thank you very much. And
thank you very much. Let's put our hands together for Senior Commissioner of Police, Kamya, for the wonderful job of moderation you have done. We all entirely agree that access to justice remains a very critical point in the justice system, more especially for women. A few things I have picked. One way of getting through this is to have to reach the emotional treatment for the women who are across the other side. But I think we also need it this way, because if we don't have an emotional stability, we shall have a challenge. Two, as Israel said and clearly stated, economic empowerment is very important. While it is easy for a man to order that they sell land and bail him out, a number of times the woman has nothing to sell because she will have gone with everything that belongs to her. Then there is the social isolation, that while a man goes to the prison, whether he has even fought with his wife or done something against his wife, it's an obligation to visit the man to the prison, because if he comes back, he will chase her. But more often than not, when these women cross to the prison, nobody wants to visit them. At best, the men get other spouses and life goes on. The children are not allowed to associate with somebody who has gone to prison. So the trauma becomes so much in far as isolation is concerned. And of course, like she has stated it, the majority of the women are illiterate. Everything that is done in our courts is really discriminative. The language spoken is English. The dress code is very challenging. The court environment is very tormenting. The cameras are everywhere. I think we may need to go back to the ground and see what is the best environment if we are to get the best out of the women to access justice. We had another session, but we are not going to have it now because the sugar levels have gone down. But let's clap to ourselves for having gone through the morning session successfully. Thank you so much. Our lunch is served down near the poolside. I think all of us have coupons. Those who have not got, ensure you have a coupon so that you are not bounced back. Let's be as fast as possible. It should take us not more than 45 minutes, and we are back for the afternoon session. Thank you very much. Good afternoon.
because it was all conversation throughout. So we want to give you more time to be able to speak to each other and interact after the afternoon session comes to an end. So before, we will also be getting our keynote that we didn't earlier on have in the morning. I'll be letting you in on that conversation later on. But just to be able to set the pace, I would like us to share some experiences, because many of the discussants and panelists earlier on were sharing stories, and maybe some of these look like they're too far away or far-fetched for those who have not interacted with such persons. But how about we get to listen to someone who's been through it and can be able to share their story and their experience. This is not going to take us a lot of time. It will be just about 5 minutes. So ladies and gentlemen, allow me invite Codette Roslyn from Karamoja to share her experience with the conversation that we are having. Codette, where are you? Please, I would like to have you right here. Yeah, let's welcome her. Let's give her some warmth. I know that we will be a little bit patient. Some of the parts might be emotional, but we will give all the patience and listen to you, Rosalind, please. The mic is yours.
Thank you so much. I'm Codette Roslyn. I came from Nabilatu. I stay in Katanga village. I came to share with you my testimony. When I was 10 years, my parents died all. He left me with five sisters and 4 brothers. I'm the 6th one. And I was the one who was big from these young ones. After their death, now life became hard. We used to wash plates for people, for survival, for these young ones. The big ones, the one whom I follow, they were beating me. They could not take me to school. I stopped in P2. Even the English which I'm speaking, I learned it from prison. Then from there, we used to go for kibarua. They pay us with posho. We eat with my sisters and my brothers. After, these big ones, when they have not got anything, when I have not looked for it, they beat me. Then I decided to marry when I was 14 years. I said maybe I will solve the problem of my sisters and my brothers. Then from there, I saw that it was also something which was hard, and life became hard. We continued with this husband of mine. I also got him on the street. He also got me on the street. Then we used just to share our life like that, which led me again, when I saw that life is not well, led me to begin now drinking, to remove stress, so that the smaller thing which you get, you give your brothers, then you take pombe. You become drunk, you sleep. Then one day, my father and my mother left us with 2 houses, small ones, grass thatch houses. Then the uncle wanted to grab the houses. Then from there, I told him, now, these brothers of mine, they don't have anything in their heads. They are big for nothing. It is all them who can take care of the children, and then plus others. Then this man, my uncle, chased us. Then I told him, we are not going anywhere. And first of all, I was even drunk. We had 1 cup of posho. I made porridge for my sisters and my brothers, they took. Then I went for my ledger. I carried water, 5 jerrycans. After, they paid me my 1,000. I came, I took my warrant. Taking warrant, I became drunk. Then I went home. I got children when they were crying that the uncle is chasing them away. Then I told my uncle, why are you chasing us? That this is not your place. For you have married, you go away. Then I said, what about the rest of the children who are taking care of them? Then from there, these ones, these big ones, they concentrate on beating only. They come when they get something, it's not at home, they beat me. When they get anything, it's not at home, they beat me. Now from there, I conceived my child. I was pregnant by that time. They chased us from our home. I went away. I produced my children from out. Then they brought me back home again. After chasing us, they brought me back home. I said, it's okay, because I cannot carry all these children. I take where? Then I brought them back, bring them back. This is the very uncle again, who became drunk. Then he came and beat me here. And then I got also a stick. I threw on him. It went miss to the child of my brother again. Then because it was the in-laws who took care of that land of ours, then the in-laws, they have to arrest me. They took me to prison. From prison, I left my children too. I left my brothers. The young one was 5 years. I left the other ones also. Now from there, I kept quiet. They took me to prison. I was convicted 7 years. From 7 years, they took me to Namaru. I got depressed. I was very sick. I started vomiting blood. Now from there, when I was vomiting blood, they called again on the phone that your brother, the young one, is sick. I say, now, I have nothing to do. I don't have anyone to come and visit me. I don't have anyone to help me. I carry sacks to help myself in even prison. Now what can I do? Now from there, they told me that my young brother, he has died. He said it's okay. Imagine, I struggled for that boy when he was 3 years. And then I kept quiet. I had to give it to God. I say, God, it's okay. Even the time when this case happened, my husband was chased with the children away. Even that one, I never knew where he was. Then the stress of my brother also came in. Then the stress of children, also came in. That's when I started now vomiting blood just because of the help of myself. And then they transferred us to Moroto. Again, I saw also life from Moroto. It was also very hard. Every day fetching water, prisons, fetching water, fetching water. It makes me again cough blood. They treated me with Panadol. I said it's okay. Corona came, took us to Kotido. Kotido also was a problem. Digging every day, carrying sacks of pamba, digging rice, digging peanuts every day. Then again, they told us that Moroto it's now full. Corona is still there. They took us to Amita. Amita also, it was just like that, digging, carrying water, digging, carrying water. Then they brought us back again to Moroto, the same thing. Then they took me to Mbale. Mbale, I went to carry sacks for Posho to buy my soap because I had no one to visit me and I had no one to give me soap or to give me anything. I used my energy. Then I used to go and dig. Then we come back. When the vehicle comes, we go and we carry Posho. That store man gives us soap for 500, just like that, for smearing oil. Then when 2021, Pale group came, Pale organization came, it was on November. They said that they want to train people. They trained us for business plan. And I said, it's okay now, because my life was just like that. I just gave up. I said, now, you was out, it was the same thing. The children that are suffering, you don't know where the sisters they are. You are just there, like a stone. Then from there, we came to, we went for the training for PEL reform, for business plan. Now we have been training us. When you get your 500,000, you balance like this. When you get your money, you do like this. You get losses, you get profits, you do just like that. That's when my life came. Then I said, maybe it might be a hope in front. But I'd already lost the hope of my life because I knew everything was not there. No mother, no father. The plots they have sold all. The children they are in the streets. My brothers they are in the streets. Others they are dying. I just gave up. I say, God, it is only you who knows everything. Then when they called me, my sister, the one who followed me, called me that there was a young girl, our young girl of 14 years, just because there is nowhere to sleep and there is nowhere to stay, there is nowhere to eat from. This lady of fetching water, at night they called her, someone raped her on the way. I say, but then from raping her, that man also gave her HIV. She was 14 years. Say now, there is nothing to do. Then I told her, you're there saying that they have done that. You are going to police. That now who can take us also to police? If we go there, they just see us because we are young. They undermine. We are just there. Then I told them it's okay. I'm still, that was 2021, I still have 2 years. Then I told them, you keep quiet, you just stay like that. And then I asked them, what about my children? They said my children, they were chased with my husband, that my husband grew mad because of the stress of the children. I said, now it's okay. Then I become lifeless. I just now remain like, I'm not even a human being, you just be there. Where the government takes you, you go. Where anyone takes you, you go. I just gave up my life. I say it's okay. It is only God who can solve my problems. But I was surprised when I was released. Before, I became sick in Maluku prison. We went to the clinic. They gave me Panadol. They told us, you go back to the chamber. We went to the chamber. We dug. After digging, you come and you get the treatment. You go and sleep. Then from there, pay reform came. The doctors, after training, they told us that you people, you come and you get treatment. That one who has his disease, you come and explain how you're feeling well. How are you feeling? Then from there, I also went because I was coughing blood. My heart was paining, the chest was paining, the whole body was paining. I could not access the way of drugs. You go to the clinic, they tell you, you buy. You don't have any money in the account. You don't have anyone to call. You're just there. Then I went there. They treated me. They gave me medicine. Actually, we were very many. They gave us medicine. Then they came back. Then the second route again, they came and they gave us again another treatment. That's when I saw that life is there with me. And I really thank God for today. I never expected this, that I will appear in big people like you. I thank God so much. And I thank the organization, Bell Reform, for the support which they gave us in prisons. Thank you so much.
All right, I think Codette deserves a bigger round of applause for that experience. Yeah, there were highs and lows, but at least, yes, we get to understand the context in which our conversation and our theme, which is looking at unlocking barriers and rights of women in the criminal justice system in Africa, entails and why we are having this. And to our keynote speaker, who is going to be speaking to us in just a few minutes, there's a lot of conversation that has come through, of course, with regard to adopting other procedures that need to come through. There are conversations about the lack of resources for these women who need to seek or secure their freedom. For example, if they have to deposit a land title or something like that. The patriarchal nature of our society seems not to be allowing that to come to pass. But also one thing that came out very clear is that many of the women, although we got quite alarming statistics coming through from the Commissioner General of Prisons, Dr. Byabashaija, earlier on, looking at the numbers in terms of those who have been convicted or charged with murder. One of the conversations that came out clear out of most of the panels is that this sometimes is not intentional, but because some of them are trying to protect themselves. So sometimes they are victims as opposed to perpetrators that they are looked at as. So that is why we are having this conversation to try and see, do we have practices that we can be able to adopt to look at the uniqueness of expectation of dealing with women in the criminal justice system. I will just have the chairperson of the Uganda Law Reform Commission make just a few remarks, and we'll be able to get our next speaker, and that will be our keynote address. Let me allow the chairperson of the Uganda Law Reform Commission to say hello to us and just say a few words and what you take out of the discussion that we have had this morning till now, because we're going to be here for the next 3 days. So to the Uganda Law Reform Commission, let's give them a round of applause.
Sorry, we are really running very short of time, and I didn't expect that we would have to make our intervention at this time. We are taking very copious notes of the various things that have been raised in terms of law reform that we need to take care of, but perhaps just to quickly respond to what the CGP said in terms of civil debtors, that we have taken care of in our proposed amendments to the Penal Code, which are currently with the Minister of Justice. Civil debtors really don't belong in jail. That's what I will say very briefly for purposes of time, but we have taken note. I'm here with a colleague as well, Ms. Doris Akidi, our Principal Legal Officer, and we are making very good notes on whatever you've raised. Thank you very much.
And like I did say much earlier on, it's not just an act for us to sit down and enjoy the fresh breath that is coming in from the lake, but it is about discussing issues that we're going to later on be able to implement and see a change in how women are handled in the criminal justice system from the point of entry up to the point of exit. We could hear the story of Codette that did come through Rosaline, which had highs and lows, not very good start, not very good ending, but all the same, we're glad that we could be able to have her here today to share her story. Ladies and gentlemen, to deliver the keynote address for this conference on the rights of justice affected women, allow me invite Her Lordship Justice Damali Lwanga, the Executive Director of the Judicial Training Institute. And I know that she has also done a lot with regard to trainings on how women in the criminal justice system can be handled. So let's give her some warmth and give her a round of applause as we welcome her. Welcome, my Lord.
Thank you very much, Doreen. Distinguished participants, all protocol observed. As I've been introduced, my name is Damali Nantude Lwanga. I am a judge of the High Court of Uganda and currently the Executive Director of the Judicial Training Institute. I have been asked by the Chief Justice, I've actually been directed by the Chief Justice to come and represent him at this conference because he could not make it. So I'm standing in for him, and I'm going to read his keynote address remarks verbatim because he gave it to me. A study by FHRI/PRI revealed that the population of women prisoners had unfortunately steadily increased in recent years. That women who passed through the courts were overwhelmingly poor, socially marginalized, often from unstable family grounds, and were frequently single mothers or were pregnant. The majority are uneducated and have backgrounds of domestic violence and victimization through discriminatory practices such as female genital mutilation, early marriage, and polygamy. They are largely ignorant of the law and lack legal presentation, particularly in rural areas where lawyers are few and far between. They face stigmatization from their communities because of their involvement with the criminal justice system. Substance abuse was a factor in some cases, but this was not a frequent occurrence. The women are stressed and lived stressful lives. The FHRI/PRI report further established that in Uganda, 92% of women prisoners surveyed had caretaking responsibilities, and 37% had experienced domestic violence. It was noted that women also experience violations of their rights in prison, and this can hinder their rehabilitation and reintegration when they leave prison, which may result in future reoffending. In Uganda, we are lucky that we have an elaborate legal regime that supports women's rights. The Constitution of Uganda, under Article 21, Sub-Articles 1 and 2 guarantees equality and freedom from discrimination on account of sex, race, color, ethnic origin, tribe, birth, creed, religion, social and economic standing, political opinion, or disability. Under Article 33 of the Constitution, the government is called upon to accord women full and equal dignity of the person with men. The state is further obligated to provide the facilities and opportunities necessary to enhance the welfare of women, to enable them to realize their full potential and advancement, and to protect women and their rights, taking into account their unique status and natural maternal functions in society. The Constitution further prohibits laws, cultures, customs, or traditions which are against the dignity, welfare, or interest of women, or which undermine their status. Apart from the Constitution, there are a host of other domestic laws that in one way or the other have recognized and especially provided for enhancement and protection of the unique rights of women and girl children. These include the Domestic Violence Act of 2010, the Children Act as amended in 2016, the Succession Act as amended in 2022, the Penal Code Act as amended in 2007, the Prevention of Trafficking in Persons Act of 2009, the Land Act as amended in 2004 and 2010, the Prohibition of Female Genital Mutilation Act of 2010, and the Employment in brackets Sexual Harassment Regulations of 2012. In addition to the above, the government of Uganda has also ratified a number of international conventions which we are currently enforcing according to their character. These include the Convention on Elimination of All Forms of Discrimination Against Women, the Declaration on Elimination of All Forms of Violence Against Women, the Protocol to Prevent, Suppress, and Punish Trafficking in Persons, especially women and children, the Protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, and the African Charter on Human and People's Rights. As you all know, the mandate of the judiciary as spelled out in Article 126 of the Constitution of Uganda is to adjudicate civil and criminal disputes following the constitutional directives below. 1, that justice shall be done to all, irrespective of their social or economic status. 2, that justice shall not be delayed. 3, that adequate compensation shall be awarded to victims of wrongs. 4, that reconciliation between parties shall be promoted. And 5, that substantive justice shall be administered without undue regard to technicalities. Addressing gender-based discrimination in the justice system is key to engendering the administration of justice and therefore making the administration of justice inclusive. The judiciary has taken commendable steps in ensuring that women and girls access justice services as much as their male counterparts. Among others, the following interventions have been championed by the judiciary. 1, passing and enforcing the Judiciary Gender Policy and Strategy of 2012. The judiciary's gender policy and strategy is focused on ensuring that there is gender sensitivity and responsiveness in the delivery of justice in Uganda. Accordingly, the gender strategy has committed the judiciary to ensure access and delivery of justice to all persons irrespective of gender, to create institutional awareness and demonstrable commitment to gender equality amongst judicial officers and other staff of the judiciary, to address gender obstacles in the delivery of justice, and to establish systems and mechanisms to address discrimination enforce women's rights, and address unfair treatment based on gender. During this quarter, I plan to constitute and fully operationalize the Human Capital Development, Gender and Equity Mainstreaming Committee to track all gender concerns and timely advise the Judiciary Administration accordingly. The second one is use of non-custodial measures and plea bargaining scheme. The Bangkok rules of 2010 recommend the use of non-custodial measures for accused women where possible. They also recommend that gender-specific factors should be taken into account by the courts when sentencing women offenders in order to reduce the gender-specific risks of recidivism, and that community sanctions should be preferred instead. Commendable effort has been made to promote community service for minor contraventions, and through the plea bargaining program, a number of women have negotiated for less severe sentences, both at the High Court level and the Magistrates Court level. Interesting to note is the case of Uganda versus Apio Agnes, where the murder convict was sentenced to community service of 240 hours after the court weighed the facts leading to the murder of her husband. In the Apio case, the court heard that the deceased had cohabited with the convict when she was 15 years and he infected her, and subsequently 2 of their 3 children, they had HIV. While her heart was still bleeding from these wounds, the deceased had an affair with her young sister, who had come to nurse the sick children. Infuriated by this discovery, Apio picked a club and battered the husband on the head, leading to his instant death. She pleaded guilty to the charge of murder. You have a right to form your opinion as to what would have been the appropriate sentence. Under the plea bargaining program, a number of female convicts have benefited. During financial year 2020-21, a total of 892 cases were disposed of, while in the financial year 2022-2023, out of 2,301 cause-listed cases, 2,144 cases were completed in record time. The third measure is conducting of special GBV sessions across the country. GBV sessions have been organized across the High Court and the Chief Magistrates Court, mainly targeting women and girls, whether as victims or perpetrators. It has been reported that rates of domestic and sexual violence against women are still high. Rape and other forms of gender-based violence, including domestic violence, female genital mutilation, and early and forced marriage, are the most common evils committed against women. With support from Government of Uganda and development partners, especially UNFPA and UN Women, the judiciary has since 2014 deliberately conducted GBV sessions both at the High Court and magistracy levels with very commendable results. Through these special sessions, timely disposal of cases and availability of witnesses have been guaranteed. So far, 4 phases of GBV sessions have been successfully conducted in 10 selected courts, and the 5th phase is in the offing. In financial year 2022-2023 alone, out of 771 cause-listed cases, 682 were conclusively disposed of within the 14 GBV sessions that were arranged during the time. The 4th measure is provision of legal representation and legal aid. Article 28, 3E of the Constitution dictates that all offenders charged with offenses that attract a death penalty or imprisonment for life be legally represented at the expense of the state. Legal aid is provided by court-appointed lawyers registered with the Office of the Chief Registrar, following the parameters set under the Judicature legal representation at the expense of the state regulations of 2022. Under these regulations, the Chief Registrar evaluates the performance of each lawyer and ensures hard work and quality legal services. The judiciary also supports the Justice Centers Uganda, which offers free legal aid services for both civil and criminal matters. There are legal aid clinics set up by various organizations, NGOs, and law schools. The available legal aid clinics and civil society organizations mainly specialize in providing legal aid to women, both accused of crime and victims, especially victims of gender-based violence. They intervene at all stages of the criminal justice process and provide paralegal services and legal representation. They also carry out monitoring visits in courts, detention centers, and police stations. Unfortunately, however, the majority of legal aid services, both government-controlled and civil society organizations supported, deal with criminal cases, and very scarce funds remain available for civil cases. Women especially need legal aid also for a number of civil issues, especially divorce, domestic violence, and inheritance in this country. With the closure of the Democratic Governance Facility, which was the major funder of legal aid services, the operations of justice centers and other legal aid services providers have been greatly frustrated. The fifth measure is dealing with negative customary practices. It has been reported that gender inequalities are exacerbated by discriminatory customs, particularly in relation to marriage, property rights, and sexual offenses. Adverse traditional stereotypes regarding the roles and responsibilities of women and men in society and in the family, as well as patriarchal norms that reinforce male dominance, still persist, especially among rural communities. These give rise to both civil and criminal aspects. The judiciary has adopted a proactive approach to these conflicts, and where necessary, we have ignored some cultural norms in favor of substantive justice, as guided by Article 33(6) of the Constitution. Number 6, induction of judicial officers on gender issues. The judiciary has taken deliberate steps to induct its staff on cross-cutting gender issues that affect justice delivery. The Judicial Training Institute, in collaboration with development partners, has developed training modules on gender issues. The most recent trainings at JTI conducted were on the areas of trafficking in persons, survivor support, and management of victims of gender-based violence cases, and disability rights. The judiciary has also published a gender bench book to guide judicial officers in this endeavor. This approach has nurtured the growth of a gender-sensitive bench that pays adequate attention to both male and female unique challenges in handling gender-sensitive cases. Number 7 is establishing gender-friendly environments at the courts. Working with the UN Women, UNFPA, and UNICEF, the judiciary has established at some courts children playrooms, shelters for breastfeeding mothers, and has ready psychosocial support specialists to attend to victims whenever called upon. At the moment, 11 courts have been designated as centers of excellence in managing GBV cases. And these are the High Court Criminal Division here in Kampala, the High Court Circuit of Soroti, the High Court Circuit of Gulu, the High Court Circuit of Fort Portal, Soroti Chief Magistrates Court, Moroto Chief Magistrates Court, Tororo Chief Magistrates Court, Gulu Chief Magistrates Court, Kasese Chief Magistrates Court, Fort Portal Chief Magistrates Court, and Buganda Road Chief Magistrates Court. Through these interventions, the judicial officers are more alert to cross-cutting gender concerns, which has made it easier for women to access justice. The eighth measure is the appointment of more women judicial officers to the bench. About 6 years ago, the number of male judicial officers far outnumbered their female counterparts, as indicated in the table below. And the table of judicial officers segregated by gender as of October 2016 shows that the justice and judges, among justices and judges, we had 43 of them male and 29 were female, making a total of 72. And for the registrars, the male registrars were 27, with the 20 female registrars, making a total of 47. For the magistrates, 162 of them were male and 129 were female, the total being 291. And the total percentage of males was 43.4% against 56.69% of females. Since then, deliberate effort has been geared towards achieving gender parity, both at the upper and lower bench, as a way of protecting the interests of both gender in the delivery of court services. This has been largely achieved, as indicated in the table below, and in this table, which was segregation by gender as of 16th October 2023, in the Supreme Court, we now have 4 male justices and 5 female justices. In the Court of Appeal, we have 7 male justices and 5 female justices. In the High Court, the male judges are 41 and 40 female judges. For the registrars, the male are 30 and the female registrars are 43. And in the among the magistrates, 247 are male and 228 are female. The percentages for the male are 50.8% of the total number of male judicial officers, and for the female judicial officers, the percentage is 49.5%. Number 9 is installation and use of audiovisual facilities. A number of courts have been fitted with audiovisual facilities, which have made it possible for the vulnerable and the shy victims to testify before courts without being physically present with their accused persons. This facility enables the witness to attend court in another room or even out of jurisdiction. His or her image and your audio is instantly relayed through a screen for other members in court to follow. Questions and answers are instantly relayed, and evidence is well received without the need for geographical presence of the witness. Virtual hearings through Zoom and other related technology have also saved us the cost and risk of transporting witnesses, accused persons, and even lawyers, in addition to enabling remote proceedings. And the conclusion is that whereas non-custodial sanctions, including the imposition of fines, cautions, and community service orders, are available for offenders who have committed petty offenses, while it is desirable to apply non-custodial measures to the women, the magistrates have raised a number of challenges which prevented them from using more non-custodial measures for accused women. Many women struggle to find appropriate sureties for bail because of their poverty. Refugees in particular find it hard to prove they have a fixed place of abode. Many women don't have a lawyer at all, and even if they are represented, lawyers rarely have sufficient time to discuss their case in advance and to uncover key aspects of a bail application, such as a woman's pregnancy. It is therefore recommended to approach the subject holistically so that all government and non-government actors are on board to provide the various solutions that are necessary to achieve a common end. The following 10 general approaches have been recommended as a breakthrough for making justice systems work for women. 1. Support women's legal organizations. 2. Support one-stop shops and specialized services to reduce attrition in the justice chain. 3. Implement gender-sensitive law reforms. 4. Use quotas to boost the number of women legislators. 5. Put women on the front line of law enforcement. 6. Train judges and monitor decisions. 7. Increase women's access to courts and truth commissions in conflict and post-conflict contexts. 8. Implement gender-responsive reparations programs. 9. Invest in women's access to justice. And 10. Put gender equality at the heart of the Millennium Development Goals. I believe the judiciary of Uganda has performed exceptionally well in this area. We look forward to more partnerships and better service delivery for our women and girls. Finally, allow me to pay a special tribute to the kind organizers of this historic conference, which has given us a golden opportunity to share our thoughts and to recount our achievements on this subject. God bless you. For God and my country. And the author is Alphonse Chigamoy Owinyidolo, Chief Justice of Uganda. Thank you for listening.
Once again, Justice Damali Lwanga, thank you so much for ably representing the Chief Justice and ably delivering his keynote address. And you touched quite very, very instrumental areas that require a lot of attention. And I love that there is something that is being done with regard to this conversation about paying attention to the women's rights. But I also loved the conversation about digitalization and application of technology in the criminal justice system. I think that saves quite a lot of resources, it saves a lot of time, but it also gives a leeway to do business unusual, quote unquote, like it is said. And that will also be one of the conversations that we will be having at a later stage, the role of technology and how technology can actually also be used. I love the fact that the judiciary is also going far ahead to look at the discriminatory customary practices, and that was a very key issue that was raised earlier on, the patriarchal society and how women are looked at and how women are molded from the time that they're girls to when they become adults. And I love that that came out very clear in your keynote address. Ladies and gentlemen, to get onto the discussion of the decriminalization of petty offenses, that is a conversation that also did come through. And the chairperson of the Uganda Law Reform Commission also did hint a little bit about it in her remarks, briefly as she did. So allow me invite Ms. Julie Mateka, who is the Program Manager, International Commission of Jurists, Kenya section, to come and speak to us about the experience there, but also the overview about petty offenses and, the criminalization. I remember there's a time I was hosting one of the UNODC conversations and panels, and the DPP was saying a chicken thief finds their way into the criminal justice system. Even one who stole a matoke bunch in there. You also have the criminal offenders in there. So how are we going to deal with this? I call it a song, I'm sorry to Justice, but I call it the song of case backlog, which we keep singing each and every day. So ladies and gentlemen, let's welcome Julie Mateka to get us onto this conversation. Let's welcome her with some warmth. Welcome, Julie.
Okay, this is perfect. Okay. Good afternoon. I know that we are running a bit late, but I hope that I will have everyone's attention as I present on petty offenses. It is something that as ICJ Kenya we have been doing for quite a while, and it is near and dear to our hearts. So allow me to introduce this particular conversation. The Kenyan section of the International Commission of Jurists is a non-governmental, non-profit, member-based organization that is the autonomous section of the ICJ in Geneva. So we are the only autonomous section of ICJ. We have members from the bench and the bar. I see some members here. ICJ Kenya has participated in the national, regional, and now global campaign on the decriminalization of petty offenses under the banner, "Poverty is not a crime." And I want to just see from a show of hands, how many have heard that statement, "Poverty is not a crime"? Okay, so just a few people, but it's okay. By the end of this session, you will see why it isn't a crime. So ICJ Kenya, in the advocacy work around petty offenses, was able to do quite a lot of research. In 2013, we did research titled Justice at City Hall, and we looked at what are the various factors within the courts, but also the kind of clientele that the city courts were dealing with and what are the prevailing factors. And what we noticed was there was a lot of, first of all, corruption within the court system because a lot of people preferred not to go to the courts and as such were able to negotiate their issues outside of the court system. But secondly, when people went within the court system, there was the challenge that everyone was pleading guilty. Why? Once you plead guilty, it was easier to get the fine, begin your processing, leave the court system, and go about your daily activity. And we saw that that was a challenge because ideally, fair trial rights were being violated. And in conversation with the people who had gone before the courts, they said that it is easier to plead guilty and get your fine and go about your business than plead not guilty. Conclusion. And that indeed was a bottleneck in itself. There was a challenge as well that when persons are within the criminal justice system, they do not have the possession of their wares. So if a person was caught hawking, these wares are seized, presented as exhibit, but unfortunately, once they are released, they do not get them back. So all this is detailed in our report, Justice at City Hall. It's a bit outdated, 2013, but we hope to do another one. In 2018, we then did another study in 3 counties in Kenya, Nairobi, Kisumu, and Mombasa, where we looked at the leading causes of petty offenses and petty offenders coming into the system. And indeed, the issue was the various local government laws that were in place. And we saw that this was a challenge because ideally the Constitution of 2010 in our country had abolished the Local Governments Act. So some counties had gone a step ahead to continue implementing this act, but also, on top of that, create new acts that mimicked the ones that had been abolished, which had similar punitive issues. So that was the next challenge. The big cities had a lot of local legislation that led to a lot of people coming before the courts. The next and most interesting piece of research that we did with my sister from CleanStart, she's in the room, was rethinking the bar's access to justice for women who commit petty offenses in Kenya. This is a recent publication, 2022, which seeks to look at the gender dynamics of petty offenders and the differences between men and women within the system. And I will be drawing a lot of my conversation from that particular book because I think it buttresses the issues. So one would argue, what is a petty offense? I have heard it being mentioned severally, but what is actually a petty offense? According to the Africa Commission on Human and People's Rights, Principles on the Decriminalization and Reclassification of Petty Offenses, it defines a petty offense as minor offenses for which the punishment is prescribed by law as a warning, community service, a low-value fine, or a short-term imprisonment, often for the failure to pay the fine. Examples that they give in these principles are being rogue and vagabond, idle and disorderly, loitering, begging, being a vagrant, failure to pay debt, and I'm glad Uganda is moving towards decriminalizing that, being a common nuisance, offenses created through bylaws aimed at controlling public nuisances on roads and public resources, such as urinating in public, washing clothes in public, and commercial activities such as hawking and vending. One would argue that it's the onus of the government to ensure that there are public resources for people who would want to have a human bodily movement. So why should we criminalize that? So the idea of petty offenses is cascaded in various treaties. We have had a bit of them being discussed here, so I'll just highlight a few. So there's the principles on petty offenses. There's the Ouagadougou Declaration and Plan of Action on Accelerating Prison and Penal Reform, which recommends decriminalization of petty offenses as part of its strategy and plan to reduce prison populations. You also have the principles and guidelines on fair legal assistance in Africa, which speak to the fact that ideally persons should not be detained because of lack of evidence, and in a lot of these petty offenses, the evidence is missing. You have the United Nations Declaration on Human Rights, which guarantee fundamental freedoms. We also have the Committee Against Torture, which has actually in its concluding remarks cited that the continued enforcement of petty offenses is actually perpetuating cruel, inhumane, and degrading treatment. So how do we ensure that countries abolish? Specifically on women, you have the Bangkok rules and the Tokyo rules, which have been highlighted, and speak about the question of women in imprisonment, and particularly in pretrial, with a conversation around the fact that women should not necessarily be in pretrial detention, particularly for petty offenses. So what is the situation in Kenya? Having said all that, the situation in Kenya is not the best, but we are making headway. So in 2017, we did a national audit of our criminal justice system, which stated that 70% of the offenses within our criminal justice system are petty offenses, which is a large number. Some of the petty offenses were drunk and disorderly, creating a disturbance, offenses relating to the lack of a license, which have instead been handled in a civil nature, have then been criminalized. In Kenya, female offenders make up 18% of our population and have annually been increasing from 7,200, and this is data between 2004 and 2012. Another study did 2012 to 2022, which showed that prison numbers relating to women were decreasing, whereas for men were increasing. But the bigger challenge is that women who are coming into the criminal justice system, unfortunately, are largely petty offenders, and we need to look at that. The data shows that a lot of the women are there for loitering, particularly with an intent to commit prostitution, child neglect, hawking, littering, and obtaining money by false pretenses. Depending on the level of obtaining, you can understand why it can move from a serious offense to a petty offense, but I think every case on its own merit. Similarly, we look at the fact that of the people who are particularly incarcerated in 2017, 5,145 women, which is a big number, 5,145 women were actually charged with alcohol-related offenses. And in this, you have also the bracket of persons who are engaging in alcohol-related businesses towards creation of wealth for their families, because it's a life-sustaining activity that has been passed down from generation to generation. So like the creation of Busa, Moratina in a few places in our country. I don't know which one you have here in Uganda, but those are some celebrated traditional brews that a lot of the women engage in creating, but unfortunately are criminalized for that. Equally important is 2018 results, which show that a large number of women, 72%, were actually incarcerated for a month to 2 years, which is ideally within the space of a petty offense. And that is quite a high number for people who are in for short-term incarceration times. So the overall conclusion leads us to believe that a lot of women are actually in the criminal justice system for petty offenses. Now, what are the consequences of the enforcement of petty offenses? I have mentioned there is a heavy use of custodial measures. You cannot have 72% of the women who are there on petty offenses being in custodial sentences. So it shows that we are heavily reliant on custodial measures. The next one is the overstretching of the state resources during the process. You find that you involve police officers, prosecutors. Once they're convicted, the prison officer. So you're overstretching the system with people who ideally should be diverted away from the system. You have overcrowding in detention facilities. A lot of prisons have reported overcrowding because of petty offenders, both in remand, but also who have been officially sentenced. The issue of petty offenses is that they're actually couched in very vague terms. So any person is within the ambit of a petty offense. Idle and disorderly has been really overused in my country to be able to attract anyone that the police want to arrest. And I'll speak a bit more about that one, but ideally one of those offenses, most of these offenses are actually very vague in the way that they are implemented. A number of petty offenses don't necessarily criminalize the person because they are a criminal, but they criminalize the activity, which is a life-sustaining activity. For example, in Africa, in Kenya, we do not have white-collar jobs for everyone. People have resorted to creating their own form of employment. We now are discriminating against people who are doing life-sustaining activity for that particular purpose. So I think it's a bit unfair that instead of being homeless and jobless, and then engaging in criminal activity, a person who then resorts to hawking is treated then as a criminal. So you see there's a need for a delicate balance there. So why are we criminalizing self-sustaining activity? There's another issue around the fact that ideally the criminalization of petty offenses often targets the poor and the vulnerable people in society. So we see that the people who go before the system are not people who can afford a lawyer, are not people who can actually be able to pay the bail terms if they're set too high, or even pay the fines once they're given. So you end up having a custodial sentence because of your inability. And the next one is the fact that the criminalization of petty offenses goes against almost all the laws that we have in our country, and most of the international regulations and international treaties that we have signed on to. So let's gender the conversation a bit more. Now that was the holistic issue with petty offenses, but what about the women's issue with petty offenses? So I've talked about poverty, but poverty affects women differently as house owners, as people who do not sometimes have this access to wealth. So poverty levels lead to challenges in securing legal representation. The family dynamic. Some women who engage in these life-sustaining activities are the sole breadwinners. Therefore, the incarceration leads to the destruction of the family unit. The sexual and gender-based violence by criminal justice actors, particularly the police or local county enforcement agencies, while implementing the arrest. In our country, we have the local city enforcement entity, commonly referred to as City Council or Kanjo, if you come from Kenya. And more often than not, when they are doing their arrest, it is actually something that is featured in the news because of how inhumane and sometimes barbaric it is. So you find that a lot of women go through a lot of violence in that entire process. Not only violence by the persons implementing it, but also even in terms of the kind of contact they come into once they're already bundled up together. There's a lack of basic education leading to non-engagement on the defense. You will find that some women, when they come before the courts, because they don't understand the criminal process, they will not engage. They will not seek mitigation. They will just agree. Anything that is said and anything that looks like it's being forced onto them, they will agree to it. So they will end up incarcerated, and when they go to prisons and asked why are they there, they will say tumeambiwa tukuje hapa. The court said, amri litolewa, because they didn't know how to engage in the process and they're unrepresented. We also have the challenge of stigmatization and discrimination by society owing to the work that they do. And in particular, this affects sex workers, commercial sex workers. Because people do not appreciate the role that they have in society as the oldest tradition, as the oldest profession in the society, whether you partake or not, it is the oldest profession. People do not see them as people in need of legal aid and assistance. So when they go before the system, they are actually mostly underrepresented and then stigmatized. When I speak about lack of rehabilitation programs, you find that a lot of the rehabilitation programs in prison are catered to long-term sentence holders. So you find that the petty offenders who come before the system really don't have an opportunity to really have proper rehabilitation programs go for them. The next one, which I spoke to earlier, was the deprivation of wares during arrest, which are not returned upon release. We know that this is a systemic problem within prisons, but mostly for remandees is the lack of adequate menstrual products in most remand centers, and I do employ a lot of non-governmental entities to consider really donating to the prisons. It goes a long way. Susceptibility to harassment and extortion by arresting officers, which leads to general corruption in the criminal justice sector, because one who is arrested for being idle and disorderly with the intent to commit prostitution would rather bribe their way out than go before a court of law in your dignified suit and tell the judge that indeed you are not doing that. So there's that kind of susceptibility to extortion. The haphazard nature of the enforcement of petty offenders often leads to separation of women and their children because of how it is done, the raids. Women are subjected to cruel, inhumane, degrading treatment, beating, kicking, stabbing. We have actually documented a bit, and in this regard in Kenya, we have been calling for the expanded mandate of the Independent Policing Oversight Authority to be able to look into the issue of accountability of certain officers. Due to poverty levels, some women are unable to pay bail and therefore are detained for an inordinate amount of time. But over and above that, they are not able to pay fines once they're given the fines and therefore lead to a custodial sentence. So their lack of wealth is actually a big issue here. So this is one of the key litigations that was done in our country. I don't think it has been appealed yet. It's the Mohammed Faisal and 19 others versus Henry Kandia, Chief Inspector of Police, OCS Songata Rongai Police Station, and 7 others. In this particular case, 19 people were rounded up for being idle and disorderly, and they were brought before Justice Nyakundi. And he actually argued, how do you establish idle and disorderly? What exactly were they doing? What is the evidence? The police stated that they were looking like they were going to engage in criminal activity, but how do you prove that before a court of law? You cannot arrest pre-action. So you should have waited for them to commit the action, then bring them, because ideally now you have just arrested them for existing, which is their right under the Constitution. So ideally it ended up with them being released. The advocate who they had called to have their matter resolved was also arrested on the charge of creating a public nuisance at a police station. And at the end of the day, they were awarded damages to the tune of 3 million for the advocate and 200,000 for the 19 of them. So 19, each of them got 200,000. So ideally, this particular case, one of the citations in it says that as a country which has had a long history of colonialism, and a lot of these laws are colonial laws by nature, it is time we rethink them and look at how we can amend the penal code to reflect the reality of today, because we should not have something like idle and disorderly within our statute. I will not mention the Africa Court on Human and People's Rights request for an advisory because of time. I've seen I've been given 5 minutes. However, ideally at the Africa Court, Palu, ICJ, Open Society moved to court to get an advisory of the compatibility of vagrancy laws in each of our respective statutes with the African Charter. And the court ruled in favor and mandated all the countries that are signatories to the African Charter to look at decriminalizing petty offenses because they're inconsistent with the laws of the land. So in case you're wondering how to go about it and how to base your arguments around decrim, this is the advisory you should use. So the last thing I'll talk about is the legislative reforms in Kenya. In 2017, retired Chief Justice David Kenani Maraga formed a task force committee called the National Committee on Criminal Justice. I am a member on behalf of ICJ Kenya. I know that Brian Kitui is a member on behalf of the Kenya National Human Rights Commission. And one of the TORs of the committee was to look at ways in which to decriminalize petty offenses from the statute. Towards that, ICJ Kenya developed the guidelines on the management of petty offenders in Kenya. These are national guidelines that could be used. So anyone who is willing to get them, please see me after this. But then more importantly, in 2023, the committee presented, and just this month, the committee presented a draft amendment of the Penal Code Cap 63 and the amended Criminal Procedure Code to the National Assembly for consideration. The bill proposes to decriminalize numerous sections under the Penal Code, including Section 182, which criminalizes idle and disorderly. Similarly, the committee was tasked by the Chief Justice to amend the National Sentencing Policy Guidelines, and we had the policy guidelines gazetted on the 1st of September 2023, and they actually acknowledge that community service orders are underutilized and recommend them for petty offenders. So these are now gazetted guidelines. So conclusion and way forward. Laws and policies and regulations have continued to form a basis for enforcing petty offenses. Once these laws are repealed or amended, there will be no basis for the enforcement of these laws. The criminal justice system in our country is inspired by the Constitution of Kenya, which has a robust Bill of Rights, to seek to do a paradigm shift, to ask the question of why, instead of focusing on what, so that we can ask the why question as to why are you in the criminal justice system? Should you be here? And look at the appropriate ways to deal with you. So I'll leave you with a task. So for anyone in the room, identify yourself. As legislators, you must be willing to introduce legislation on laws to decriminalize certain forms of conduct. As CBOs, NGOs, and public advocacy groups, you must be willing to bring public interest litigation in appropriate cases, help trigger legislative reform of existing criminal codes. As legal drafters and legal reform commission, ensure unnecessary criminal provisions are not added to general legislation. You might decriminalize something, but then someone will sneak it back in through another law. So you must be vigilant and ensure that it doesn't happen. Police and prosecuting authorities should take lead in diverting suspects out of the criminal justice system through the various mechanisms: plea bargaining, diversion policies, warnings, cautions, whichever way that is available to your various entity, please use it. And probation and aftercare services need to ensure that there are gendered approaches that are considered in reintegration programs. Allow me to end it there, and thank you very much for your kind attention. That has been my presentation on petty offenses on behalf of Kenya.
Another round of applause for Julie. Julie, sorry, if I put some music to your presentation, that would become a rap song. Because you were trying to make sure that you wrap up everything in the shortest time possible, and yet still hard to make the points come out fair and clear. And one aspect to pick out is the rethinking of our laws. What do they stand for? Most of them being colonial, and we still follow them. Do we need to rethink them, or do we need to repeal them entirely? That is a very great conversation that Kenya is having. I know Uganda is having that one as well. The pre-action arrest, would I equate that to preventive arrest in Uganda's case? Of if we think you are going to be a nuisance to yourself and the public, we can actually be able to stop you from doing exactly that. But anyway, yeah, it's all about rethinking the laws coming through. Okay, we're going to be moving on to the conversation that is talking about the management of women in pre-trial detention and looking at the experiences from East Africa. This is a conversation that did come through, and especially looking at the humongous numbers of women in pre-trial detention, and many of them staying there because probably they can't be able to bail their way out. They do not have the resources that are required, and we can clearly see out of Julie's presentation that that is not only a Ugandan scenario, it is also a scenario that is happening in Kenya, but we also want to listen to what's happening in other countries. So allow me to invite the moderator for the next session, Dr. Fred Sechindi, who is also a human rights expert. Ladies and gentlemen, let's give it up for Dr. Fred Sechindi taking us on for the next panel, which is not a very huge panel, but are having very interesting conversations.
Thank you very much, moderator. Ladies and gentlemen, good afternoon. My name is Frederick Sekindi, as I've been ably introduced, and I will moderate the conversation on pre-trial detention. So the theme of our discussion during this segment is the management of women in pre-trial detention experiences from East Africa. And kindly allow me to introduce the panelists. The first member of this panel is Ms. Doreen Kazora, Asimwe SSP. Could you please join us? The next member of this panel is Ms. Florence Kerubo, Deputy Commissioner General, Kenyan Prison Service. Please join us. And the final member of this panel is Hope Bagota, Senior Human Rights Officer at Uganda Human Rights Commission. Thank you, panelists. Ladies and gentlemen, allow me briefly to set the tone of this conversation, and I'll ask the panel one question, to be fair, so we can learn, because this is about sharing experiences and ideas. So in setting the tone of this conversation, I want us to reflect briefly on the conversation of earlier today. The Commissioner General of Prisons has given us statistics on the increasing number, on the composition of women in the prison population. I think another speaker also spoke about the global trends in the similar vein, how many women increasingly are caught up in conflict with the law. To me, as a human rights expert, the trend in international human rights instruments and norms relating to the treatment of women in conflict with the law also reflects that pattern. You know, so we see, I mean, reference has been consistently made to the Bangkok rules. But I think there's another underlying point here. I participated in a study about the role of women in the genocide in Rwanda. And interestingly, you know, the African perception of, putting it mildly, a woman who's subservient, who is not, who is neutral, criminal neutral, is increasingly being undermined. Obviously, there are other influencing factors. And if you look at that study about the role of women in the genocide in Rwanda, you'll find that the level of their complicity or perpetuation in those crimes almost is similar to what men did or carried out in those atrocities. So I think generally we have to think about how a justice system that wasn't designed for women, increasingly is women are occupying a larger population of that. But that aside, I think we need to also consider, you know, and this goes to the panel, so it will lead into my question, that our criminal justice system has got its roots as Africans in our colonial heritage. You know, and I think the point has been made about petty offenses and how those are used to harass women, especially sex workers, you know. I mean, interestingly, and I speak to persons in the actors in the criminal justice system about our laws here in Uganda. Now, for instance, we have a common provision here in Uganda that provides, if you are charged with an offense that is not within the jurisdiction of the magistrate, which is maybe a non-petty offense, a severe offense, you go before a magistrate, and the magistrate will refer you, because they have no competence in that matter, to the High Court that has got competence in that matter. But our law says that you will appear before the High Court at the next available session. But interestingly, if you look at that legislation, that legislation is rooted in our colonial heritage. And this is what happened. Justice in Uganda was originally dispensed by our British judges. So you could never tie down a British judge who had to go back to England for holidays to hearing criminal matters. So the law then provided that you'll be tried whenever a judge is available. Now, 61 years after independence, we are still applying the same legislation. So I think in that conversation, we must be alert, to how we can rid ourselves as African people, as African independent people, of colonial implications in our legal system in relation to women and as a people, broadly. I attempted to look at Uganda's legal system in regards to how it can, how it recognizes the peculiarity of women in the criminal justice system. I looked around the Constitution, the main provisions on discrimination, on affirmative action, and on the rights of women. But when you look down further into the legislative framework, the Magistrates Court Act, the Trial and Indictment Act, you do not see those gender-sensitive constitutional provisions trickle down into the legislative framework. So I do think that there's a conversation to be had in that regard. So finally, in form of my question that goes to the panel, how can we ensure access to justice, and please stop me if I am rushing through this, in a way that recognizes the peculiar nature of women going through the justice system, but that also protects the presumption of innocence. And let me qualify my last sentence briefly. I don't know what happens in other countries, but I can tell you here in Uganda, if I said to Afande here, I'm sure he doesn't mind, if he's got up and I said, Afande, run, and I say, thief, 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 no one in 95% of Ugandans will not ask, what have they done? But what they will do is they grab the nearest offensive weapon and throw it at. So we have a mindset also as a people that thinks once you enter the criminal justice system, you must have done something wrong. So in that context, I don't know if my question was clear. In the context of pretrial detention, I'd like the panel to discuss with us, share experience, or give us guidance, if you may, please, at the 3-4 major stages of pretrial detention, how we can build policies, legislative framework that ensures, that reflects the vulnerable nature of women in the criminal justice system during arrest, perhaps at the initial stages of detention, bond, remand, and bail. Thank you. And the first panelist, please.
Thank you very much, moderator. It is a good feeling to be in this distinguished congregation and place, the Regional Conference on the Rights of Justice Affected Women, and that we are all here because we want to look at unlocking barriers, the rights of women in the criminal justice system. It is wonderful to be here because we are all like-minded, and we are looking at how do we assist women? How do we create a system that is female-friendly, gender-friendly? And I wanted to look at this inside out. Why do we have so many men serving sentences? What is the impact of imprisoning men? I want to look at it this way because we came here to share experiences. And from the Kenyan context, and my friend Julie has brought it out so well, I was looking at a particular context where we have so many men in prison, and like the first lady, the spouse of the deputy president, keeps on saying, they are all there with the seed. What is happening to our girls and women? Then begs the question of who is taking care of the family. And therefore, it is the reversed roles that have brought about the imprisonment of women, the insensitivity, the patriarchal system, whereby you're imprisoning a woman for doing a role which is basically male. And the law does not look at women and men. The law is law for everybody, and it's applied equitably. Greetings from the Kenya Prison Service. Our Commissioner General Brigadier Retired Warioba is following in and wants to hear what recommendations do we come out with at the end of this conference. As of today, we have 62,200 inmates in the penal system in Kenya, and out of these, 3,200 are women. 1,500 are convicted, and the other half is pre-trial detainees. And while the entire population of female detainees in prison is indicative of the fact that 50% are pre-trial and 50% are convicted, you may be asking yourself, this looks like a small number. It is not a small number when they have 300 children also accompanying them in prison who are at their formative years, and I'm assuming that each of these women has 2 children. And some of them, their husbands could also be in prison. So what is the impact of retaining these women? What is the impact of having women serve time in prison without a conviction? And they might finally come out, but imprisonment is imprisonment whether you are convicted or unconvicted, because your family suffers and the damage may not be undone. A moderator was asking, why if you shout thief, does everybody throw a stone? It is because we have not done enough sensitization. We don't think. And that is why I like the keynote address from Madame, because she said we are sensitizing everybody, starting with the magistrates and the community. So when you have 300 women, 3,000 women serving sentences, whether convicted or not, just think in terms of what are we talking about here? Let us start with the men. Let us address the role of men in our society and the abdication of paternal duties, paternal responsibility. And until we do that, we will not get to the core of what has brought us in this conference. This high number of pre-trial detainees is there because many of them cannot afford a fine. I'm going quickly because much of this has already been covered. They cannot afford even bail. And when you put them in even for 500 shillings, in default they serve 1 month, the government spends more than 20,000 shillings taking care of these women. So do we really have to have them in prison? Because they are overstretching government resources. They are there for petty offenses. Are they then getting rehabilitation? No. The time is too short for them to get any rehabilitation. However, in Kenya, when you are not convicted, we do not put you on a rehabilitation program because you are still a suspect. But you are still serving time in prison.
Summarize in the next 2 minutes. Thank you.
Thank you. And then we have, in Kenya, we have accommodation that is separate for both the convicted and the non-convicted. We have provisions for daycare centers for children accompanying their mothers in prison. We provide prenatal and postnatal care. And then we do not allow small children to mix with the other offenders, so their mothers are given mother-child units. We have provision for special needs. That's the aged, the young, the expectant, and persons with the disabilities. We have adequate health care. We have legal aid thanks to our partners who have come in a large way to support legal aid and to also support in some of the facilities that government may not provide. One of the achievements is that we have a policy on child care for children accompanying their incarcerated mothers. And the policy has gone a long way also in addressing the needs of children left home by their parents, whether they are male or female, so that we counter the effect of incarceration on children of incarcerated people because they may end up in prison, like we heard from our sister from Karamoja. She brought it out so clearly. Why are women in prisons? Because of poverty, because of relationships, which are also poverty-related. What are the challenges? Pre-trial detainees experience challenges of isolation from family and friends, low or no legal assistance, financial constraints that lead to shortage of prisoners' uniforms, like I've said, overstretched resources, overstretched accommodation, overstretched everything to the extent that they suffer stress, they suffer depression in the process, and if they are pre-trial, then it means that the problem is multiple. What are the lessons learned? There was a study which was insinuated by the IJM that was carried out in conjunction with the Clean Start, who are also here, rethinking the bars, access and administration of justice for women who commit offenses. That was done in July 2022. The findings indicated that these were low-income, poor women, mainly sole breadwinners because the fathers have decided to abdicate their responsibility, lack of economic access to justice, and the recommendations were that we should try as much as possible to rethink our criminal justice system. We should rethink the laws that we have, such as hawking, that's the laws, the petty offenses. Consideration for decrease in the duration of time spent in pre-trial detention, and I'm happy that we are loaded with officers from the judicial system, and they've been taking notes and listening keenly, and I know that they are going to come up with very good recommendation, and we have people from academia, from the research, and I'm happy that we have everybody in the house. There is a need to advocate for pre-trial detention to be used only in exceptional circumstances in line with the international human rights standards. This has already been mentioned. We need to develop and promote alternatives to detention and incarceration. 3, we need for African countries to promote access to legal aid, especially for the poor women and for all women, because they are mothers. And when you imprison a woman, a young woman, for a long time, you see, then you deny her the opportunity of giving birth. Because we get time bad. The biological clock does not wait for women to serve their sentences and come back home to do that noble duty that's God-given. It is necessary for detention, therefore, to ensure independent monitoring bodies to avoid abuse and the violation of rights of innocence until proven guilty, effectively to monitor process of pretrial detention. And I've also had colleagues in the room who have earlier on presented allude to this. What then would be the way forward? Allow me to say that prison work attains more access when many hands make work lighter. Therefore, we are all here to come up with solutions to amending our laws, to shortening sentences, to being sensitive as people to the rights of our friends, the women, and also to ensure that we come up as partners and collaborators to help in making a difference in the way that we pass our sentences and in the way that we rehabilitate our offenders. But when the offenders come back home, kindly accept them, because they have been given the tools that are going to help them take part in economic development and to also do that women God-given duty of child-bearing and child caring, because we are natural nurturants. Thank you very much.
Deputy Commissioner, thank you very much. To the next panelist, I am happy to ask the question again, if you prefer. Would you like me to do that? Right. So, the topic of discussion is how can we build a criminal justice system that recognizes the peculiar nature of women that are going through that system, but also paying attention to the presumption of innocence. And that's at 3 major stages of the pre-trial detention stage. On arrest, during detention, so you can talk about bond, how we can reflect, have provisions or policies that relates to bond, bail to women. On arrest, how can we treat women during arrest? How can we do that? So that is broadly the question. Thank you.
Thank you, moderator. Well, much as the female population is at 4.7% of the entire male population in this country, and putting into consideration the increasing numbers of the female inmates, as the Commissioner General had earlier said, we are mindful of the unique needs and challenges of women, and more especially the remand prisoners, whom we call the pretrial detainees. And here our role is right from entry into the prison up to the entire period that they spend in custody. On entry, we get into the admission process headed by the admission boards. The admission boards consist of the psychosocial workers, they consist of the medical personnel, the receptionist, under the supervision of the officer in charge to identify who this inmate is, what are the needs, and how we can be of help as they are in custody. These admission boards, they help in connecting to the families through telephone contacts. They help in determining the category of the prisoners so that it can aid us with placement, and also ensuring that there are successful medical checkups on entry. When we go to safety and security of these inmates, the pretrial detainees, like the Commissioner General had said, the female units are totally managed by the female officers, and they are detached from the male sections, both physically and administratively. whether it's at maximum, whether it's at medium, or low security setup. In terms of access to justice, as Uganda Prison Service, we make contacts to the outside world, like I've said, to the families, to the lawyers. Then we also have prison visits by both families and the lawyers. And for the lawyers, it's in seeing and not in hearing during supervision. We have trained paralegal inmates to offer basic legal knowledge to their colleagues, but also to make sure that these inmates, they have basic knowledge on representation in courts of law. We also do timely production of these inmates in courts of law, whether it's physically or virtually. In terms of rehabilitation activities, yes, we have various rehabilitation activities. Majority of them, they are inclined to convicted prisoners, but I'm also happy to note that we have rehabilitation activities for remand prisoners. And these include, we have life skills training that relate to anger management, that relate to forgiveness, so that even when you're innocent, until proven guilty, there's some basic information that you get in custody. We have guidance and counseling. We have recreational sessions, and these include sports and music, dance, and drama. Then we have religious-based activities that are faith-based, where inmates have access quite often to engage in the spiritual rehabilitation. Yeah. Now, in terms of pregnant women, mothers, and children with mothers in custody, here we have separation in terms of accommodation. The mothers sleep alone, and the pregnant sleep alone. Then we also have the on-site child care centers or facilities that we call the daycare centers. Legally, we are mandated to have children who are 18 months in custody, but in circumstances where these children can't have alternatives, then we have the daycare centers that hold the children above 18 months, but interact with the mothers over the weekend and sometimes in the evenings. Yeah. We also have human rights committees for both inmates and staff that have clear reporting procedures to prison headquarters routinely. Yes, we look into the complaint handling and procedures through the officers in charge and their mechanisms and systems where an inmate can easily access help while they are in custody. Yeah, issues to do with hygiene and sanitation, that one, the Commissioner General talked about it, the constant availing of sanitation and hygiene items and facilities. Yeah. To note, there's also the support from the psychosocial worker, the psychiatrist, particularly to attend to mental health. And in terms of this, even cases of mental health are separately accommodated. In terms of nutrition, we have supplementary nutrition for the sick, for the elderly, for the mothers, and the children.
SSP Simwe, kindly allow me to give you another 3 minutes to wind up. Thank you.
Okay. I'm finishing up actually. In terms of challenges, yes, we have challenges. We have overcrowding due to the limited infrastructure and the ever-increasing number of inmates, as you've seen in the morning, according to the statistics. We also have overstay on remand, and this requires a multi-sectoral approach in the entire criminal justice system. As part of the recommendation, we need to look into alternatives to imprisonment so that these women can play their social roles in society and also their economic roles as well. Probably this will also reduce on the congestion in the prison. Thank you.
Thank you very much, SSP Asima. The final panelist. I don't know whether you would like me to. No. Okay, but I think it's significant in the capacity of the institution that you work for, that you represent, that you answer that question in the context of your general sort of constitutional obligation.
Yes.
Thank you.
Thank you so much, moderator. Distinguished ladies and gentlemen, my name is Hope Bagota, and I work with the Uganda Human Rights Commission. To answer your question on how can we ensure access to justice in a way that recognizes the peculiar nature of the needs of the women and also bearing in mind the presumption of innocence. As the Uganda Human Rights Commission, we are the national human rights institution that is mandated to protect and promote human rights. So how have we done this to ensure that there's access to justice for women? The first thing we do is to sensitize, because you cannot give what you do not have, and it has been echoed in this room that it's pertinent that we do sensitize citizens on their rights vis-a-vis their responsibilities. And the Uganda Human Rights Commission is mandated to conduct civic education across the country, which we do in partnerships with different stakeholders, both state and non-stakeholders. You will appreciate that it's a broad mandate, that we will not say we go at it alone. We emphasize partnerships and collaborations. And with emphasis to women, we do what we call focused group meetings, because we know sometimes we might not be able to access these women, and they may not be able to express their issues ably in a large gathering with everybody else. So we target them on their own and see how we can address or prevent crime in the first place. We also go ahead and train security officials on how to use the human rights-based approach while they're conducting their work, on the rights of the people that they're handling, on the different human rights standard to ensure that human rights are respected and protected with regard to suspects, remandees, and people who have been convicted. We also go ahead and monitor places of detention, and we think monitoring will do also help to create access to justice for women. And we do not go at it alone, as I had already alluded to. We work with the district chain-linked committees, because we have 12 regional offices, and these are tailored according to our different dialects. So in those particular regions, those particular offices work with the DCCs to see that we are ensuring access to justice. So on these monitoring visits, issues that have to be addressed immediately are addressed, because we will work together with people from the judiciary, we will work together with the police, and we see that these issues are resolved as fast as they can be resolved. In the previous year alone, that is 2022, we visited over 600 places of detention, and for prisons in particular, we visited 107 prisons across the country, and our findings have been fully reflected from the different conversations that we have been having since morning. Issues of overcrowding, issues of mothers being detained with their children even after they have passed the 18 months because of the different needs or peculiar needs, and they're not able to have these children relocated. And also issues of funding that also create some challenges, or a bigger part of the challenges. We do also review bills before Parliament, and with a view of ensuring that they're human rights compliant. And we do work closely with the Uganda Law Reform and advocate for reform of laws as necessary. As you've heard from the previous speakers, that many of the women that suffer this bulk sometimes are also victims of things like petty offenses, which we've been advocating should be decriminalized. We also go ahead and ensure that all these findings, whatever we find out in the course of implementing our mandate, is represented or presented to Parliament through our annual report. And we've been doing this for the last 25 years. And this report is discussed in Parliament, deliberated on, and the necessary stakeholders are called upon with a view of seeing that human rights are respected and implemented. So to wrap up, to ensure that these women's rights are being respected, to see that there is change, that this comes out, it leaves this room, like we have like previous speakers, and respecting the rights of these women across the chain. When the women are being arrested, how are they arrested? Is it in a humane way or in a degrading way? Are we forgetting that these are the mothers of our country? How do we handle these women during that time? During detention, do they get to be told why they've been arrested, as the law requires? Do they get legal representation? Do they get access to their families? And then even in detention, how are they being treated? Are they treated in a humane manner? If we can start with the prevention element, I believe we can go a long way in seeing that there's change. And also when it comes to issues of representation, we have already spoken about it, that women, a lot of women, or majority of women, do bear the burden of poverty. So if we can all speak from the same hymn book and advocate that there is a legal aid policy in the country, across the country, to be able to help. Yes, we do have legal aid that is being provided, but it is not adequate to serve the entire country adequately. Thank you so much for listening to me.
Thank you. Thank you, panelists. Can I invite you all to join me again in giving them a louder clap of applause? Thank you. I mean, interestingly, let me just share a little experience I had about, many times I have worked with police officers, judicial officers, Afande Kamya, had several conversations about this. I remember one time asking a police officer that, telling a police officer that, you know what, when you arrest a person, you must tell them why you are arresting them. And you know what the police officer said to me? He said, by the time I arrest you, you must know what you have done. Why should I explain it to you? You know? So for me, I think we have major issues in our criminal justice systems, and it starts with a mindset change. Can I then invite members of the audience to either ask questions directly to the panelists or make comments or observations? Thank you. Show of arms, please.
Thank you, panelists. It was very interesting. Just picking up on this last point about mindset, which is something that we at PRI believe is the magic bullet to implementing the Bangkok rules. But when you're talking about pre-trial decisions by judiciary, all of those steps that happen before somebody is detained, and then possibly review of pre-trial detention, what do you think, how do we change the mindsets? What are the barriers to changing that mindset? How can we overcome that perhaps feeling that we need to protect society and just be on the safe side and put somebody in pre-trial detention, for example?
Panelists, you're free to answer that question. Then we'll take another, maybe two more. In any order or form. I'm not particularly fussy about order.
Thank you, moderator. I think how we can change mindset. Rome was not built in a day, and human rights it's work in progress. It has to be continuous, to continuously engage the citizenry, because it is inbuilt human nature to debt collect. For example, why do I say this? So, like, say you did something wrong. You'd say, I owe somebody an apology. Why do you say I owe somebody an apology? It is within you. It's part of your nature. And the other person as well, when somebody has wronged you, you feel they owe you. So that debt collection thing is something that is ingrained in us. How do we change this? Slowly but surely engaging, continuously speaking to these citizens. Continuously, for example, to the Afandes in the room, my apologies for this. For example, if somebody is accused of doing something, why do we parade them before cameras? It's not yet been confirmed, but we are tarnishing somebody's name. The cameras are in their face. We are everywhere. So even ourselves, we are at fault. But how do we do this? If we speak from the same hymn book and continuously engage with this conversation. So imagine if, as a land person or a person that has access to this room, you think that way, then how about the illiterate or somebody at the grassroots or the tail end in the country? So for me, my take would be, let's continue. It should be continuous. It shouldn't be a one-off. It should be collaboratively done and continuously. And with time, we will see these changes through our work and even through the public that we are dealing with. Thank you very much.
Thank you. Can we take another question from the audience?
Thank you so much. The Deputy Commissioner, Madam Kerubo, mentioned something about, trying to uphold the reproductive health opportunities to women who are incarcerated, especially pre-trial. Now, something that has been disturbing my mind, I might be a bit gross. We talk about biological clock ticking. We talk about giving women opportunity to access ability to reproduce. As a prison official, has it ever occurred to us that failing to grant incarcerated women opportunity to enjoy conjugal rights, basically opportunity to have sex, could actually be contributing to more decay in the society? Because I've seen some unofficial figures talking about people learning new habits, like what you termed unnatural sex, people adopting habits they didn't have, turning to homosexuality in a bid to satisfy themselves. Are we able then to think as a liberalized society, possibly creating private rooms where occasionally when the loved one visits the women detainees, they are able to have some private, reasonable private times that ensures then mentally, emotionally, they feel stable even in incarceration? Thank you.
Thank you very much, Amol. I want to speak as a long-serving practitioner in the penal system and as a woman. First of all, thank you very much that you have the same concern as myself, but we look at it from different angles. Now, if you interview women who are serving sentences, they will for sure tell you that conjugal right is not number one on the priority. Children are number one on their priority. You heard my sister, once more I want to refer to her, that beautiful girl, talk about her children. She talked about her sisters. She talked about everything so emotionally. She actually did not say she missed sex. Women think we are wired differently. When we are in a crisis, the last thing you think of is that one. When women are serving sentences, this is the worst crisis that a woman can be in, separation from your family. A woman changes, you can change residence, geographical, whatever, anytime. The name they know me by now is not the name that I was known by many years ago. Why? Because I got a partner. I moved, I changed everything. My primary school colleagues can hardly recognize me from my names. What I'm saying is that in prison, SSP has mentioned that before we admit, we do a medical checkup. There is a board, admission board or reception board. This board looks at, are you married? So I want to ask us a question. How are we going to ensure that this conjugal right is with the partner? How do we get a marriage certificate, for example? How do we ensure that this person does not have HIV and AIDS, for example? You know, we don't engage in what we are calling unnatural activities because of incarceration. Some of it is because of values. Some of this could be happening because we are in, and that is why I was saying we should not let women overly stay for too long while they are waiting the conclusion of their cases. For me, my take would be let them be in prison for as short time as possible. Let them not be in during pre-trial for 2 years. Even a year is too much. 6 months is too much. 6 months should be the maximum. And if you give them 6 months and you conclude their case, then they would not have a reason to be visited by everybody. So my take would be that we will be risking more if we have African prisons, Kenya, where I come from, we are already over-congested. Commissioner General, my mentor, Dr. Biaba Saija, talked about 300% overcrowding. So if we have no space for the normal accommodation, then how can we create room for conjugal rights? If we have no space for the children accompanying their mothers in prison, then how are we going to ensure that we have some space for somebody to come whom we are not sure they are a partner to engage in this? We really are sensitive to this. It's painful that women should spend time until their biological clocks expire, but then we should also really take care of our women so that they don't get infected while in prison. We really should try and limit the time that they are going to spend in prison. For me, that would be my take. A woman is different. Even I'm seated here, I'm not thinking about whether my husband is doing whatever. I'm like, are we getting rights for these women behind bars? Thank you.
Thank you. That will be all in the interest of time. But as a parting shot from me, and I would later ask all of us to thank the panelists and the contributions from the audience. As a parting shot, I'm slightly concerned on an individual basis that the criminal justice system has lagged behind other, for instance, the civil justice system. Increasingly, we're seeing jurisprudence in Uganda and across the world that reflects the contribution of women to many settings. For instance, you know, legal minds in this audience may have heard of the concept of matrimonial contribution. So initially, if this was my spouse, we lived together for 10 years, if I got rid of her or the relationship breaks down and I own the property that we live in, all I would say is, leave. The title is in my name. You have no deed to this property. You have to leave. You know, but, sorry, civil systems are increasingly looking at non-monetary contributions made by women, for instance, in a matrimonial settings, to reflect their contribution when a relationship breaks down, whether the person has been officially married to the person or they've just been cohabiting. And the concern for me is that we have not built gender-sensitive policies when it comes to criminal justice system. Thank you. Ladies and gentlemen, join me kindly to thank our panel of experts for their contribution and insights today. Thank you.
Let us also join hands to thank Dr. Fred Sechindi for taking on this conversation. And it ended up on a very interesting note. Mr. Hannington, you didn't bring up a very new conversation. I think that's a discussion that Uganda has also wanted to start at some point in time. And it always ends up with the person asking, actually, nodding in acceptance like you did when the Deputy Commissioner of Prisons did respond to you. We always end up asking the same. Actually, before she said it, I asked myself, if we do not even have enough space for the prisoners, will we be able to get these, private rooms, in as much as it is a human right? So it is quite controversial to take on some conversations, but it's great to be able to look at them and see what exactly can be able to be done at that point in time. I don't want to take a lot more time because we have just one panel left. But ladies and gentlemen, please feel free, as at any point, much later on we have a cocktail, but feel free to stretch out and pick a cup of coffee, because I know the starch could be working up a little bit. It has already been turned into carbohydrates in your bodies probably. So feel free to pick a cup of coffee or tea as we continue with our last conversation. Then we'll give you a bit of time to go freshen up, and then you will join us for cocktail at exactly 7 p.m. next to the poolside, exactly where we had our lunch. So our very final panel for today will be looking at the progress on gender mainstreaming in the criminal justice system, looking at the lessons of Uganda, Kenya, as well as South Sudan, which is also one of the youngest nations that we still have, and quite unique, issues that have happened in that young nation right there. So without wasting any more time, allow me invite Ms. Martha Nanjobe, a human rights expert, to come and also take on this conversation. But as Martha comes, please, I will request that we stand for just 30 seconds. Yeah. Health is important as much as the criminal justice system is important, So when I ask you to stand, you know what the drill is. We are basically asking ourselves to stretch out. Let's stretch our hands a little bit. Or no, by the way, let's just get some space. Just step out of. You all know your names, right? So I want you to write your English name using your West. So if your name is John, write a J using your name, I mean your West. So let's go. We're going to see who has longer names and who has a shorter name. So there are people who have names like, if they were Chinese, Ma, and you would only write 2 letters, right? So let's start. 1, 2, 3, let's go. Let's write our names. 1, 2, 3, using your West, not your hands, not your head, not. Let's all hold our West. Hands in the West, all of us, hands in the West. So let's start writing. 1, 2, 3, we go. Some people only have 1 letter in their name. They're stuck on writing 1 letter. And it is letter O. I didn't say you. Let's go again. 3, 2, 1, we go. Let's write the first letter. And the second one. And the third. And those who have 4. And those who have 5. And those who have 6. And the 7th. How long are your names? How long are your English names? All right, ladies and gentlemen, let's get seated. But as well as we continue with the next panel, feel free to pick a cup of coffee or tea. This is our very final panel for today. We'll move the other panel that we had to have this evening for tomorrow. So let's welcome Martha to take up this. A round of applause and give her some warmth, please.
Thank you very much, Mildred. Good afternoon, everyone. Good afternoon. So my name is Martha Nanjobe. I'm a human rights expert, and today I'm here to lead a panel which is going to discuss gender mainstreaming in the criminal justice system, lessons from Uganda and Kenya. You've heard many stories today, so please allow me to tell you the last story for that day. It's just my experiences in being more gender sensitive when I'm dealing with people in the criminal justice system. So when I was working with the Legal Aid Project of the Uganda Law Society, we had programs to assist prisoners in need of legal aid. And normally when we are writing donor projects, we promise them so many things. We tell them we are going to help this number of prisoners in this prison. So we normally pick prisons that have high number of prisoners. We looked at Chigo and Luzira prison. So when I went to Chigo, I found Mr. Baine at that time. I think he remembers me. And he took me to the men's section. The next time I went there, he told me, I want you to go and talk to women. So my first question was, how many women are there? Because I'm looking at the numbers, he said, there's a particular lady I want you to talk to. So I asked why. He said this lady came here when she's pregnant, she has a baby, and this environment is not good for the baby, so you need to help her get out. I went to the women's section, I told them what we do, we are lawyers, we provide legal aid, who wants legal aid? And they all kept quiet. Who wants legal aid? They kept quiet. So I asked for the prisoner they told me to talk to. Before I could talk to her, they said, Madam, we've heard everything you've told us, but our problems go beyond your legal aid. We have issues with our kids. We need sanitary towels. We need soap. So if you could help us with that, we've come to terms with the fact that we're in prison, but we need help beyond that. So in the next visit, we were able to secure them soap and sanitary towels. And then later I went to Luzira prison. Again, and I want to thank the prison officials, because most times they know, they are tuned into the needs of the prisoners, so they will tell you the people who need most help. They showed me a lady who had been there for 6 years, she had never gone to court, and I requested to represent her and she refused. She says, I'm happy with where I am, but she had a mental issue because she had lost her daughter while she was in prison, she wasn't able to bury, so she had a lot of mental stress. I said, the best I can do, if you don't want me to represent you, I'll write a letter to the DPP requesting for your case to come to court. Then at least you'll know that you've passed the system. I wrote that letter not expecting anything from the DPP. So on a Friday afternoon, it was evening, I got a call from Luzira, and the lady who had told me not to represent her told them to tell her lawyer to come to court on Monday. There was a high court session. I had never talked to her, I didn't know what her case was about, but I wanted to go and argue on the morality of the issue, because you cannot take somebody to prison for 6 years and not even bother to try them. So when I went to court on Monday, I was ready with my argument, and the DPP withdrew the case. So I was very happy because I got a success story that I can write in my report. But as I was leaving, the prison officials called me, come and talk to your client. I found her outside on the veranda crying. I thought she's crying out of happiness. But I realized she wasn't. I said, Jane, why are you crying? She said, I'm going back to pick my stuff from prison, but I don't know where I'm going. I don't know whether I'm going to find my home. I don't know where my kids are. So it's just me. I had a van from legal aid, so I had transport back to office, but I gave her the money I had. And she went back. And I somehow thought maybe we need to be a bit more conscious about the woman as a whole. That you may provide legal aid, but normally we say legal aid is band aid. There is more to this person. So many times after that, I keep meeting Mr. Baine in conferences like this. Some people say that these conferences achieve nothing. But for the time I've been in legal aid up to now, there are conversations that have started. I'm glad that we're having these conversations about women. Because there was a time, I think I was in a conference, it was stating some, it was a judges conference, and you can tell from the way people talk, but she committed murder. But we need to know the backstory to why she committed murder. So I'm glad we're having these conversations. The last conversation I had with you, Mr. Baine, we were talking about a halfway home for women who leave prison. They need somewhere to stay as they organize themselves. I'm hoping the conversations will continue. But here today, we have 3 panelists to talk to us more about this issue. And we have Mr. Brian Kitui from the National Commission of Human Rights, Kenya. Mr. Brian, please take your seat. Ms. Rachel Odoi from the Justice, Law and Order Sector, Uganda. And Lieutenant Colonel Mali Linda from the National Prison Service of Southern Sudan. You're welcome. Mr. Kito, you can go first, please. You can go first, please.
Thank you very much. Good afternoon. My name is Brian Kitue. I work with the Kenya National Commission on Human Rights. And I've had the advantage of my colleagues from Kenya going before me. We've had the Deputy Commissioner General of Prisons. I also had my colleague from ICJ Kenya, so a lot about the Kenyan context has been explained, so I'll try to be very brief. And maybe just a disclaimer that whatever I present will be looking at the perspective of both women as victims and also women as perpetrators and how they fit into the criminal justice system. So we look at the progress made by Kenya in terms of mainstreaming gender issues within the criminal justice system. And I'll start by policy and legislative gains. And the take-off point will be the Constitution of Kenya, which basically introduces the concept of gender equality and non-discrimination as one of the fundamental principles of our country. And beyond that, we also have the enactment of the establishment of the National Gender and Equality Commission, which is also a byproduct of our constitution, and basically to set up to spearhead the issues of mainstreaming gender within Kenya. And within the criminal justice system, the National Gender and Equality Commission are part of what we call the National Council on Administration of Justice, and also part of the National Committee on Criminal Justice Reforms. And through those two particular outfits, they're able then to mainstream gender issues within the criminal justice system. Another significant development is the enactment of the Sexual Offences Act in Kenya and the subsequent amendments, and specifically with the outlook of gender. We take particular interest on Section 38, which initially, when the Act was established, there was a clause that said any person who wrongfully accuses someone of a sexual offense then is guilty of that particular offense with which they had accused someone else. And this was viewed as negative because then it was hindering victims of gender-based violence from coming forth, and sexual gender-based violence from coming forth and reporting. So that particular section again was amended and that particular clause was removed, so that was a positive step for us. And then we've also had various policies. We have the National Policy on Gender and Development, which basically provides a framework for addressing gender disparity in all sectors, including the criminal justice system. I think my colleagues have also mentioned the formulation of the sentencing policy guidelines, which basically was trying to look at the various disparities that exist within the criminal justice system in terms of sentencing, and also just getting to appreciate some of the gender dynamics that exist before sentencing. And that is closely tied to a presentation that was made in the morning on the gender-sensitive pre-sentencing reports questionnaire, which the probation and aftercare use before they submit their reports to court prior to sentencing. And then, as the Deputy Commissioner General explained, we also have the enactment of the Persons Deprived of Liberty Act. And basically, this was just a domestication of what we refer to as the Mandela Rules. And some of the gender dynamics introduced in that particular piece of legislation were issues around sexual reproductive health for women, as explained, issues around children accompanying their mothers to prisons, separation of women, healthcare, both pre and antenatal care for expectant mothers, rehabilitative programs, very specific rehabilitative programs that target women. And I also hear there's a colleague from an organization called Clean Start Kenya, who have been very fundamental in just coming up with specific rehabilitative programs for women. We have issues around legal aid, and interesting enough, I think Langata Women was one of the first prisons in Kenya to have a fully funded legal program for inmates. So we have law graduates who are inmates, and this has gone a long way in helping the other female inmates in accessing justice. Other legislations in Kenya, of course, that take into account the issues of gender. We have issues around death sentence, where in our law, of course, women are not, pregnant women cannot be sentenced to death. And then in terms of jurisprudence, I think in the morning one of the presenters mentioned the issue of the whole battered woman syndrome, and it's an aspect that also Kenya as a country we are beginning to embrace. Of course, just an example of a case is the case of the state versus Trufena Ndonga, where the court sentenced the woman to 1 day in prison for killing her husband, and gave further direction to the probation and aftercare to provide counseling. And this is a woman who had suffered continuous battering by the husband, and then in the midst of that transaction then proceeded to kill the husband, and the court jailed her for only 1 day.
We're dealing with. What is the real problem? What are the real challenges? And over the course of today, we've had several of them. But in 2016, we undertook a gender analysis and mapping, which was a baseline for us to be able to understand exactly what the problem was within the criminal justice system. And that baseline identified several barriers that were affecting women in particular in the criminal justice system. These include specific barriers to physical access, things like distance and cost of accessing our services. There was a peculiar challenge with sexual and gender-based violence, which was affecting women in many ways. There was an issue of underrepresentation in the work, even in the morning session, that was an issue that many institutions set out to address specifically. And we're glad to see that in the police force, in the prison service, in the judiciary, we've seen significant changes with the recruitment processes, bringing on board several more women. But this was a peculiar problem that we had across the criminal justice chain. So even where we needed specific services of women, or we needed the voice of women in decision-making, the shortage in the workforce was a challenge, and that is something that we continue to address. There were peculiar regional challenges. So we found, for example, that northern Uganda was particularly affected in terms of access to justice by women. And at the time of this survey, we had some of our structures missing. Some of the structures were not fully constituted. For example, the local council courts. And this was particularly important because the local council courts were the most accessible justice agency at the time. They are close to home. They were at the village and parish level because this was LC 1 and 2. They had specific officers responsible for women, and they were there to address issues at the community level. So their absence was a peculiar challenge and a barrier to us being able to fully address the criminal justice chain. In 2022, we followed up that baseline with a specific need of women. What are those the peculiar needs of women as opposed to the needs of the men and needs in other contexts? And of course, there were other issues around budgetary and human resource concerns. So what have we done about it since then? Because it's one thing to do the studies and make the recommendations, but it's important that we translate those into action. We've tried to address them in several categories. We've looked at the institutional reforms, and as I've mentioned, we've had a lot of changes in our human resource. We've had specific targets set in terms of recruitment and promotion of women, so that there are more women at higher levels and more women at the decision-making level. But we've also tried to improve the quality of the services. And in quality, we're looking also at how responsive are we to the needs of our clients generally, but specifically women and girls. So when we've done it through training, and the executive director of the Judicial Training Institute was here, but we've also focal points. Each of our institutions, all 18 of them, have a focal point whose responsibility is to work with us and the institutions to continuously see that these barriers are addressed. There have been legal reforms. There have been legal reforms that have addressed issues of witness protection, which continues to be a big challenge for women, especially women who have been victims of sexual and gender-based violence. We've heard from the statistics that oftentimes these are relatives, these are people from within the family, and if a woman or a girl is expected to testify, she faces insurmountable odds under those circumstances. So it's important that we have issues like witness protection. We've also addressed infrastructure, developing physical facilities for our service delivery to bring them closer to the communities and reduce the walking distance, reduce the amount of time and the cost women take to access these services. Many times we're asked, why do you keep building things? Can't you use this money for something better? But for a woman to access a legal aid service provider, for her to attend court, for her to go to police, it means she has to leave other work behind, she has to leave children behind, she has to use resources that are very limited. If we can make it easier for her then we are making the criminal justice process a lot more accessible. So we focus on bringing the services as close as possible. We are focused at the district level. We are hoping eventually to take this down to the sub-county level. But we've also focused on automation and innovation. So for those who can access those services, we're able to do that. We do recognize that women are not always able to deal with automated services or some of these online provisions, but we know that once we have that available, we free the human resource that we have to be accessible for those who can't use these other services. I want to say something specifically about the special sessions on sexual and gender violence, because if you look at our prison population, a large part of our population are people, both men and particularly the men, facing charges related to sexual and gender-based crime. Now, the victims in many instances, not all, but in many instances, are women and girls. But these cases were taking a very long time. So we took a specific decision to prioritize sexual and gender-based violence, and I want to thank our colleagues from FIDA Uganda who worked with us to develop that. And we have now held special sessions to address sexual and gender-based crime, working with all the institutions across the chain, building their capacities, supporting them with resources to be able to properly deal with these offenses. So right from the probation officers and helping them to provide the social inquiry reports, to the forensics officers and making sure they're able to collect the data, all the way through to the prison service at the judiciary to make sure that these cases are handled quickly. We implemented a first in, first out principle, so the older cases are given priority, but we recognize that with the first in, first out, and I think it was mentioned earlier in the morning, that the women were suffering because they are very few, so there was the likelihood that they were not going to be included in many of the sessions. So we took a deliberate affirmative action decision to say that 25% of the cases in every session should be for women, for children, for the elderly, or people with HIV and AIDS. This was a deliberate effort to make sure that they are not lost in this innovative process. And that has helped us to be able to clear cases out of the system. We're now looking at having a permanent special procedure for gender-based violence that will take forward the lessons we have learned from the special sessions. We've had specific programs for conflict-affected areas. Our transitional justice program has dealt specifically with the issues of women in post-conflict communities, and we're also now working on a similar program for refugees, which provides things like mobile courts and legal aid so that they're able to access these services. And this helps the very vulnerable women, the most vulnerable women, the ones who have been affected by conflict, the ones who are displaced from their homes, to be able to access justice services. And I think finally, the previous moderator talked about how far ahead the civil justice mechanisms are and why we do not then bring that into the criminal justice process. But I wanted to say we have a lot of reforms in the commercial justice area, in the area of doing business, in improving the climate for investment. And it might look like it has no relation to the criminal justice system, but it has a direct correlation. We've said it the whole day. Poverty is an underlying factor in why women end up in the criminal justice system, why they commit crime. Many times it's issues around resources, family resources, it's disputes over land, it's disputes over property that eventually force women to commit crimes. There are some who are just criminals, but the majority, when we look into their cases, they're crimes of opportunity, crimes of circumstances, and many of them are rooted in the aspect of poverty. So when we focus on the commercial justice side of things, when we look at improving the climate for doing business, when we look at creating a mechanism for small enterprises to develop and grow, we are focusing a lot on women. So we've had interventions to make it easier for them to access credit, including the chattels securities, which allows them to pledge chattels or crops as security rather than them having to have real estate. That enables them to access credit to start and run their businesses. We have small claims courts, which allows them to settle their disputes. We have other processes that are helping it to make it easier for them to register their businesses, to get identity documents. This helps them to establish themselves and empower themselves so that they are not driven into actions that will eventually lead them into the criminal justice system. Or even when they do come into contact with the criminal justice system, they have the means and the empowerment to be able to work their way through that process. So we look at the interventions in the commercial justice system as something that also contributes to addressing the challenges of the criminal justice system. And for us, we then look at it as a holistic solution to addressing the barriers and mainstreaming the challenges of women to make it more effective for them to access justice. And we do that with our motto, which is justice for all. And when we say justice for all, we're talking about not leaving anybody behind. We're saying every single person, whatever their context, should be given the necessary tools and the necessary support. So when we look at mainstreaming, the interventions that we have put into place are intended to deal with the holistic issues. As Martha was saying, do we deal with the whole woman? We're not just seeing you through the legal aid and answering your case in court, but then what happens after that? And I want to take this opportunity to specifically appreciate Uganda Prison Service and Penal Reform International for the formal education that has been provided to women in prisons, both in terms of acquiring formal education, but also the business training. I've attended sessions where they have received their certificates and a package. For those who are leaving, it gives them an opportunity to know that when I leave with a new beginning, and I leave with something that can set me off on a new path. And I think that's the most important thing when we're dealing with women in the criminal justice system, as Martha says, to deal with the whole woman. So at the end, you have somebody who can go back out into the world as a productive citizen. And the whole idea behind the justice, the reforms and the justice chain is to improve the lives for all Ugandans, but particularly the most vulnerable in our society. I'll stop there for now. Thank you.
Thank you very much, Rachel. I would like now to move on to our last presenter today, our last panelist, Lieutenant Colonel Mali Linda from the National Prison Service of South Sudan.
Okay. Thank you, my moderator. Good evening for all. South Sudan progress on gender mainstreaming. In South Sudan, we have a National Action Plan, Resolution 1325, on women, peace and security, duration from 2015 up to 2020, to incorporate it into the government work with the aim of reducing the impact of conflicts on women and girls, and increasing women representative and participation in decision making. Number two, we have 35% affirmative action, which is promote women participation. Example, we have first female Minister of Defense and Minister of Interior. We have Speaker of Parliament and Vice President. Number three, we have 3 years strategic plan development. In National Prison Service, security sector, we have incorporated the international instrument for treatment of female offender and juvenile female. Example, like rehabilitation program, protection from GVB, contact with outside community, and their special needs. Number 5, establishment of women security network, security sector network. We conduct several training, TOT training on GVB, and training on gender mainstreaming, and awareness on human rights. And then we have juvenile and GVB court is established. Challenges facing gender mainstreaming in South Sudan. Lack of female officers in leadership rank. From my rank down, we are many, but from colonel up to leadership rank, we are not there. Literacy and English language. I'm the one who facing these challenges. I'm an educated woman, but we are coming from background Arabic from Sudan. We are start education from primary up to university with Arabic. But when we are get the independent, our official language is English. That's why I'm trying every day. One day I will be better than tomorrow. Number 4, lack of female educated personnel. Challenges number 5, traditional customs. Challenges number 6, overcrowding in prisons. Way forward, promotion, assign female officers in leadership rank. Training, advocacy for gender mainstreaming. Number 3, recruiting educated female personnel. Number 5, in action of law that promote gender mainstreaming. Number 5, do away with the traditional custom and any discrimination. Adult education, and then we look for alternative imprisonment that we can reduce our overcrowding in the prison. With these few, I will stop here. Thank you for your attention.
Thank you very much, Lieutenant Colonel Linda Mali. I would like now to invite any questions from the audience for the panelists. You could put your hand up if you have a question or a comment. Musa? It seems there are no, oh sorry, there is a question.
Thank you very much to the panelists. My question is to Ms. Rachel. You talked about your organization working towards making it easier for women to get access to credit. So my question is, does that include women who have been impacted by the criminal justice system, women who have come out of prison and want to establish their businesses or want to get support in businesses that they have already started? Thank you.
The scheme that I referred to is not specific to women in prisons, but it would be accessible to someone who is coming out of prison. We call it the SIMCO, which is, we used to call it the Chattel Security. It's a specific registry with the Uganda Registration Services Bureau, which allows you to register assets that are not necessarily real estate, because previously you'd have to most likely have land. You'd have to have land to pledge credit. But if you have some other assets, including some item of household and a household item or something like that, and you can access credit, then you can then register it. It makes it a little bit easier, because previously people would only give you credit under very stringent terms. But with this one, it makes it more likely that even the formal credit, the formal institutions, microfinance and banks will give credit to somebody who doesn't have that type of an asset. Previously, you would have had to go to some other money lender or something like that. So it's accessible, but it's not specific. But why I specifically mentioned the program that prisons has with Penal Reform International is because that is specific. It's not in every prison, and I'm hoping that it will expand. But it's a skills, it's two things. They first give them the skill, they train them, and then there's something to help you start. And to me, I think that's the scheme, that those are type of schemes that will set them off. But going forward, I think it's important that maybe we start to look at something that's very specific. It's difficult to give a package to women, to say that we're going to give every woman who leaves prison a package, because then we're not being fair to the men. Why do you give the women and not the men? It's not, that may not be something that we can sustain, but we know that once they're in the community and they've started the business, there are mechanisms that can help them to access credit much better. But it was not designed specifically for prisons.
Thank you very much. Yes, sir.
What Rachel forgot to tell you in a gender mainstreaming effort is gender-based budgeting. When all the issues, gender-related issues are identified, then it is a requirement that we have to incorporate them in the budget. And then we have to go through approvals where we have to be marked whether we are gender compliant through a gender compliance certificate. So as a way forward for all countries, if the issues are identified, then we need to have that component where we must test that the issues, gender issues, have been properly captured, and then they have been provided with the budget to enable implementation of this gender, and that will be a way forward in gender mainstreaming.
Thank you. We'll take 2 more questions. Musa and...
Thank you, moderator. You insisted, so I had to cook up some. Gender mainstreaming is a means to an end. By itself, it's not the end. On a very ad hoc scaling, on a scale of 1 to 10, between Kenya, Uganda, South Sudan, where are we on that path to realizing the outcomes or the essence of gender mainstreaming? Number 2, we are sharing experiences at country level. How do we translate this conversation to an East African level? It's apparent that we are at different levels of progression, but in the spirit of the East African bloc, we have a common pursuit. How do we create opportunity for South Sudan to learn from Uganda's experiences and from Kenya to benefit Uganda, and so on and so forth? And I think for me, these will be useful takeaways from the very expert panel. Thank you.
Thank you very much, Musa. Olivia?
Thank you, and thanks for raising the program that we've been implementing for women to lead with a business. I think I just wanted to highlight 2 things with this, is that we came up with that and we've implemented it in other countries as well, including Georgia, for example, because we realized that women, we could train them in all sorts of vocational skills, but they couldn't get jobs because of the stigma. And so then we realized they needed to have their own small little business. And so they needed training on business skills, on computer skills, for example, and then the seed money. And I think that idea can apply to any person who's been in prison, but of course women usually commit a crime because of poverty. And so it was more relevant for women. But increasingly we see a movement to engage businesses, engage business leaders. Richard Branson, like him or hate him, from Virgin, he is a huge advocate for employing people who have been in prison. There's other big, large companies in England that don't make it public, but we know that they employ a lot of people who have criminal records. So I think that's something that could also be thought of moving forward, as engaging some businesses, and whether they start by doing it not publicly, but they move towards that. And Virgin and companies like that even have produced toolboxes and guidance for other companies on how to kind of navigate employing people who have left prison. So there's a lot of ideas to think about to, as you say, get people to leave prison with prospects, with hope, with a toolbox so that they can actually improve their lives by themselves.
Thank you very much. One final comment, question. Who was the mic? There's somebody there.
Thank you, Madam Moderator. My observation is these rights of justice affected women, I don't know how it's going to be easy because I, for one, I have witnessed women, they are victims, as you're saying, for example, someone commits a crime after going through a lot. Poverty, domestic violence. Now, after serving the sentence, my problem, that is where it is. I have witnessed a number of women, especially those ones who were involved in cases of murder after serious domestic issues, after a woman serving a sentence in prison and is supposed to go back home. This is a woman who has a home, talking about those ones who have a home, like she killed the husband. And this person, after going to the village, the relatives of the husband do not allow her. They don't accept her, the community. The civil leaders do not help. The religious leaders cannot help, and you find someone who was a victim in the beginning, even at the end of the system, she's still a victim because they call police, come and rescue this woman who has finished serving sentence and has gone back home but is a problem. Are there any tangible reforms to protect the rights of such women? Because it has happened. Thank you.
Thank you very much. I don't know if there is any of our panelists who can respond to that, but while I was thinking through what I would say when I'm moderating, I thought that a lot of the time we focus so much on the civil and political rights of these women. Your right to get out of prison, your right to a lawyer, but we don't focus on the social and economic rights of these women. Because a woman might be lucky to actually go back to her home. Because after you kill your husband, your kids will go to many places, the home will no longer exist. So it's you. You can't go back to your family because you ashamed them. You can't go back to your husband's family. And I think that's where we had that conversation with Mr. Bain about a halfway home. Let them have somewhere where they can organize themselves. But also the issue of their access and capacity to make money, whether in prison and out of prison. Because when they're in prison, they are concerned for their children. I don't know where my kids are, I can't support them, I can't fend for them. So that's a real concern for them. But even when they come out, how do I survive? So maybe we need to have projects, as I said earlier, that look at the whole circumstance of that person, not just your life in prison, because that will end. And then you have to start another chapter. But I would like to invite our panelists in case they have some more insights on this.
Maybe you've covered a lot of what I would have thought. It's really about the economic empowerment, the halfway house where they have someone to get their, somewhere to get their footing. But I wanted to maybe to draw a little bit on what happens with the child justice system. When a child has been serving time for an offense, before they go back, there's a process of reintegration. And I think it's done. I think prisons does it also for the adult prisoners. But that process of reintegration, I think, is key. It should be in that process, and I think the prison officers will say, there is a process where you prepare even the family to take back this person. And we maybe need to build that particular aspect a bit more. In many times, somebody has been away for 5, 6, 7 years, maybe even 20 years. They've lost touch with the family. The family has moved on, doesn't know you, doesn't have a space for you. And then you come back. And you come back with no job, with no money, and you've come back to be a burden. So the family does need to be prepared to receive you back. So when we're talking about even the civic education and the sensitization, we need to have the general one for communities to understand that the criminal justice system is not a permanent, it's not a permanent punishment. You have a set punishment, you serve your punishment, and you should come back home. And also to help the community understand that people are reformed. People reform and they change. But that requires sensitization, it requires a lot of education, and then it requires that very strong and deliberate reintegration process to prepare the person to go home, but to prepare that home to receive them as well. And I think that's where we should put a bit more focus.
Okay, thank you. Maybe just to add on to that is, I think the process of reintegration has always been looked at as an event. But reintegration starts from the very first day that this person sets foot in prison. Reintegration process begins there, such that then if you treat it as a process, then it becomes easier to reintegrate this person back into society. And also just plugging into one of the suggestions that was given about how does the prisons and probation, how do they work with some of these partners? I think I've seen some of the partners that work in the Kenyan prisons. What they do is they try to sort of reintegrate these people back into society by providing for them an avenue for that continuous just earning a living, such that then you're able to link them up with some of these companies, because like in Kenya, we know Kenya prisons produces people who are best at making furniture and all that. So how do you make use of that particular skill, and how do you fit it into the reintegration process? But there was also a question on where are we in the process. I think it came from the gentleman. Where are we in the process? And for me, in terms of where we are, is I look at it, it has so many facets, but I look at it in two ways. One, where we are in terms of accessing justice for women, and two, where we are in terms of the structures of justice for women. So in terms of accessing justice to women, I think we're still lagging, especially for women within the rural areas who just have this fear in the first place of just coming in contact with the criminal justice system. And I think I was just having a conversation with my colleague about what we refer to as alternative justice systems. And these are systems that were set up to sort of mitigate that gap in terms of accessing justice. But then it begs the question, are they really serving that function, especially for the women? Because if you look at what you call traditional justice systems within a patriarchal society, would they then be able to respond to some of the issues that women have? Look at how cases of defilement, rape, how they have been handled within the traditional justice systems. Then would you therefore say that these systems come into place to bridge that gap of access to justice for women? That question remains. But in terms of structures, I would say we have gone a long way, rather we have come a long way in terms of structures, because like for Kenya, if you look at it from the aspect of the police, within the police we're still lagging. I think they have been very reluctant to take up some of the proposals in terms of gender mainstreaming. We have had the issues around the gender desks which have failed. We're trying to bring them back. Now we have come back with a different outfit, which is multi-agency, and we are hoping it will work, which is what we refer to as the polycare. But if you look at the judiciary, the prison system, the rehabilitative system, then those particular structures have been able to mainstream the aspect of gender, and they are more gender responsive. So in terms of the structures that are in place, I would say that we have come quite a long way. But in terms of access to justice for women, I would say there still remains so much that can be done. Thank you.
Addition to that, to my brother there, I think we can establish the regional network so that we can benefit from it, and we share in experience and challenges, and then we look forward. Thank you.
Thank you very much. I think we've come to the end of the session. I'm going to request that we give a hand clap to our panelists. Thank you very much.
In the same vein, let's give a very loud applause to our moderator, my dear friend. Thank you so much for the evening. Like they say, a problem shared is half solved. I think we are on course. I will have to seek your indulgence that we don't leave this one crowning topic so that tomorrow we start on a very fresh note. But before I invite the final presenter today, I was tickled by the conjugal rights conversation. In most fora, it is always heightened about conjugal rights. But in our Ugandan case, we have a very interesting situation. 80% of the ladies are concubines. Evidence of who qualifies to do it is another thing. Two, at least wherever I have heard and read about conjugal rights, it's at a cost. If we are crying that these ladies don't have money, who will pay? Whether they have the capacity to pay, that's another thing. Three, I think I heard it or I didn't hear well, but unfortunately, out of 10 mothers with their children in the prison, only one father goes to visit the baby. So if the fathers are not able to come and see the baby who are carried from their homes, how easy will it be to own up? These babies, they are not sure they are the only ones who have participated in their production. So it remains a very interesting thing. And more important, I think as we go in, we also need to dwell on the juveniles. How much do they contribute? Mishandling the juvenile justice system, how much has it contributed to the problems in these gender-related issues when these ladies become adults? So our last presenter this evening actually has about 10 minutes, and it's a very, very critical topic: strategies to prevent and address violence against women in detention and after release. And our competent speaker is none other than Dr. Rosalyn Karugonjo Segawa, Chairperson, Leadership Code Tribunal, Uganda, and a member of the board of PRI. You're welcome, Madam.
Thank you very much. I have had the worst session because you've had a long day, and I have the task of trying to get oh, thank God it's moving. So I have the task of keeping you awake, and I'm going to try. But my topic is strategies to prevent and address violence against women in detention and after release. Fortunately for us, as we were going through the presentation, I noted that we were all on the same page. And forgive me, I won't be repeating what others have said. But I want to emphasize that in general, people who are deprived of their liberty are vulnerable, and particularly at risk of human rights violations. Their security and well-being is the responsibility of the detaining authority, which has to guarantee conditions that respect human rights and human dignity. And women deprived of their liberty are among the most vulnerable of those in detention. And of course, they have rights. We have been talking about them. And what I want to emphasize here is that women in detention have the right to be protected from violence. We want to keep them looking the way they are looking in that picture. And a big thank you to UPS for making them look like that, keeping them like that. There are definitions. I'm not going to really go through that because you have been talking about violence and discrimination. The definition of discrimination is coming from CEDAW, and perhaps I'll emphasize the one on gender-based violence, which is discrimination in the form of violence directed against a woman simply because she's a woman, or something that affects women disproportionately. And it includes acts that inflict physical, mental, sexual harm or suffering, threats of such acts, coercion, and other deprivations of liberty. The situation of women, as you've been discussing today, the number of women in detention is increasing. And this has been, as the number of women increase, it exposes them to sexual assault, sexual abuse and harassment, forced and coerced abortion, among many others, which amount to torture or other cruel, inhuman, or degrading treatment. So, since there is an increasing number of women, it is important that for minor non-violent offenses, non-custodial measures are embraced, and I am happy that that was already emphasized. Globally, the number has been increasing, and the prison population for women is increasing. In Uganda, it has also increased, so specific measures have to be taken. I haven't been changing. So, according to penal reform, there are several risk factors. And if we can address the risk factors, then we have the strategies to deal with protecting women from violence, especially those in detention and thereafter. We have to deal with certain contexts which heighten the risk, for example, societal and legislative context. In our case, we have the societal context. As much as we have a relatively progressive legislative framework, the societal is different. So that kind of context heightens the risk. And then it also depends on the timing of where the woman is in the criminal justice system. If they're in police custody or on pretrial detention and transit, the risk is more averse. And there are certain policies and practices, of course, and the inadequate safeguards and assessments on admission, and the nature and scope of medical examinations, and not separating male and female prisoners. Some of you may be wondering, I also used to inspect prisons. I was staff of the Uganda Human Rights Commission for a long time. I worked with the Uganda Human Rights Commission for 12 years. And in some rare incidents, we did find that some female prisoners were not separated from the male. And that was disturbing. But it was a few incidents, but they were there. And the other issues that affect another risk factor is where supervision is by male staff or mixed gender staffing. It's important that in the case of women in detention, the supervision is by female staff. Yes, we know our male colleagues have been oriented and all, but for the sake of the protection of the women, we need to have supervision by male staff. The searching policies and practices, the way the searches are conducted can enhance violence against women, and it is important that the searching policies and practices follow the law. And the use of solitary confinement or disciplinary segregation, though to the best of my knowledge, in Uganda that is a bit of a challenge, partly because we don't have the space even to carry out solitary confinement. Nevertheless, in some jurisdictions, it's a big deal. I'm continuing with the risk factors, and there's also the inappropriate and unjustified use of restraints. Of course, the Bangkok rules talk about there is no need for restraint, especially for a woman who's pregnant, who's already in a vulnerable situation, and then you add on the unjustified use of restraints. Restraints should be used only when it's appropriate and justified in the circumstances. if the lady, if you expect that the woman perhaps will escape or will, yeah. The other risk factor is inadequate provision for gender-specific hygiene, sexual and reproductive health care. And the risk factors continue on, including inadequate provision for family contact. There was a time when prison officials would punish prisoners, not just women. There's a time they would punish them by reducing the family visits. But it's important that there is provision for family contact. When there is provision for family contact, this helps in the reintegration of the person when they get back from prison. But if you limit the family contact, slowly all those connections are blurred, and at the end of the day, the woman will have nowhere to go to. So it is important that as you're thinking about punitive measures, you don't reduce provisions for family contact through the visit. The other is inappropriate decisions to separate dependent children from their mothers in prison. That also increases violence. You can imagine the trauma of a woman who has to be separated from her child because perhaps there are no facilities to cater for both of them. The other is detention for protection. There are times women are detained, allegedly for their protection. When I was inspecting as a director monitoring and inspections at the UHRC, we once found a lady, a woman, actually a young girl, because yes, she was 18, and she had been detained to protect her she was detained. It was actually interesting. The girl had sought to live with a certain man, and the parents of the girl decided to put her in detention to protect her. Now, if you visited our police stations and prisons, especially the police, you would not detain somebody there for their protection because the circumstances are not, given the overcrowding, you won't be protecting them. You will actually be exposing them to other issues. In terms of strategies, I hope that those who are sleeping can now awake. We need to address the risk factors comprehensively. I spent time going through the risk factors because they at the end of the day, if these risk factors are not addressed, then there is no way you can reduce violence against women. All these factors are important that I mentioned earlier. A simple thing, let us implement the law. In Uganda, we always complain about, we are good at complaining about the laws. We need another law. For everything, we keep saying we need another law. Even when we don't need a law, we keep getting another law because we think that the law will help us. But for what we have, whatever law that we have, we need to implement it. If we can implement it, we might find a better solution with what we have. We can implement. As you can see, I was messing around, given the time constraints. I was messing around with this and I've completely shut that off. So I was saying, let's address the risk factors. Let's implement the law, including the international standards on the protection of women's rights. We will need to continuously review and ensure that our laws align with international standards. And I'm very happy that we have the chair of the Uganda Law Reform Commission here, who's a good friend and colleague. And I know that they are always continuously reviewing and ensuring that our laws align. And I was very happy to hear about the law. I haven't yet seen it, but the one that deals with the detention of civil debtors, if that can come through, that would be a major achievement. And I do hope there's also been, that we've also addressed the issue of those people who used to be detained on ministerial orders. I don't know whether those are still there, and what has been there, but we found that many people were detained on such orders and including women, and it was a challenge for them. The other thing that we need to invest in is capacity building and training for all relevant staff working in detention and in the criminal justice system. And that is why I must appreciate the efforts of the justice, law and order sector. You must have seen Madame Rachel Doy. They've done so much when they brought the justice, law and order sector together. Many problems have been resolved, and we need to continue working like that and having capacity building for all those involved in the criminal justice system so that we can make improvements for women. We must encourage non-custodial measures and reduce the number of women in detention. This was already mentioned by the previous speakers, and I can only emphasize it, and it is possible to do. It has already been done. Community service is being done. There must be continuous and consistent independent monitoring of places of detention by the national institution, the Human Rights Commission, and civil society. Then we must also ensure that when a woman in detention, that violence is meted out against her, that there are effective remedies for them, including prosecution of cases of sexual and gender-based violence. Now, ordinarily, when a woman faces violence, even when they're out of prison, it is very difficult to get justice because of the society that we live in, because of the cultural beliefs, because of the patriarchy. So now a woman in detention is even more vulnerable. But if we can make sure that we have effective remedies for them, that would help. And we must establish efficient complaints handling mechanisms. I know that they are there, but their efficiency should be improved such that the victims get justice. And we must ensure women's equitable access to effective legal aid. Martha was sharing about how she used to work for the Law Society and they were providing effective legal aid. And I need to add that, as she was saying, just to affirm what she was saying, that apart from legal aid, we will need to cover the other socio-economic needs of the women. That I have added after listening. But for a start, if we could have effective legal aid, such that even at the point of arrest, if there was legal aid that to the point of arrest, somebody is there to fight for bail for this woman such that she doesn't have to get into pre-trial detention, that would also protect them from that kind of violence. We need to support gender-specific provision of healthcare services to women prisoners. And then we must have special measures in place where the safety and security of women in detention is ensured. For example, this separation from men, it's a simple thing. Even if we are limited by resources, surely we should be able to separate men from women. And even if we are limited by resources, such as should be done by female officers. We have many female officers in the service. And then discipline and punishment and use of instruments of restraint should be in line with the law. We need to provide specific resources. The Commissioner General used to keep complaining that he puts provision for resources such that vulnerable groups of women, such as girls, mothers in detention, including pregnant women and girls, breastfeeding children, and mothers with the children and other vulnerable groups are catered for. But when the budgets are cut, that inevitably comes down to how are they going to provide for the resources. The last I remember is that the daycare was available mainly at Luzira. I'm not sure whether it has gone on for all the other prisons, and Mr. Baine can tell us whether it is now all over. But it is important that we have daycares in all the prisons, and then some special measures to protect the pregnant and mothers of children in prison. I had already emphasized the need for contact with the outside world to ease reintegration. This is important. And then effective rehabilitation. Effective rehabilitation of the person is because we are made of 3 parts: body, mind, and soul. That rehabilitation must cover those areas, and it must also cover the socio-economic aspects as we were talking about. And once you've covered the socio-economic aspects, you've equipped the woman living detention with the skills to be able to cope, then you also need to sensitize the communities, their families, and the public to kind of reduce on the stigma and ease their acceptance into the community. For those who are nodding off, dozing, tired, you'll be happy to know that I'm concluding. I want to conclude by saying that women who have been deprived of their liberty remain vulnerable, and they need to be protected even after their release. And I'm saying that it's important that their rights are promoted and protected, and it is important for us to continually identify and comprehensively address the risk factors, including taking out special measures to enhance protection. I want to thank you so much for listening to me. And in terms of sources, I used PRI materials. Please go to Penal Reform website for further information. Thank you very much for listening to me.
Thank you so much. Let's put a thunderous applause for our presenter. You know, being the last presenter is one of the hardest things to do. But thank you so much for delivering. And all I can say, that when a professional surgeon has done his part, it's no longer necessary for a seer to predict good results. I think we are there where we want to be. I want to congratulate everybody for today, for having persevered. We have not managed time so well, but we promise to do better tomorrow, because tomorrow is strictly business. Like somebody one time commented, culture does not make people, people make culture. I think time has come to make a culture of change where we recognize the vulnerable, especially the women and the children. For this evening, I have one administrative instruction. We are all invited to a cocktail. The venue is Mango Gardens, near where we had lunch actually. It is in that tent. The ushers will be ready. Unless my colleagues from Penal Reform International and the UNODC have anything to say, I think we call it a day. Let's go and brush off what we have packed, and we continue to interact and network so that tomorrow we start on a vibrant note. I want to request that tomorrow we come very early and we respect the timetable, because if we are to catch up and finish what brought us here, we must respect time. Thank you very much. Good evening.